Oh, there it is. Hey, Mark. Mr. Davis. Oh, there. I'm just going to sit it right over here.
But it's going to go. They're all. Well, just stay here. It's going to be fine. Yeah, like early down. Huh? Plus, I don't want to say they're up to 150. Yes, I hope it's
Oh, okay. All right. Great. Good morning. Morning, everyone. Let's go ahead and settle down so we can get started. We've got a long agenda today, and I understand there's a deadline for this room at 4 o'clock, so I'm going to try to keep us going and keep us on target. I'm Judge Suzanne Van Wyck with the Division of Administrative Hearings for this state, and the county has contracted with us to conduct their quasi-judicial hearings on these major development orders. It's my understanding that the first item on the agenda is a request for continuance, actually, MAJ 25-000034 Echelon. Ms. Davis, if you would make your appearance for the record.
Brooke Davis on behalf of Walton County. Your Honor, at this time, we're requesting a continuance on the Echelon project. The one thing I would note is with 1080, SB 1080 coming into play on October 1st, we are cognizant of the 180-day deadline. So opposing counsel and I have discussed extending the 180-day deadline for an additional 60 days to just ensure that backstop is also taken care of. So.
All right.
And we concur with that. We're just putting it on the record so that it's...
Your appearance for the record.
Oh, I'm
sir.
sorry. This is Stephen Tatum on behalf of HNS LLC.
Thank you, Mr. Tatum. All right, so we'll show the first agenda item continued to the October docket then. All right, let's take up the second item on the agenda, Tucker Bayou PUD, number MAJ 25000046. I would start with asking the attorneys or representatives to make their appearances.
Brooke Davis on behalf of the county, Your Honor.
Steve Hall on behalf of the applicant.
All right, thank you and welcome. So the process today, we're going to follow as set out by Ordinance 25-07, Walton County Ordinance, presentation by the applicant and the county. You all can decide amongst yourselves who's going first. I will be taking sworn testimony. It will be subject to cross-examination. Concluding those presentations, we will have the public hearing portion. All right, who's going to go first?
Your Honor, the county will open the proceeding.
Okay.
I'd call Rosanna Edwards.
Good morning.
Morning.
Welcome, Ms. Edwards.
Morning.
You would please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Please state and spell your name for the record.
Rosanna Edwards, Rosanna, Edwards, Edwards.
Ms. Edwards, are you the project manager on this case?
Yes.
Can you take a brief moment and provide the initial introduction to the case?
Sure. This is the Tucker Bayou. It's a conceptual PUD. It's a request to approve by ordinance. It's project number MAJ 25-000046. It has been reviewed by myself. This is a major development application submitted by Interlight Engineering Corporation on behalf of Tucker Bayou Investments LLC. They are requesting a conceptual PUD consisting of 47 single-family lots, recreational and civic uses on 21.33 plus or minus acres. It has a future land use of residential and mixed use and zoning districts of traditional neighborhood development, neighborhood infill, and conservation residential 1 to 2.5. The property is in District 5 and it's located north of Dog Hobble Lane and east of County Highway 395 and adjacent to the Point Washington neighborhood planning area. It is also identified by the parcel numbers outlined in the staff report.
Ms. Edwards, how long have you been employed with the county?
I have been with the county for 9 years.
And what's your role there?
I have been in various roles within that 9 years. I'm currently a senior planner for the last 5 years.
Have you had the opportunity to engage in any education regarding planning?
Yes, I've continued education, currently full-time grad student at the University of Florida with coursework in urban and regional planning and GIS analysis.
In your time with the county as a senior planner, approximately how many projects have you managed?
At a minimum, several hundred, maybe even close to 1,000.
And throughout that process, you work with the LDC and the comp plan on a daily basis?
On a daily basis for the past 9 years.
Your Honor, I've spoken with opposing counsel, and it's my understanding that we're stipulating that Ms. Edwards is an expert in land use planning, as well as in the Walton County LDC and comprehensive plan.
Is that so? Let me hear from the other side. Just
No objection, Your
all right. Thank you. All right. So accepted.
Ms. Edwards, can you explain the process for how this project got to this point in the process?
After the pre-application meeting, the process for a project in traditional neighborhood development for new development requires a PUD process. It did go to TRC, Planning Commission, and now we are here today as a major development because the criteria in T&D requires a PUD overlay ordinance for new projects.
Explain to us exactly what type of PUD this is at this point.
This is a conceptual PUD master plan, which will be followed once it's, or if it's approved, with a technical review for the project.
So what does that PUD, what does that allow to happen for this project?
The PUD, as similar to the criteria in the T&D zoning district, allows for flexibility in design, but T&D also requires a specific mixture of uses. The PUD requirement allows flexibility in the land uses within the boundary as far as density and intensity requirements, allows flexibility in design, and it also allows flexibility in the regulation of the land development code.
Or is that also known as deviations to?
That would be the same as a deviation from the land development code.
So in this PUD, are there specific deviations that are requested by the applicant?
There are a number of deviations the applicant is requesting that are in the land development code. And they have, as part of that, required to have some sort of public benefit.
And you've had an opportunity to review the specifics of this particular plan, is that right?
That is correct.
And are those deviations requested by this particular applicant, are those consistent with the comprehensive plan?
Yes, they are consistent with the comprehensive plan.
And are they allowed to be done by the LDC?
Yes, as long as the deviations are not part of the comprehensive plan, they are allowable deviations to be requested.
Did you have the opportunity to prepare a staff report for this project?
Yes, I did.
And how did you do that staff report? Is that all on your own, or did you work with other people?
I worked with several other individuals within the county, to include surveying, engineering, floodplain management, environmental, and public works right away.
In
As a And more. I would have to look at the staff report for the entire list, but yes, multiple entities.
So within that staff report, did you come to any conclusions as far as whether this project is consistent with the Land Development Code and the Comprehensive Plan?
Yes, conclusion was it was consistent with the Land Development Code and Comprehensive Plan.
Have you prepared a proposed final order for this project?
Yes. that
Did
has
you
been-
include any conditions for approval?
Yes, there are a number of conditions tied to the staff report for approval.
So those conditions were gleaned from your preparation of the staff report and other
Yes.
input?
Yes.
And I don't have anything further at this point.
The applicant have questions for this witness.
Thank you, Your Honor. Good morning.
Good morning.
One question in relation to the recommended order. You discussed both in the staff report and in your testimony, the deviations. I didn't see the deviations listed in the staff report as far as the recommendations of the hearing officer. Should we add those?
We can certainly add those. Those were outlined in the staff report to be attached to the development order, but we can certainly add those as conditions to the development order
And
as a
good. I think-
individual line.
I think that'll be
Item.
helpful. Thank you, that's all.
Okay. So is that something you're just going to amend and submit to me then, and kind of an amended proposed final order?
Yes, Your Honor.
Okay, all right.
Your Honor, I failed to ask to move the staff report into evidence
Okay.
with the inserts.
All right, so is there any objection from the applicant on admitting the staff report as Exhibit 1? Okay. So admitted.
That's all I have.
All right. Does the applicant wish to introduce evidence?
Good morning, Your Honor.
Morning.
Again, Steve Hall representing the applicant. I have, as just a little administrative matter, I have a thin little notebook here of just, I don't intend to submit it as evidence, but I think it's for your reference on a couple of items in our presentation.
All right, if
come-
you would make sure Ms. Davis has seen it, and she haven't had any objection before I look at it.
Your Honor, the staff for the planning department has actually asked if we would just go ahead and submit it into evidence.
All right,
So what I have here for submission as a composite Exhibit 1 would be for judicial notice, the Land Development Code provisions that govern the proceeding,
okay,
the definition out of the Land Development Code 2.02.19 for traditional neighborhood development zoning category. Also, the development standards, which we've drawn from the Point Washington Neighborhood Plan, which we intend to apply voluntarily to our project. And then finally, a copy of the December 19th, 2024 Walton County staff report for the adoption of the Point Washington Neighborhood Plan update, which is also relevant to our proceeding. It's mostly judicial notice stuff, Your Honor.
all right. Thank you. And so, Ms. Davis, will the county make sure that this is scanned and gets into the electronic record for the case?
Yes,
All right, so at this time, I'm admitting applicant's composite Exhibit 1. You may proceed. Okay, I generally, give both parties exhibit either numbers or letters. It's the applicant's Exhibit 1 as opposed to the county's Exhibit 1. Is that okay with you, or you'd rather them be letters?
That's fine.
Okay, all right, thank you.
Ready?
You may proceed.
Thank you, Your Honor. And good morning. I'm here representing the applicant, who I have represented for 25 years in Walton County. It's an honor to be here representing them, somebody that I know and can trust to do what they say they're going to do. We are here in a QJ format as the planning staff represented, and we're here because we're required to present a conceptual PUD plan. Walton County has an interesting PUD ordinance, and I provided you with the copies for your review. And it has the two-stage process. If you recommend approval of the conceptual plan, we will be back before you in a QJ format within a month or so with the detailed plan to implement the concept. Both of them are heard as a quasi-judicial major development. So just a little quirk of the Walton County Land Development Code. So we'll be working out of 2.06.02A, conceptual plan. And we're not here to hear ourselves talk about our great project. We're here to inform you as best we can as the finder of fact. Please feel free with any of our presentations to ask questions as they arrive. We prefer that because then we know we're targeting you with the information that you need. Even though the plan that you will see looks like it's finished, there's still a great deal of detailed engineering and infrastructure work that has to be done. However, what you see here is almost a finished product because of the nature of the property that we're dealing with. It's a very special piece of property, and we had to make sure that what we wanted to do on the piece of property was going to work. And that requires extensive stormwater analysis, geotechnical analysis, the kinds of things that go into to see exactly whether or not the project will actually fit with what we want. What you'll see today is, with David Smith's testimony, is the product of several hard months of design and redesign based on one thing. And we'll speak about trees today, probably more than you want to hear. We'll also speak about the neighborhood plan for Point Washington, because they're both relevant to an issue that the staff brought up from the county, which is public benefit. And, it comes in a lot of forms and fashion. And in this case, what my client has determined to do, we believe, is a significant public benefit of the PUD proposal. So we'll talk about it, even though the Point Washington neighborhood plan does not apply directly any longer to this property. It did. At the time we submitted the application in June, a version of the Point Washington neighborhood plan, and just as a quick background, the Walton County Land Development Code has a vehicle for local neighborhoods to vote themselves additional restrictions that are common and maybe unique to their neighborhood. And where there are a number of neighborhood plans, Point Washington was one of the first neighborhood plans to be adopted in South Walton County. It's basically an overlay district, which imposed a set of restrictions on the area within the boundaries. It's actually brought, staff works with the local citizens, in this case, a committee of local neighbors. And it goes through a process, which is about a 2-year-long process, where that plan is adopted and but it's voted on by the owners within the boundaries of the neighborhood plan. So it's truly a democratic representation of their desire. Here we have, when we submitted, part of the neighborhood plan, and we designed our project and our pro forma based on compliance with those neighborhood plan provisions. The staff report that I've provided you will give you the background of the adoption hearing for that part, those changes to the neighborhood plan. Functionally, and again, this will go back to public benefit, is that this committee of neighbors spent about a year and a half looking at this 22-acre parcel almost exclusively and designing what they wanted to be done here. The most notable element is the tightest tree ordinance this side of Leon County. In fact, we may be the only project that's ever been approved in Walton County subject to a tree ordinance, a tree protection ordinance that is this detailed. Of course, what happened, and you're familiar from the land use world, the legislature implemented Senate Bill 180, which made those changes that were adopted in December void ab initio. So here we are with an application in-house designed to comply with the neighborhood plan. And all of a sudden, we're not subject to the neighborhood plan any longer. So there was a bit of legal wrangling and a little bit of revisiting on what my client would do. And what my client has decided to do, since they liked the dang idea that the neighbors had developed and voted on, that they would stick with it. So we've got a project before you that is the land use category allows up to 30 units per acre in a mixed use development. And what we're presenting today is a 2.2 units per acre single family residential plan. And we are agreeing, and this is the legal point that we'll cover a little more in the detail plan review, but we have agreed to take the standards that I've included in your notebook relating to tree protection, related to nighttime lighting ordinance, relating to the pattern book, the historic pattern book that governs Point Washington, and adopt those into our development order. This PUD process also requires an overlay district ordinance to be adopted, separate and apart from the conceptual and detailed plan, where it incorporates any conditions that are specific to this overlay district, in this case Tucker Bayou, and incorporates them into the land development code specifically. So we're going to take these standards that we've drawn from the neighborhood plan that don't apply to us and agreed to adopt them as a part of that overlay ordinance into the land development code. So the tree, for example, the tree ordinance will govern everything that happens within the boundary of this PUD. Seemed to be the best way to accomplish it. I'd refer you to one exhibit within that the neighborhood plan staff report, which is the last piece of the composite there. Just to give you a visual, and it's on page 13 of 40 of that staff report. It's a map overview, and you can see the green outline is the outline of the existing Point Washington neighborhood plan. The red outline is the outline of the property that was added in December. And if you look at a picture of our site and our PUD boundary, you'll notice that they're about exactly the same. So it just gives you an idea that the relationship between this parcel and the Point Washington neighborhood, and the fact that they were definitely speaking out on how this piece of property should be developed. All right, so today I'm going to provide witnesses on two specific subjects, and then just have a brief statement from the applicant, a corporate representative of the applicant. The first witness that I'm going to bring up is David Smith.
Welcome, Mr. Smith.
Thank you and good morning.
And you're going to see Mr. Smith, I think, at least once more this morning on another item. So maybe some of the expert qualification stuff will save time in a later introduction.
If you would please, Mr. Smith, raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you.
And I know it's probably very easy to spell, but if you would state and spell your name for the record.
David Smith, Smith.
May proceed.
Your Honor, it is our intention to proffer Mr. Smith as an expert in civil engineering, including the application of the Walton County Land Development Comp Plan requirements to specific development projects, also in traffic impact analysis and infrastructure planning and design.
Right, give me that second one again, because that's not
Yeah,
the
the long
typical
one. The application of the Walton County Land Development Code and Comp Plan requirements to specific project applications.
Your Honor, the county is familiar with Mr. Smith and his qualifications, and the county has no objections to
All right, so I think I missed the fourth one. After traffic impact analysis, what's the fourth area?
Infrastructure planning and design.
Yeah. All right, without opposition then, without any objection, sorry. So accepted.
Just for the hearing officer to get to know you just a little bit, David, can you describe your work history in Walton County as a civil engineer?
Yes, I'm a civil engineer with over 28 years of experience. I'm a professional engineer licensed in the state of Florida, also a professional land surveyor licensed in the state of Florida. I worked with Walton County in 2003 and 2004, and one of my responsibilities was to review projects for consistency to the Walton County Land Development Code and Comprehensive Plan. And I have over 23 years of experience in Walton County alone, so I'm very familiar with the Walton County Land Development Code and Comprehensive Plan.
And can you give us a ballpark on how many major development projects you've been taking the lead on?
It's hundreds, maybe 1,000. It's a lot.
Would it be fair to say that on the bulk of those, you've also provided a traffic impact analysis?
Yes, we have. That is a requirement of a development order application.
What has been your role on the project development team so far?
I'm the civil engineer and land planning for consistency to the code and the comprehensive plan. My firm provided a tree survey. As Mr. Hall presented, that tree survey is the basis of this design. So we provided surveying services and civil engineering services and the consistency with the rules and the regulations.
In fact, was that the first assignment that you were given by the applicant here to go do a tree survey?
Yes, it was.
I have just a qualifying question. Were you the lead engineer or the representative of your firm in compiling the application that the county has entered as exhibit, its first exhibit?
Yes, I was.
Were you responsible for reviewing and assuring compliance of the application with the requirements of 2.06.02?
Yes, I was.
How could the hearing officer determine that if she looked at your application? How do you structure that application?
2.06.02A, there's 18 items that are detailed in the Walton County Land Development Code. And the way my firm prepares the application is consistent with those 18 items. So if you look at the first part of our application submittal, you'll see that it's organized based on those 18 items, and it goes in order of the 18 items. We find over the years that that's easy for us to do to stay consistent with the rules and the regulations, but it's also easier for staff to review. So it's in the same order as the Walton County Land Development Code 2.0602A.
And that's helpful for me too. So you described the process of developing the site plan as tree-driven. Madam Hearing Officer, if you could look at page 55 of 224 of the staff report.
Did you say 25?
Yes, no, I'm sorry, 55.
55, thank you.
55 of the staff report. It is the actual tree survey that was submitted as a part of the application.
All right, I'm there.
So I just wanted you to get a glimpse. Now, what trees are represented on that survey?
It's the trees that are in the Point Washington neighborhood plan that are required to be preserved. So we prepared the tree survey in accordance with the Point Washington neighborhood plan.
Okay, thank you. Can we go ahead and move to to the site plan that you developed based on those facts?
Yes. If I may point to my board. this is the plan that we prepared as part of the application that's before you this morning. And this is a total of 47 single-family homes. We have a connection to Dog Hobble, where as you enter the development, we have a loop around roadway with the homes located along either side of that roadway. In the center, we have a stormwater retention facility to meet the rules, local rules and regulations, as well as state rules for stormwater management. In this location, we have a civic park for the residents to congregate in the civic park area. And then up here on the north, we have an access to the Choctachi Bay for the community to have access to the water.
In fact, can you describe the extent of the trail system that runs through the entire development?
Absolutely. We have trails around the stormwater facility throughout the park, as well as we'll have mulch paths along the roadways to provide plenty of pedestrian interconnectivity between the residents, the amenities, the lake area, and as well as the access to the bay.
And you described the green space in the center area as a civic space. Can you, and I believe that the staff report also identifies it as a civic space. And would that satisfy part of the requirement of the T&D
Yes,
land use?
Sorry to interrupt you. I jumped in too soon. Yes, and one of the requirements is there's a mix of uses required in traditional neighborhood in the zoning designation. One of the requirements is a civic space, and the park does fulfill the civic space requirement as part of the traditional neighborhood zoning designation.
And in addition, do we have active residential components as a part of the overall project design?
We have plenty of recreational opportunities with a trail system, the park, and just the area where the residents can walk and be active.
Can you describe the central park theme as far as the stormwater retention area and the developer's plans for an enhanced stormwater management facility?
Yes, the developer's goal was to be as natural as possible, and it's all centered around the trees, which we'll continue, obviously, to talk about. That's the basis of everything. So the stormwater facility does have to be in place to meet local rules and state regulations, and we will have a littoral planting zone. That's natural vegetation around the shoreline, and as it matures, it will be as natural as possible. So the whole goal and theme of this area is to be natural around the trees.
Does that also fit into the infrastructure plans that you have already worked with local utilities to design?
Yes, it does, and we will have utilities within the rights of way to provide to the residents. We'll have water, sewer, there'll be gas, media, and we will be going around the trees. So it's not just a straight shot along a new roadway. We'll be meandering around those trees to preserve the integrity of the root system so that the trees obviously live, and that's the entire goal.
And that's part of what's allowed under the PUD ordinance, isn't that correct?
Yes, it is.
How about the one of the modifications or variances that we've asked for, which is the use of pervious sidewalk or trail systems instead of the required sidewalks?
The Walton County Land Development Code requires 2 5-foot concrete sidewalks along either side of the roadway. One of our deviations is to request a variance from that to be lesser in width, as well as to have a different paving material type, so we can have either a gravel or a mulch just for the character of the development to fit that natural theme. We'll still have the walkways. It'll just be a different material, maybe lesser in width, to interact with our pedestrian trails in the center as well.
And again, also to allow for variability to deal with tree canopies?
That is correct, yes.
A little easier than moving a sidewalk around.
Yes.
Is the idea to provide a pervious surface then?
Yes, ma'am.
Okay.
Which will obviously help with our stormwater treatment requirements as well.
All right, David, the next thing would be the modifications or variances that we're requesting, just to be able to point them out for the hearing officer and explain why we've gotten after them.
There's 4 deviations that are a part of the application before you, consistent with item number 8 in Land Development Code 2.06.02a. And the first one is we're requesting a setback variance. And currently the code requires a 20-foot front setback, 15 feet in the rear, and 7.5 on the side. We're requesting to go down to 10 feet in the front. And the reason for that is we want the front porches to extend in the setback, not the garages, but the front porches, just to have that flexibility. And that's also consistent with the Point Washington neighborhood plan. We're also requesting deviations for rear setbacks to 10 feet and side setbacks to 5 feet And in areas where the lots abut landscape buffers, we are requesting for those deviations to go to 5 feet because you'll have a landscape buffer and then a reduced side setback. So you don't have the full setback from the landscape buffer. That's why we're asking for those reductions there.
David, could you hold up,
Absolutely.
just while it's fresh, if you could hold up the plan and indicate where those buffers are located and where you're looking for the variances?
There's along primarily the western boundary of the property. So it would be deviations from the rear and the sides and the rear.
Now, is that because the county requires those buffers be in common area and not as a part of the individual platted lots?
Correct. The landscape buffer cannot be located on the lot. It has to be placed in common area. And therefore, if you have a traditional setback, the setback is from the common area. So we're requesting for the deviation to have a lesser setback adjacent to those buffers within the common areas.
So in essence, you've got part of the buffer on common area adjacent to those lots.
That is correct.
All right, I interrupted you in the middle of your work.
The second and third deviation pertain to one another, and those are the requirements within T&D for workplace and artisanal uses, as well as commercial development. And we're just requesting a deviation to not have those requirements that are currently required in the Walton County Land Development Code. The reason for that is because this project is back in the Point Washington area. We don't feel that commercial is appropriate, nor will it succeed back in that area. As well as in our community meeting, the residents expressed a desire not to have commercial in that location as well. So we obviously all agree, community and us, that commercial is not appropriate. And that's the reason for deviations number 2 and number 3. The fourth deviation I touched on earlier was the sidewalk material and width deviation per the Walton County Land Development Code. And that's just to have lesser trails, pervious paving systems with mulch and or gravel to have that flexibility to maneuver around the trees.
Thank you. And just a summary then, so we can get done quick.
Absolutely. This
Well,
development.
let me ask my questions first.
Sure, go for it.
You said earlier that you were supervisor on the submission of the application and that you're familiar with all of the expert reports that are provided, like the Red Oak Consulting report on the environmental item. Are you able to represent to the hearing officer that based on your knowledge of the application, that it was submitted and still does meet the requirements of Section 2.06.02 of the Land Development Code and other general applications of the Land Development Code?
Yes, I can. It does meet the requirements of 2.06.02 and then all the other regulatory requirements of the Walton County Land Development Code and Comprehensive Plan.
You've had an opportunity to review the recommended order that was included as an attachment to the staff report. And are you familiar with the conditions of development that are included within that draft order?
I am, and those are general conditions that are placed on a development order.
And to your knowledge, do those reflect the discussions that you've had with staff on the recommendations, the conditions that will be included as a part of the conceptual plan final DO?
They do.
And I think that's going to be it for you.
Thank you, and thank you, ma'am.
Thank you. Okay, thank you.
And now, Your Honor, for a brief and beautiful presentation by our architect.
All right.
And his name is Trey Carter.
Welcome, Mr. Carter. Please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, and please state and spell your name for the record.
My name is Trey Carter, Trescarter.
Thank you. You may proceed, Mr. Hall.
Your Honor, we don't intend to proffer Trey as an expert witness.
Okay.
Trey, what's your connection and what's your role in the project development so far?
So I graduated from Auburn University in 2023.
War Eagle. Sorry.
War Eagle.
David graduated from Auburn too, so.
I've been working with Walt Chansey since my graduation, and I have been involved.
Who is Walt Chansey?
Walt Chansey is the owner of the firm that is doing the architectural guidelines for this project.
And what's the name of that firm?
Chansey Architecture and Interior Design.
Thank you.
I have been involved on many projects in the South Walden area, including Alice, Graydon Beach, Seaside, a few of which I was leading and a few of which I am still leading as project manager. I have a solid understanding of design code and pattern language since my graduation.
And your particular role in relation to this application?
My specific role was working with Walt Chansey on laying out the lot lines and the original concept of the project from the beginning, working with him and David with the tree surveys to avoid every tree possible.
So you've had hands-on on the design, and I'd like to say that you've added the beauty to David's mechanics.
Yes, yeah.
Do you have some drawings here that you can share with the hearing officer? Now, we're both aware that the TND zoning requirement includes a component that new development shall be conducted utilizing a pattern-based or other performance-based design code.
Yes, and some of the design features of Tucker Bayou are drawn from my experience living in South Walden over the past few years.
Okay, are you familiar with the historic Point Washington pattern book?
Yes, yes.
Could you describe that for the hearing officer, what that particular pattern book is?
So the Point Washington pattern book lays out, it's written by the class of 2014 from Notre Dame, and they laid out a set of restrictions and guidelines for the community to match a old Florida vernacular style approach that fits the characteristics of Point Washington and its historical background.
Would the illustrations that you're holding up for the hearing officer reflect the kind of design elements that are included in the pattern book?
Yes. Oh. These houses that I'm showing on this board are taken from local communities around South Walden, such as Watercolor and Graydon Beach, that do preserve that old Florida vernacular style approach that would be characteristic of Point Washington.
So your design work so far, could you say that it is subject to and informed by the pattern book?
Very much so, yes.
And going forward, will your firm have a role in the development of architectural guidelines and restrictive covenants to implement the design requirements of the pattern book?
Yes, we are in the process of working and writing up a pattern language and design code that would match closely with the Point Washington pattern book.
Okay, this will be, I'm throwing you a curve. Have you discussed the process for approval of individual site plans for platted lots once they are sold and being prepared for development?
Yes, we have talked about it briefly. So for the approval of a site plan to be would be a requirement of the neighborhood in order to begin construction or permitting processes for your house. Some of those restrictions include approvals on the tree locations and the plot of your footprint of your house to be located in a way that avoids as many trees as possible.
We've talked about a variance for both the sidewalk requirement and the front porch requirement. In this vernacular, can you discuss the importance of the front porch and the trails?
Yes.
And then, excuse me a second, Mr. Hall, are these blow-ups of items that are already in the county's Exhibit 1 or in your exhibit?
You know, Your Honor, they're not.
They're not, okay, so these are demonstratives.
That's correct.
Okay, thank you.
So for the question about the porches, in Point Washington, it is very characteristic to have your, and in many of the communities in South Walton, to have a connection to the street, which encourages a greater sense of community. So we want to bring that to this neighborhood to align better with the Point Washington characteristics. And similarly, the paths as well create a low-impact solution that is still walkable. It's still very easy to use, but it kind of preserves that naturalistic landscape that we are trying to preserve.
And I forgot, you actually have an example of the kind of littoral planting that we're currently working on for the stormwater management system on the left-hand side.
Yes.
And I believe that's all. Thank you very much. Any questions?
Thank you. Ms. Davis, any questions? All right, thank you.
Thank you.
And Your Honor, final witness will be Ricky Ruckus, representative of the developer.
Welcome, Mr. Ruckus.
Thank
How are
you.
you?
Fine, thank you. How are you?
Good. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Ruckus, are you here today as the corporate representative for the applicant?
I am.
And have you been authorized by any other partners that you have in that company to be here today?
I have.
Are you familiar? I know you've been living with this dang application for about 9 months, so I assume that you're familiar. But the particular question I have for you is, have you had an opportunity to review the staff report as presented by county staff for this hearing?
I have.
Have you had an opportunity to review the proposed recommended order that's attached at the very end of it?
I have.
Are you willing to commit to the hearing officer under oath that those are conditions that are acceptable to the applicant as a company, and that you will implement those to the greatest extent possible as you prepare the detailed conceptual plan?
We will.
Thank you.
Thank you. Ms. Davis, any questions? All right.
That'll end the presentation, Your Honor.
All right. Thank you. All right. Are there members of the public here to speak on this particular application? All right. We have at least one. All right. So I'm going to open the public hearing process. I'll ask you to come forward, state and spell your name for the record. Members of the public are limited to 3 minutes each. And I think the clerk's office, actually, I don't see the light system up here. Okay.
Oh, I'm sorry. Didn't mean to blow up.
Not your fault. Don't worry about it.
Technology, here we go. I go ahead.
Let's give them just a second to get
Okay.
this set up. I
Sure.
apologize for the delay.
No problem.
All right, you may proceed. Please state your name for the record.
Nancy Gross,
And how do you spell your name, Nancy?
Nancy Gross.
Thank you.
And this is my husband.
I'm the husband,
And husband, what is your name?
Bob Gross.
All right, Bob, thank you. Welcome. You may proceed.
So we have, I appreciate being able to come up and voice some concerns. We bought our property over 25 years ago and have retired here. And so we are directly across from, pretty close to where the dock is, the proposed dock is going to be located. So our view off our back porch, is incredible trees. So we have wildlife that come in, the dolphins, deer. In the last snowstorm that we had deer come up in a family of deer. So that is a natural habitat for a lot of wildlife. I don't know what's going to happen. We're invading their habitats. I'm concerned, and I know that they've done some environmental studies, but Tucker Bayou is a refuge for dolphins, cormorants, pelicans. They come and perch, especially in the wintertime. So I want to just express the care, and I know that I've been promised that they're going to take care of the trees. Our lot has 19 live oaks in the front yard. And so, and we have preserved those for the beauty of the neighborhood. The other concern as far as environmental is the traffic. When we turn 395 onto Eden Drive and then left onto Tucker Bayou, which right now I know that they're going to have to build a road because it's a dirt road right now. And I know that the neighbors are looking forward to some infrastructure in that side because there's some huge homes that have been built. So I do believe, and we had a meeting where we discussed this concern because the county has not, it was supposed to in 2020 resurface 395 north with a bike trail, and it has not happened. So the money's been spent on other things, and so we're constantly in Point Washington Historic Association, which I'm a member of, have been trying to increase the dialogue, how necessary it is. We have 2 churches, a preschool, a Montessori school, a boat ramp. Oh, I'm up. That's it.
The 3 minutes are up. If you'll just wrap it up very
Okay.
briefly for me.
Anyway, it's a very busy road. We have a Bay Elementary. So I'm just concerned about the traffic and especially the condition of the road itself and safety. So I'm glad I had the opportunity today, and I appreciate the opportunity to express concern. And I really, I pray that they will be honorable to the beauty of the nature and the environment. Thank you.
Thank you. Anyone else that wished to speak on the Tucker Bayou project? All right, does either party want to offer any rebuttal testimony? No. Okay. Mr. Hall, did you want to offer something?
David will have just a couple of points
Okay.
on the concerns.
Thank you. Welcome back, Mr. Davis. I'll just remind you that you remain under oath.
Yes, ma'am. Thank you.
I'm sorry, Mr. Smith. I said Davis. I'm sorry. Go ahead.
Sorry, I thought you were calling me by my first name. Thank you. The trees, I know Ms. Gross, her concern regarding the trees, as we presented, we fully intend to keep, to the greatest extent possible, the trees. And the shoreline protection, there's along the Choctawhatchee Bay, which is across from Mr. and Ms. Gross's property. There's a limois zone, which is a FEMA-regulated line. There's also an environmentally sensitive wetland area. So all of those areas will remain natural, which should continue to provide that look and that buffer that she spoke about earlier. I spoke to Ms. Gross personally. We had a great conversation, and I did want to reassure her and her husband that we do fully intend to keep the trees. Now, we did coordinate with the Walton County Public Works Department regarding the improvements to County Road 395. Chance Powell, the county engineer, assured us that the county is moving forward with those improvements at the end of this year, and that's repaving 395 as well as putting a stop sign there at Eden's Drive. So I did want to just provide the facts that the county will be moving forward with those improvements here at the end of the year.
All right.
Thank you very much.
Thank you, Mr. Smith. All right. Does that conclude the presentation?
That concludes our presentation, Your Honor. We would ask that you provide a recommended order in support of the issuance of the conceptual PUD. Thank you.
Thank you. All right, let's take 5 minutes before we take up the next agenda item. Thank you.
Thanks, man. I'll be back Monday.
Next time I'm gonna bring you an Easter basket. The same place. I have a gray suit. And from there, it's too cold to wear dresses here. So I can't pull that off. I know that's your rules too. But yeah, I know, especially in the summertime. Here definitely it's too cold. It's way too cold.
All right, let's get ready to take the second item, I guess really the third item on the agenda, or take up the next project. Application is Sunliner Diner, MAJ 25-000044. First thing I'll do is ask for the attorneys to make their appearances for the record.
Brooke Davis on behalf of the county, Your Honor.
Thank you.
Stephen Tatum on behalf of the applicant.
Good morning,
right.
Your Honor. Mark Davis on behalf of Blue Water Landing Homeowners Association.
All right. I announced before that we're going to follow the same process. It is laid out by Walton County Ordinance 25-07. I'm going to have a presentation by the applicant, well, by the county first, then the applicant. I will be taking sworn testimony. Each person who's going to provide testimony will be sworn in and will be subject to cross-examination. After the presentation, I will be opening the public hearing portion. Speakers are limited to 3 minutes each. However, the county did change a memorandum of understanding with my office and have incorporated a procedure that's already in their public hearing procedures. When an item for consideration, if there's a representative of a group that's going to speak, they will be allowed to speak longer than the 3 minutes, and we'll get more to that when we take up the public hearing portion. All right, Ms. Davis, you may proceed.
Your Honor, I would call Mr. Bob Baranti.
Okay.
Your Honor, if he can be sworn.
Absolutely. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do, ma'am.
Thank you. And if you would state and spell your name for the record.
Robert, Robert, Baronti, Baron as in Nancy, Ti.
Thank you, Mr. Baronti.
Mr. Barani, can you explain where you work?
I work currently for the Walton County Planning and Development Service Division. I'm a senior planner. I've been employed a little bit over 9 years here. I have 32 years of planning experience. I have worked at every level from federal all the way down to the local level. In 1999, I received my American Institute of Certified Planner certificate, and in 2015, I received my Certified Public Manager certificate. I have a master's in planning and master's in geography and geology from California University of Pennsylvania.
Mr. Barani, do you work with the Walton County Comprehensive Plan and Land Development Code daily?
Yes, ma'am, daily.
And your current role on this is project manager for Sunliner Diner, is that correct?
That's correct.
Your Honor, it's my understanding that opposing counsel, Mr. Tatum, is going to stipulate that Mr. Barani is an expert in planning as well as the Walton County Land Development Code and Comprehensive Plan. I'm not sure, Mr. Davis, if he had any objections.
All right, in planning and the LDC and comprehensive plan?
That's correct, Your Honor.
All right, so accepted.
Barani, can you introduce the project for us?
Yes, ma'am. The project is Sunliner Diner, a request approved by final order, project number MAJ-000044, formerly known as MIN 25-000094. It was reviewed by myself. This is a major development order application submitted by Interlight Engineering Corporation on behalf of Blue Water Landing 38 LLC, requesting to develop a 10,086 square foot restaurant on 1.77 plus or minus acres with a future land use of mixed use and a zoning district of small neighborhood. The property is located in District 5 and is located on the west side of County Highway 30A West, north of Jetty Road, and is identified by the staff parcel number in your staff report.
Mr. Barani, was there any development order process that preceded this development order application?
Yes, ma'am. This project originated as project MAJ 21-000006, Blue Water Landing Development Order, which was approved by the Board of County Commissioner on 7/5/2021, and the current interim director was the project manager.
What, as far as this parcel within that development order, what kind of entitlements were created at that time?
So the main part of that project at that point was the single family subdivision, but it also granted a 20,000 square foot commercial footprint, which they've come back since and started the development order process for that commercial.
That's what this is?
That's correct, ma'am.
Were there any restrictions to the type of commercial development within that prior development order in 2021?
No, ma'am.
Can you explain the process for how this development order application came to be at this point in the process?
Yes, ma'am. So the applicant met with me during a pre-application meeting. We went over the process with the applicant. The applicant was given an application. The applicant then submitted his project. It was deemed complete. It was assigned to me as the project manager. It started as a minor project, as I read in the blurb, So it moved to the Technical Review Committee, and then Acting Director, Mr. Schoen, because of concern and public comment letters, deemed that he would designate this as a major project to go through the whole review process and public hearing process. It was moved out of the Technical Review Committee on 5/7/25. It then went to the Planning Commission on 7/10/25. And here today, it's in front of the administrative law judge, and pending the outcome of this meeting will be scheduled for a future Board of County Commissioners meeting for final consideration.
I want to back up for a second. You said that it went through technical review committee. Is that correct?
That's correct.
Were there technical comments on this project?
Yes, there were technical comments. The applicant was given those comments in the official staff report. The applicant addressed those comments, resubmitted. It was sent out to our review partners, the subject matter experts like Public Works, right-of-way, engineering, environmental, stormwater. Come back, all comments were addressed. Some agencies gave conditions of approval to move the project forward. The project, once all comments were addressed, like I said, was moved to the Planning Commission, and then here today at the Administrative Law Judge.
You mentioned Public Works was included in the evaluation for this project. Is that correct?
That's correct. Public Works, engineering, and right-of-way.
In Public Works' evaluation, were there any additional measures that they identified to address safety?
They have their standard requirements about prior disturbance of public way or damage to county maintained roads and public, but all safety matters per the comp plan and the LDC were met at that time to the certified engineers.
I do want to make clear, the Planning Commission, what was their recommendation?
Yes, ma'am. On 7/10/2025, the Planning Commission recommended denial because of safety, non-compatibility in the zoning district, and just non-compatibility of the project itself.
Mr. Barani, have you had the opportunity to examine this project for compatibility?
Yes, ma'am. Throughout the whole process, I have reviewed and re-reviewed the project.
Can you explain the standard for planning for compatibility for this?
So the standard of compatibility is obviously the project has to meet the comprehensive plan and the land development code, plus just general planning, theories that go to meet this project. And through our reviews and my sister review agencies, we have deemed that this project meets compatibility for the land use plan and the comprehensive plan.
Is that based on your training experience and professional knowledge?
Yes, ma'am, and also the same thing for my review agencies.
I know there on the site plan that's been submitted through your staff report, are there signs reflected in that site plan?
Yes, there are, and the applicant was made aware during the review process that they would not be approved by the development order if it was approved. The applicant was asked to remove them, and they chose to leave them in, but the signs would have to be approved administratively and meet the land development code. But that review was not done, nor was it referred as approved for the signs.
So this development order would not be an approval of those signs, is that correct?
Correct. It will be a separate administrative approval.
In your professional opinion, do you have any concerns with this project in terms of the comprehensive plan or the land development code?
No, I don't, ma'am. the concerns were addressed in the comments, and the resubmittal addressed all those, and it's my professional opinion that this project meets both documents.
You had the opportunity to reevaluate the project even after Planning Commission's deliberation,
Yes, ma'am.
and you were present for those deliberations?
Yes, ma'am.
And again, in your professional opinion, do you still believe this project meets the comprehensive plan and the land development code?
Yes, ma'am.
Did you prepare a staff report for this project?
Yes, ma'am, at all different levels.
Gunnar, I'd ask to move the staff report into evidence with the inserts and the public comments.
Right, is there any objection, Mr. Tatum? Any objection, Mr. Davis? All right, so accepted. Did you say Exhibit 1? You want to go with 1 or
Yes.
A? Okay.
One, Your Honor.
Okay, County Exhibit 1 is accepted.
Have you prepared a proposed final order for this project?
I have, ma'am.
Did you include any conditions for approval on the project?
I have, ma'am.
Are those conditions that you gleaned from compiling your staff report?
Yes, ma'am.
I don't have any other questions at this time, Your Honor.
All right, Mr. Tatum, questions for this witness? All right, Mr. Davis, questions for this witness?
Mr. Bronte, has there been any changes to the application or the plan as it relates to the size and scale of the restaurant since June 10 of 2025?
I don't, I mean, the resubmittal made some changes because they had to address comments, but after it made compliance, no.
So not to the size and scale of the actual building?
No, sir.
Okay. Is it your opinion that the small neighborhood zoning district is designed to provide mixed and commercial uses for the property that is actually located within the zoned district? In other words, within the parcel zoned that way?
Yes.
So the compatibility analysis should be within the zone, not within the neighborhood, such as a greater neighborhood of Blue Mountain Beach.
Correct. It meets, the restaurant meets the small neighborhood zoning district.
But as for compatibility, the compatibility is within the actual zone itself, not within the greater neighborhood outside the zone.
Well,
Outside the zone.
part of the typical planning process is to look at the surrounding and make sure it's compatible.
But as written, section 2.02.18 of the Land Development Code contemplates compatibility within the neighborhood itself that is zoned a small neighborhood, correct?
Correct.
Thank you. That's all I have, Judge.
Thank you. Ms. Davis, any a redirect? No, Your Honor. Okay. Thank you. And that concludes the county's presentation?
That's correct.
All right, thank you. All right, Mr. Tatum.
Good morning, Stephen Tatum again for the applicant. A couple of housekeeping things I wanted to take care of first. The staff report was moved in and it contained several of our exhibits. I just want on the record that in the staff report under QJ Inserts 3, there is from pages 237 to 253, our civil plans done by Interlight Engineering. Pages 254 through 269, prepared by DAG Architects, includes architectural, landscaping, and lighting plans. On top of that, I do have at least one more item I want to move into the record. It is in the portal and uploaded to EALJ. However, that was done yesterday. So I am going to enter in, unless there's an objection, the land use analysis provided by Sage Entitlements. And she is, Tina Ekblad, who prepared it. She's here today to testify regarding it.
Okay, is there an objection to, I'm going to call this applicants. Do you want to give them letters or numbers?
Exhibit 1.
Okay, applicants Exhibit 1. And it is Ms. Ekblad's
That's correct.
analysis.
Land use analysis, yes, ma'am.
All right, is there an objection?
Not from the county, Your Honor.
Okay,
Not from the objector.
okay. All right, so accepted. So that one is admitted. Go ahead.
Would you like a copy of it, Your Honor? Now, or will you look at it? later on. It's
If you want to
88
go,
pages. It's a
if
lot
you
to
want to
walk
go
through.
ahead and give it to me now, that's fine.
I will give you one.
Thank you.
All right, with that out of the way, I'm going to make an opening that's going to be relatively brief. Again, my name is Stephen Tatum. I'm here on behalf of Blue Water Landing 30A LLC. This application represents the completion of a previously approved mixed-use community vision, we'll call it. It provides needed commercial services within the area. It actually significantly lowers traffic impacts below what was originally anticipated by the original approvals for the Blue Water Landing project. It incorporates thoughtful design that preserves the environmental resources, and it also provides pedestrian-friendly features that enhance the Blue Mountain Beach community character. Just general overview. I won't go into a lot of the history that's already been touched on, but this is a previously approved master plan that it included a commercial lot that's 1.77 acres in size, called the Blue Water Landing subdivision. Let me skip to that. This slide is actually a general overview of the area. I think it kind of is redundant based on what the county had as well in their staff report. That is the entire property area for Blue Water Landing, the entire development. Our particular project located in this drawing, the top right corner in that area. Originally approved for 2,000 square feet of commercial use on the commercial lot. The traffic at that time was calculated based on shopping center ITE codes, because no one knew what was going to go on that parcel. The shopping center came the closest to providing the mix of potential uses.
And that's at the 20,000 square foot?
And that was at the
size.
20,000 square foot size, yes, ma'am. Since then, the property is sold to my client, and they would wish to develop the Sunliner Diner on it and the related infrastructure. Mr. Smith will go over some of the other background behind the project and the particulars of it, so I won't bore you with that myself. We are zoned small neighborhood, and neighborhood commercial is an allowed use within small neighborhood, and restaurants are a neighborhood commercial use per 2.03.00 of the Land Development Code. Moved those into evidence. The project itself is both pedestrian and bicycle friendly, as is most of 30A. We meet the requirements of the Land Development Code and Comprehensive Plan per staff and per our own consultants. Keep in mind there are no architectural design standards in the 30A Scenic Corridor, so this project's located in an overlay, we'll call it, that's called the 30A Scenic Corridor. It provides certain design standards for site layout, landscaping, buffering, preservation, that sort of thing, and for sign requirements, but not for aesthetic design of buildings. We do have another overlay district called the 33198 Scenic Corridor, which you'll hear about at some point in your tenure here. And that one does have architectural design standards, but the county chose, for whatever reason, to not include that on the 30A. I do want to touch on the discussion about the signs. We completely agree with county staff that these signs, although shown on the plans, were included on the plans and to be, full visibility on what our plan is, so that neighbors will understand what we're trying to do. It was in no way intended to be a sneak in an approval of a sign in that particular location.
Just so I understand, what kind of signs are we talking about?
It's a monument sign. That's the one that is shown on the plan. On the elevations, there is also a sign on the building that was, I believe in contention. Our architect is here.
Are they indicate the name of the project? Or?
Yes.
Okay.
Yeah.
Thank you.
Again, staff recommends approval with the standard conditions. They found that it is compliant with the Comprehensive Plan and Land Development Code. We have all utilities available. The stormwater management is designed to meet and exceed the 100-year storm. which Mr. Smith can get into more in detail. And with that, I would like to call him up. So I'm going to call Mr. David Smith up as a representative from Interline Engineering.
All right, welcome back, Mr. Smith.
Thank
I'm
you.
going to swear you in again
Yes.
for the purposes of since it's a second project.
Sorry, I'm getting situated
No
here.
problem. Please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
In the interest of time, and since Mr. Smith has already been qualified as an expert in civil planning and Walton County Land Development Code and Comprehensive Plan application and interpretation, as well as preparation of traffic impact analysis, unless there is objection, I'd like Mr. Smith to be qualified as an expert in those areas.
All right. Okay. All right. Then he is accepted again in those 4 areas.
Okay, so thank you, Your Honor. David, if you would, I know you've already provided your work background, but I did want to ask you a couple questions. You stated earlier that you've worked in Walton County in the past, and what were your job duties during that time while you were here?
I would review projects for consistency to the Walton County Land Development Code. I would also review plats for consistency to Chapter 177 Florida statute. I would sign the plat as the county engineer and also the county surveyor.
And since your time here at the county, you have worked on, I believe your testimony was possibly even 1,000 or more projects?
That is correct.
Did you prepare a traffic impact analysis for this project?
Yes, we did.
As I recall, that was not included in the original submittals. Can you explain what happened there and why?
Yes, the original traffic was submitted as part of the Blue Water Landing Development Order. And I was working for D.R. Horton at that time. That was my client. And as stated earlier, we used 20,000 square feet of shopping center because D.R. Horton is a residential home builder. And so the traffic analysis accounted for both the 31 homes and the 20,000 square feet of shopping center. That was reviewed and approved by Walton County back at that time of the original development order, and D.R. Horton proceeded to pay the proportionate fair share amount for their impacts to the Walton County roadway system. So as part of Sunliner Diner's application, the traffic was already reviewed, approved, and committed to the concurrency management system. And so we did a letter stating that the diner being reduced to just over 10,000 square feet would be less impact than the 20,000 square foot restaurant that was approved and paid for by my client at that time.
You said 20,000 square foot restaurant right now.
I'm
Did you
sorry,
mean-
shopping center.
That's okay. Just wanted to clarify.
Thank you.
And is this the traffic impact analysis that your firm created for this project that recently created on September 19th of 25?
Yes, it is.
All right, unless there's an objection, we would like to move in this traffic impact analysis. And what this analysis does is shows the difference between what was approved back in 21 and what the current project would produce traffic-wise. And this would be applicant's Exhibit B if it's submitted, or I'm sorry, Exhibit 2. if
Let's
it's
call it
submitted.
2.
I'm just
Okay.
going to switch them back and forth.
All right, applicant's Exhibit 2 is being offered into evidence, and this is the traffic impact analysis stated what date?
September 19th, 25.
Is there any objection, Ms. Davis? Ms. Davis, any objection from the county? No objection, Your Honor. All right, so applicant's Exhibit 2 is admitted. You may proceed. Okay, thank you.
All right, Mr. Smith, if you would just walk through the project particulars and the design and a little bit of the history for us, keeping in mind that we are kind of on a tight schedule. And here is the clicker.
Thank you, and I will be brief, but as stated, I was the engineer of record for the original Blue Water Landing development. And I would like to briefly present, this is the original plan that was submitted in February the 5th, 2020. So the original plan was for 186 units with 6,000 square feet of commercial located on 0.6 acres. It was a planned unit development at that time. So one of the deviations we were requesting at that time was small neighborhood requires a minimum of 5% of a project to be commercial. We were requesting for a reduction so we could do a lesser commercial amount, which was 6,000 square feet on 0.6 acres. This project at that time was very controversial. We had many, many meetings, numerous community meetings. We interacted with the neighborhoods extensively. And so D.R. Horton at that time made the decision to withdraw the application and resubmit a new application. So we made application on February the 3rd, 2021, and the plan is this plan here, which is the approved master plan that was approved as part of the development order on July the 5th, 2021. The approved master plan, phase 1 is the 31 single-family homes. You'll notice phase 2 is the commercial area, and that is 1.77 acres and approval of 20,000 square feet of commercial. But it's important to note it's 3 times the size as the original application that was submitted back on February the 5th, 2020. I also want to make one more point, if I can go back to the western part of the property. You'll notice on the slide is 22 acres that abuts Draper Lake. Another concession of the developer at that time was to dedicate that 22 acres into a conservation easement. So the western 22 acres of this property is in a conservation easement and will never be developed. It will stay wooded, and that was a concession that was made at that time. The new plan that's being reviewed this morning, as we presented, is just slightly over 10,000 square feet of a proposed restaurant, and it does have access off of Jetty Lane, which does connect to County Road 30A. And I would like to read one more brief, sorry, I keep going back.
It's all right. Can you show me the access,
ma'am.
please?
Is there a pointer on this?
Got to ask the expert now.
On the laser pointer.
Okay.
May I show you on my board?
Yes.
Same image that's on the board.
Right. Okay.
The connection that we're proposing is to Jetty Lane, which that provides access to both phases, and Jetty Lane connects to County Road 38.
Okay. Thank you.
I would like to just share the reason for that connection. When we submitted, as I mentioned, back in February the 26th, 2020, I would like to just present a comment we received from the Walton County Public Works Department that, and I'll read it specifically. It says, please note that Phase 3 commercial must access off a roadway other than 30A. An additional access point onto County Road 30A will not be allowed for Phase 3. And that was at that time. So that's why we stayed consistent with this connection to Jetty Lane with the application that's been, or the application that was reviewed and approved, and that's before you this morning.
And is Jetty Lane the main access for the master planned
Yes, ma'am.
subdivision? Okay,
Yes, ma'am.
thank you.
So you'll notice we have parking that's all internal to the development. We are required 67 parking spaces. We're providing 71 parking spaces. We're also meeting all of the setback requirements, landscape buffer requirements of the Walton County Land Development Code. There's no wetland impacts and no preservation impacts or buyout as part of this phase. Stormwater management. We are proposing an exfiltration system that's under the parking lot. That's just a subterranean, it's a perforated pipe with gravel, and it'll be under the parking lot area. It's the same design that's on Phase 1 of Blue Water Landing. That system's under the road. This will be under the parking lot. So with the sandy soils here, it performs well, and it can contain a 100-year storm event, and the system works well, and it's working well in Blue Water Landing. So it's the same stormwater design. So with that being said, I'd be more than happy to answer questions, or I'll turn it back over to Stephen.
All right, let's see, Ms. Davis, do you have questions for this witness? Mr. Davis? Okay.
Okay, Mr. Smith, how are you today? Just a couple of questions. Would you also agree with Mr. Baranti that the size and scope of the planned restaurant has not changed since June 10th of 2025?
The original application was for 10,000 square feet. It was increased by 86 square feet to 10,086 square feet.
So it's actually de minimisly gotten larger, correct?
It's minuscule and de minimis, I agree.
But it's basically the same since 6/10/2025.
Yes, it's de minimis, I would say it's the same.
Okay. I want to talk just briefly about the traffic study. The traffic study's purpose is to determine whether or not 30A has capacity to handle the projected number of trips in and out of the restaurant. Is that correct?
Yes, it is.
It's not a study to determine the effect or the of those generated trips on the neighborhood next door. Is that correct? It's a capacity study, is what I'm asking.
And we perform the analysis on the roadway classifications that are identified in the Walton County Concurrency Management System.
So it's designed to determine whether or not there's capacity to handle that particular traffic.
Per the roads that are in the Walton County Concurrency Management System.
Thank you. Do you agree with the interim planning director's determination that this is a destination type, or this is a destination type restaurant? In other words, it's not designed just for the residents located within the small neighborhood.
I mean, it will be open to people outside of the neighborhood.
And does we'll go back to the traffic analysis just briefly, does it account for traffic created by employees of the restaurant?
IT classifications provide studies across the United States in various applications. They account for employee as well as customers, and they provide generation rates, which is acceptable engineering practice. And we use the rates that are identified in the ITE code, which does include all of the traffic that's generated by the restaurant.
Including the employees. Do you know what number of employees was used for this particular ITE baseline?
Well, the IT baseline is a national study. So it's a national study on various locations throughout the country, so that employees are variable to come up with a blended or generated rate that's used in acceptable engineering practice.
So I'm trying to get to that question. Do you know what that number is for this particular restaurant? It's square footage.
I don't know if I understand the question.
How many employee trips would be generated by this particular restaurant in this particular setting, this size, having three servings a day?
The accepted practice is to use IT code, and that's consistent with Walton County review procedures. And that's the code that we used.
Okay, so there's no actual number assigned?
There's a number based on the studies that are performed by IT code.
Mr. Smith, I'm not trying to be obtuse. I'm just trying to figure out what that number was that was assigned.
I don't know because it comes from a national study.
Okay. Just so the record is clear, there is only one access in and out of this development, correct?
Correct, as a requirement I read earlier by the Walton County Public Works Department.
And there is no other access and no other access possible, correct?
That is correct.
Thank you, that's all I have.
Thank you.
Thank you.
Anything, anything a follow-up, redirect?
Mr. Smith, is this the letter that you were referring to that you read from that required there to be only one access?
Yes, it is.
30A?
Yes, it is.
We would like to put this in the record, Your Honor, since it's been brought up. This is a letter from Dewberry Engineers under a Walton County Technical Review dated February 26, 2020 of the Draper Lake PUD. And as Mr. Smith read earlier, it says, please note that Phase 3, commercial, must access off a roadway other than 30A. An additional access point onto 30A will not be allowed. So if there's any objection?
All right, any objection to applicant's Exhibit 3 that's being offered?
No objection, Your Honor.
All right, so it is admitted at this time.
All right, thank you for clarifying that, David. My last question for you is, to your knowledge, does the LDC state anywhere that neighborhood commercial uses in small neighborhood must only serve the areas located around it that are also zoned small neighborhood?
No.
Okay, thank you.
Thank you.
All right, I have nothing further,
All right, thank you.
at least not from this witness.
Right, okay, you may call your next witness.
Thank you.
All right, next witness is Tina Ekblad from Sage Entitlements. I don't believe there's any objection to her being qualified
Okay,
as
hold
a.
on, just wait
Oh,
for me,
yes, I'm
Mr.
sorry.
Tatum, okay? Just let me finish up real quick before I swear her in. All right, Ms. Ekblad, if you would please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. All right, now you may proceed,
Okay.
Mr. Tatum.
I don't believe there's an objection to Ms. Ekblad being qualified as an expert in land use planning and the Walton County Land Development Code and Comprehensive Plan. So unless there is, I won't go through the questions of qualifying her unless you would like me to.
Let me find out if there is an objection. Ms. Davis, any objection to qualifications in those three areas?
No, Your Honor, previously testified
All right, Mr. Davis. All right, so accepted as an expert in those three areas.
All right, thank you. Since we handled that so easily, Ms. Ekblad, I'm just going to turn it over to you for your presentation.
Sure.
There you go.
Y'all ready?
Yes, you may proceed.
Okay, thank you. So I just want to go through some of the land use analysis related to this development order application. As a little bit of backup and a reminder, Walton County is broken up into 4 planning areas. We are in the South Walton planning area. In terms of the future land use, we are in the mixed use future land use, which is the predominant category for areas that were not in platted subdivisions in 1996. That category under objective L16 is to accommodate for a mix of commercial, residential, public, civic, and recreational uses. And then a little bit unique to Walton County, the policies under those future land use categories demonstrate what the anticipated zoning districts are. So the mixed use future land use category has a number of zoning districts that implement it. What is specific to this case is the small neighborhood zoning district. Policy L162A identifies small neighborhood as established in areas transitioning from fragmented development to areas with higher density and a mixed-use core that will facilitate neighborhood continuity. I think it's important to note that in addition to a mix of uses being proposed, the policy also indicates that the development in this category should, quote, encourage a walking and bicycle-friendly design to conserve energy and reduce emissions. And you can see from the graphic on the screen that there's quite a large area within this future land use category.
Just to make sure I'm following you, so these are excerpts from your analysis, correct? I'm following along with your report.
Yes, but specifically I've given the objective and the policy number from the Walton County Comprehensive Plan. And then I also want to note that the Walton County Comprehensive Plan in policy L115.4 identifies that compatibility for projects within the mixed use future land use is to be established by promoting an integration of uses, not a separation. And that mixed use projects must submit a detailed site plan, and we can see that through either a planned unit development or the development order process that's in front of you today. And so moving on, the properties that are subject to that mixed use future land use category, as I mentioned, are within a number of different zoning districts. The one applicable to the property today is small neighborhood. We see that the intent in the Walton County Land Development Code is a replica of the comprehensive plan policy. The density is anticipated to be between 4 and 10 dwelling units an acre. And then we have a list of what is actually permitted use categories. And those categories are further defined in LDC section 20300. And so, for example, the neighborhood commercial use category permits offices, brew pubs, cafes, commercial or trade schools, financial institutions with drive-through, a dry cleaner, medical office, gas station with convenience store, as you heard Attorney Tatum, sit-down restaurants, etc. So I want to point that out because while we have these uses listed, they are actually broader categories that are used to identify what is anticipated in these zoning districts. And then I also want to note that there is small neighborhood zoning on the east and west side of County Road 30A here, and that LDC section 20218 states each small neighborhood zoning district shall provide for a mixture of uses. And I want to keep that in context with the existing approved development order. So we are, as you've heard, phase 2 of an existing development order. This particular parcel was created by the recorded plat. It did not exist prior to that. The entire 35-acre property was a single parcel. That is demonstrated by the staff report that was attached to the final order related to that existing development order. And so when we think about the special development standards for the small neighborhood district, we need to go back and evaluate the entire parcel. This commercial component is the mixed use to the residential community that is already established. Without it, the Blue Water Landing Development Project is not a mixed use project. And then as you'll see on the next slide, along this area of 30A, there's existing residential and commercial development within the small neighborhood zoning district and also the other traditional neighborhood development, village mixed use zoning districts, and residential preservation. So immediately to the east of this site, we do have a commercial area known as the Village. It has a small shopping center with sit-down restaurant, hair salon, coffee shop, and then there's a larger standalone restaurant on the other side of that shared accessway. Behind those commercial uses are an existing, I'll say, multi-type residential community. There's attached products and then also single-family units in there.
So is this located, I'm looking at the figure 4 in your report. Is this located off what's shown as Village Boulevard there?
Mhm.
Okay.
Yes, that would be right. If you were looking at an aerial, the commercial is in front of the blue rooftops. And then to the north of that, we have the Ventana Dunes neighborhood, which is a older subdivision that's established, also within the small neighborhood zoning district. And then if you keep going north, we get into Highlands Park. In front of Highlands Park, there is an existing commercial office. And then beyond that, we have very standard, sorry, I just lost my train of thought. Very stereotypical block pattern platted neighborhood development. So if you're looking at figure 4, you'd see that near Blue Wade Drive along that curve in 30A. To the south is very similar with that traditional subdivided block pattern of residential development. The reason those neighborhoods are in yellow is because they're in residential preservation. They existed prior to 1996. And if you're still looking at figure 4, those purple areas south along County Road 30A have some commercial, gas station with convenience store, more sit-down restaurants, shopping plazas that include office, retail, bakeries, etc. I say all of that to point out that this is very much a mixed-use area. Pedestrians and cyclists can get between the residential communities and the existing commercial via a multi-use path along the west or south side of 30A. I believe it's 8 feet wide. It is wider than a standard sidewalk, and it is heavily used by the permanent residents and also the tourists that reside in this area. I do want to point out that under the existing development order, that Jetty Road, that is the shared internal access to the Blue Water Landing development, has sidewalks on both sides of the road. So the existing residents can get from their home to the multi-use path using that existing infrastructure. And then I'll show it in a later slide, but we have 2 proposed access points to that existing pedestrian infrastructure. So as I mentioned, the lot that we're dealing with today was created by the Blue Water Landing plat. It did not exist during the previous development order. That plat does include very specific commitments that reduce the development area. So at the frontage and the rear of the lot, we have existing habitat that is being preserved. Along the frontage of County Road 30A, that provides the required scenic corridor buffer and along the rear, that provides the required preservation of the native community that existed on site. And then we have a 10-foot landscape buffer that's along the southern portion of the property. And what that does is it limits the vehicular access to a single break in the southern boundary that connects to Jetty Road. It provides some separation from the turning movements from 30A into the neighborhood. And then I'm going to flip-flop between the slides here a little bit. You'll see that in our proposed site design, that vehicular access that was created by the plat extends through as far as possible to the north, which will create internal stacking for vehicles on site. So we're not anticipating impact to that existing internal Jetty Road. Then the only other thing I wanted to note was that the front buffer also includes native community preservation, which is required by the existing development order. There is a portion that does not have existing habitat, and we have proposed an enhanced streetscaping, pedestrian pathway, and landscape buffer in that location, which is shown on this slide just in front of the area highlighted in pink. So with those existing commitments on the plat in mind, the design team got together and located the structure, which is highlighted here in blue, non-transparent blue, up against the frontage of 30A. It does have a fenced storage area, which is also shown in blue and is slightly transparent. That is where we are anticipating solid waste, back of house, etc. And what happens is you basically screen a majority of the frontage of 30A using the building and that storage area from the back of house, parking, etc. That is promoted, that design is encouraged by the Land Development Code and the County Road 30A scenic overlay. It would entitle us to a reduction in parking that we have chosen not to take to address the comments that were made by the community during our community meetings. It's fairly obvious, but I'll say it anyway. The preservation of the native habitat along 30A also screens the parking along the northern boundary. And then I talked about the enhanced streetscaping. The area in pink here is shown to first provide pedestrian and bicycle access from the County Road 30A multi-use path. Second, it provides pedestrian and bicycle access from the internal existing sidewalk to Blue Water Landing development. And then a larger gathering area, because with the seasonal nature of the area, we know that patrons will likely be waiting inside and outside during high times. That is offset by an enhanced landscaping plan that was included in the packet, which I believe was County Exhibit 1. So there will continue to be screening from 30A, but we've tried to make that a nice gathering space to address what we anticipate will be higher demand during seasonal peak times. And then I also want to note that we've purposefully located the patron access to the restaurant along the south side of the building. And part of that is to ensure that if people are gathering, they're using that streetscape area and they're not wandering off into that native community preserve in the northern portion of the site along 30A. And then last but certainly not least, you have heard that there are requirements regarding the 30A scenic corridor. The comprehensive plan identifies this in policy L116.1. It specifically identifies that the items that will be regulated by the Land Development Code, including a scenic corridor buffer, with exceptions for properties in the mixed-use future land use, prohibition on walls that immediately front County Road 30A, and that building placement standards, signage, and landscape requirements will be implemented via the Land Development Code. These requirements have been met by the proposed site design. We've talked about the 20-foot scenic corridor buffer being provided through preservation and enhanced landscaping. As a result of that, we've also included the structural setback, although it's not required. Our preservation buffer does include salt and drought-tolerant species, which is encouraged but not required by the Land Development Code. And then our driveway separation, because it was permitted through the Blue Water Landing development project, it meets the separation standards for 30A. And then as you heard, it also addressed those earlier Public Works comments about having a secondary access. We do have fencing around our storage area, and that is required to be consistent with the building theme. As Attorney Tatum noted, there are no specific 30A architectural requirements within the scenic overlay. And then you've already heard this, but just for repeat, we are anticipating that we will need additional permits regarding the building signage, the actual structural building permit, and then I believe the water management district for the water management system. But we did include, you can see it here on the rendering, we did include the ground mounted sign. And then as we were talking earlier, I heard someone note the building signage. Those were here for transparency. We acknowledge that there's a separate process for getting those permits. We just didn't want there to be a question later on, what are you doing, how are you doing it, et cetera. And so in conclusion, it is my professional opinion that the applicant has made the appropriate application for the development request. A commercial restaurant is a permitted use within the small neighborhood zoning district. This development does meet the required 5% of commercial for an existing mixed-use development, and it is phase 2 of an existing approved development order. As you heard Mr. Smith testify to, the engineering plans implementing the site design meet the technical requirements of the Walton County Land Development Code. And then within the surrounding area, we do have existing residential subdivisions and commercial development. And the proposed design is one piece of a larger project that supports the county's vision for an integrated and walkable mixed-use neighborhood. And the restaurant will support the existing residents of Blue Water Landing, the residents that are within the small neighborhood zoning district, and then the larger, broader area should they decide they want to dine out. And then you've also heard substantial and competent evidence provided from multiple consultants that the proposed development will not adversely impact the adjacent and surrounding projects. It can exist in a stable fashion with the existing adjacent and surrounding properties and is consistent and compatible with the predominant single-family development and also, as I've mentioned, the commercial properties in the adjacent and surrounding area. That concludes the presentation. I'm happy to answer questions or if there's any comments from the county or Attorney Tatum.
Great. First of all, Mr. Tatum, do you have additional questions for your witness? All right. Ms. Davis, you have questions for this witness? All right. Mr. Davis.
Yes. Thank you, Your Honor. In your review of the uses outside this particular zone parcel, oops, I think I turned it off by
There you
accident.
go.
There
It's
we go. In your review of the other uses outside of the area that's zoned small neighborhood commercial for this parcel, are there any 10,000 square foot restaurants in that area?
I did not research the square footage of the existing sit-down restaurants.
So to say that this restaurant is compatible with other restaurants in this area, that's just simply not true, or you can't testify that it is?
I don't consider compatibility to be based solely on restaurant size.
But the size of the restaurant does have an effect on the use of the road, the use of the neighborhood, the use of the joint access, and the number
I'm
of
sorry,
people.
Mr. Davis, that was a lot of things. I heard the use of the road.
Yes,
Which road are we talking about?
both 30A and Jetty Road. A smaller restaurant would use less trips, correct?
I am not a traffic expert to answer that question.
Okay. Is it consistent with a small coffee shop?
The restaurant is larger than the coffee shop across the street.
And also Justin Gaffrey Art Gallery, it's not that kind of consistent use, is it? Which is across
A
the street.
restaurant is not an art gallery, that is correct.
And I'm not particularly talking about use, but I'm talking about size and scope. Is that correct? They're not the same in size and scope.
A restaurant and an art gallery are not the same in size and scope. That is your question?
Yes.
That would be correct.
So I'm trying to get to the question. Is there any commercial use in the area that you looked around this particular zone property that's the same size and scope of this proposed project?
I answered the question about the size already. Regarding scope, there is a commercial restaurant next door.
You're talking about Mimo's?
Yes.
Do you know how many square feet it is?
I answered that question. I do not.
Okay. Do you know in that particular neighborhood, I think it's called the Village, how many vehicular accesses there are to that particular neighborhood?
I believe there is a single shared access.
There's no more than one access to the Village? You know for sure?
I answered that I believe there is a single access point.
So you don't know for sure?
I'd be happy to look at a map for
Okay,
you.
yeah, that'd be fine.
So 230A, there's a single access point, and there's another access point to Highway 83.
Okay.
So that would be 2. However, I believe that the 83 access is for residential only because there's a gate.
And in fact, the residential access to the residents located within this particular area is also gated. Is that correct?
This particular area being where?
Blue Water Landing.
Yes, there is a gate to the residential in Blue Water Landing.
Okay. Is it your opinion that this 10,000 square foot restaurant is designed to draw diners from outside of the immediate area?
Any restaurant would in this location.
Well, that's a great way to answer that question. But if it was a significantly smaller, it would be less inclined to draw folks from outside the area. Is that correct?
I don't agree with that.
Okay.
Mr. Tatum, if you're going to make an objection, make it where I can hear it. Okay. Okay. Thank you.
That's all I have. Thank you.
Okay.
Thank you.
All right, Mr. Tatum, redirect.
Ms. Ekblad, to your knowledge, does the Walton County Land Development Code provide a definition for what compatibility is?
It does not. We typically defer back to statute, which encourages neutrality.
And would that be the Community Planning Act definition in 163-3164?
Sounds right.
Okay.
I don't know the number off the top of my head, but it does sound right.
So without testifying, I would point your honor towards the Community Planning Act in 163-3164-9 that does provide a definition for compatibility. And it states, compatibility means a condition in which land uses or conditions can coexist in relative proximity to each other in a stable fashion over time, such that no use or condition is unduly negatively impacted directly or indirectly by another use or condition.
Well, usually judicial notice is for the purpose of getting evidence into the record. I don't usually take judicial notice of the law, but I am well aware of it and its application, its application in terms of a law that is important in determining compatibility of development orders. So I'm not going to take judicial notice of it, though, because I don't think it belongs in the record of the hearing.
Understood. One more question for you. The small neighborhood zoning district itself, does it require a finding of compatibility for any project?
No.
Okay. Is there any zoning district within Walton County that specifically requires a finding of compatibility?
Yes, neighborhood infill comes to mind.
I have no further questions, Your Honor.
Thank you. Ms. Davis, anything? Mr. Davis? Thank you.
With that, we rest. I'm sorry, Your Honor.
It's fine, thank you. Just give me a second to finish my notes here. All right, Mr. Davis, were you planning to make a presentation this time?
Yes.
Okay. I do not.
Thank you.
Go ahead.
First, we'd call be Stephen Shawn.
All right, Mr. Shaw?
Mr. Shawn, would you say your full name
Hold
and
on
spell
just
it?
a second.
I
Hold on. That's
jumped
all right.
in.
No problem. Please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Now you may proceed.
Thank you, Your Honor. Mr. Schoen, tell the court what your full name is and spell your last name and tell us what position you hold currently.
Yeah, my full name is Stephen Schoen, spelled S-C-H-O-E-N. I am currently the Deputy Director and Interim Planning Director for the Walton County Planning and Development Services Department.
And how long have you held the title as the Planning Director? Or Interim Planning Director?
Interim Planning Director. I was provided that role, I want to say April of this year, maybe May.
And you've been a planner for how long?
I've been practicing planning for approximately 16 years in the Panhandle, approximately 6 years for Walton County.
And you consider yourself and would hold yourself out as an are you AICP certified?
I am AICP certified.
And you would consider yourself an expert in the Walton County Code and its application to major development projects?
I would.
We'd tender him as an expert in that area. I don't think there's any.
All right. All right, so I am accepting Mr. Schoen as an expert in the Walton County Land Development Code and its application to major development projects.
Thank you, Your Honor. Mr. Schoen, I believe this letter is already part of the evidentiary package submitted by the applicant, but in June 10th of 2025, you provided a letter to David Smith of Interlight Engineering Corp. Is that correct?
That is.
I'm going to show you a copy, and Your Honor, if I may approach, I'll hand you a copy so you'll have it. And I guess we'd mark this as objectors 1.
Yes, you may. Thank you.
On page, first of all, what was the purpose of this particular correspondence?
This was to address any concerns or questions relating to my decision at the Technical Review Committee meeting prior to my issuance of this letter, as a courtesy and for the record for this application.
Okay, no problem.
I direct your attention, Mr. Schoen, to the second page of that particular letter. In the first non-full paragraph, you state, despite this hodgepodge of historic development patterns, the currently proposed project, which would be the project at issue today, stands out in contrast and as an outlier in Contra's ideas of conflict with the built environment, not only with a 30-acre scenic corridor, but also with the overall development site that is comprised primarily of single-family dwellings in close proximity. Since June 10th of 2025, I believe the testimony has been there's been no changes to the project. So would this opinion still hold today?
Yes, to my knowledge, without any changes, it would.
Okay. And you also state in subparagraph B that you have concluded that despite a phased commercial development having been previously considered as part of the overall development, the current proposal appears somewhat inconsistent with the intent of the underlying zoning and conflicts with the overall development plan. Again, since there's been no changes since June 10th of 2025, would this opinion still be the same?
I suspect so, yes.
Okay. And can you tell us how you believe it was somewhat inconsistent with the intent of the underlying zoning?
I would have to say that the design, scope, and scale of the development in relation to the size and character of the development site, as well as surrounding built environment, it did appear somewhat inconsistent with the existing built environment.
And that would be, is it your opinion that would be inconsistent with the requirements of section 2.02.18, the small neighborhood zoning district requirements?
No, it would not.
Well, in what part of the code would it be inconsistent with?
If it was inconsistent with the code, I would have denied it at the TRC level. It was just a question that I determined needed some additional review by other bodies other than the TRC.
And did those additional reviews, for instance, the Planning Commission rejected the proposal, correct?
That is correct, I believe.
Okay. And the size and scope of the project has not changed, as we've said multiple times, correct?
That's my understanding.
You said the currently proposed stands out in contrast to the 38 scenic corridor. Tell us what you meant by that.
I believe at the time I was specifically concerned with the aesthetics of the proposed building as being a sort of very shiny metallic structure, in keeping certainly with an aesthetic that they're going for, but not with the surrounding development patterns.
And is that a compatibility type analysis?
I did not necessarily consider it at the time, but I suppose it could be argued that.
And do you believe that the 10,000 square foot restaurant as proposed promotes the future viability of the neighborhood known as Blue Water Landing?
Please repeat that.
Sure. I'm sorry, I stuttered through it. Do you believe that the development of a 10,000 plus square foot restaurant would promote the future viability of the Blue Water Landing development, or neighborhood rather?
I'm not sure I'm qualified to speak on the future viability of that.
You understand that is a requirement of the small neighborhood zoning district?
What is?
That the development, that the mixed use development would promote the future viability of the neighborhood?
Is that the specific language in the code?
Yes, sir. Yes, I'll show it to you. I'm not trying.
Right, so in terms of the phase one of that project, I suspect I had some questions about that particular component of the code. Not necessarily as it relates to all of the surrounding neighborhoods or surrounding neighborhood in general.
But you had concerns that this particular 10,000 square foot restaurant would not promote the future viability of this particular neighborhood?
In a sense, yeah, I did have some concern there, yes.
Have those concerns in any way been modified or allayed since June 10th of 2025?
Not that I'm aware of, no.
Lastly, you said the current site layout provides a shared access point with phase one, which contains 31 single-family homes behind a gated community. Tell me what your concern is there.
My concern is simply the access, the way that it's laid out, with the T and the gate into the phase one portion of the development site. I have concerns, I had concerns and still do about the functionality of that gate. If that gate were to malfunction during a busy time, I believe that vehicles could potentially be stopped in the 30A corridor and could cause some safety concerns there.
And is that concern enhanced by the addition of this restaurant to this particular neighborhood?
It is the primary enhancement. Without the restaurant, I do not think that a malfunctioning gate would serve to create the same issue within the corridor itself.
Would let me rephrase that. Would a development of a multi-use or smaller neighborhood commercial use, such as a coffee shop, a hair salon, those types of uses, would that cause the kind of traffic concerns that you would have in the neighborhood?
I suspect so. On some limited basis, it could.
Would it be greater with this type of use?
Based on my understanding and potential popularity of the restaurant, I did have that concern and still do.
You understand this restaurant is not designed just to attract pedestrian type of clientele, correct?
I don't think any restaurant, or very few, are designed that way.
Unlike Bud and Alley's in Seaside.
There may be some that are pedestrian oriented, but not at this location.
And so it's going to draw significant traffic to the neighborhood. And I'm not suggesting that it's not meeting the capacity or will exceed the capacity for 30A, but you'll agree it will draw significant traffic to the area.
I'm going to object
Okay, in land use planning, correct? Let's see. Let me just go back to what I wrote down. I think I accepted him as an expert in the Walton County Land Development Code and its application to major development projects, right? Not even into planning. You didn't offer him as an expert in planning, did you? Okay. Okay, so I'll sustain the objection then.
That's fine, Your Honor. Question about the code, hang on a second. And I've suggested this before, do you believe that do you believe that the requirements of the small neighborhood zoning district as written by the Walton, or as written in the Walton County Code, the application of the standards are within the district, not within the neighborhood itself?
In terms of the developed neighborhood as part of the master plan?
Yes.
Say that one more time. The question is?
The requirements for pedestrian access, pedestrian-friendly use, all of those requirements in subparagraph G, the special development standards, are for the actual neighborhood, not for, or for the actual zoned property within the project, not for the area surrounding the neighborhood.
So, well, I'll be honest, I'm not exactly sure what the question is, what you're actually asking me here. But I will say that there is both, I think, intent within the zoning district to ensure compatibility and pedestrian-friendly infrastructure, et cetera, within the development site as well as outside the development site.
Is there anything in the actual language of the code that suggests outside the development site that you're aware of?
Not explicitly, nor the opposite.
Thank you. That's all I have, Judge.
Okay.
Thank you, Steve.
Thank you.
Wait just a second. Okay,
I'm sorry.
No, I was confused.
all right. Do you have a cross-examination, Mr. Tatum?
I do, just a couple of things. Mr. Schoen, good morning.
Morning.
Made several statements there about why you elevated this project from a minor development order to a major development order. I don't know if you have in front of you the conditions for what requires you to be able to make that elevation. I believe it's in that letter. Could you read that?
I'm sorry?
Could you read to us what that standard is?
Are you talking about subsection 7 here?
Yes, please read that.
Okay, so looks like under section 1.13.11.7, any development that the Director of Planning and Development Services determines should be subject to more thorough consideration and review based on the following criteria. A, a proposed development is part of a larger parcel for which development is anticipated and would likely exceed the limits of a minor development plan when considered in conjunction with the larger parcel, or the proposed development will have a potential impact on public facilities, natural resources, or public safety based on location, complexity, or the hazardous nature of the use.
And it's your contention in this letter that which part of that applies to this particular development?
7B.
Okay, and why does 7B apply?
Because I determined at the time of technical review that there is a potential impact on public facilities and safety.
And would the public facilities be the roadway?
That would be the County 30A roadway, yes.
Okay. And was 20,000 square feet of commercial space already approved on this lot?
I believe so.
So the property owner was vested to build 20,000 square feet of something there that was commercial?
Up to, yes, sir.
Up to, yeah, we can agree to up to. Okay. So, but it's still your contention that although 20,000 square feet of commercial space could be built there, a potentially more intense use that is allowed in neighborhood commercial could be built there, that this still needed to be elevated to a major development order because of potential impacts on facilities?
Yeah, I think if the application was brought in with the 20,000 square foot retail, I would have had similar concerns.
Okay. Discussing compatibility, you stated that that you did not feel like it was compatible with the built environment. Is that a requirement that can be considered per the Land Development Code?
I think there's some attention that must be paid to compatibility. Is the term built environments explicit? Is that what you're
Correct.
asking me? I don't believe so.
Should
I'd
you-
have to look at the code.
Would you not take into account the actual zoning district that the project is located in?
As any sort of analysis, I would suspect that would be absolutely part of that review.
And in that review, isn't it presumed that if a use is allowed in the zoning district, that it is compatible?
There is an innate sort of understanding, of compatibility in that regard.
You also mentioned the look of the building,
That's
shining the exterior facade. Is that a consideration in the Land Development Code or any other code that the county has allows to be taken into account?
No.
Okay, all right. You also had concerns with the T intersection. That was approved along with the original design, is that correct?
The layout into the site, the commercial, there was a proposed access into that commercial section. Yes, sir.
All right, and you mentioned the gate that the HOA has installed.
That's correct.
Was that gate installed as part of the original development order?
It was not.
Who petitioned for that gate to be installed?
I believe the HOA.
Okay. And that was done after the plat for the subdivision was recorded and the subdivision was built out, is that correct?
I believe so.
Okay. That's all I have for you.
All right, Ms. Davis?
Mr. Schoen, as far as the prior development order that entitled up to 20,000 square feet of commercial space, the prior conditions of approval for that development order, those will still apply even with this new development order in place.
Yes.
So any limitations of things such as amplified noise, things like that will still apply.
Yes.
That's all I have.
Okay, thank you. Mr. Davis, any redirect? All right. Thank you, Mr. Schoen.
Or we would call Louis Cerna.
I hate to interrupt you, but I need to take a quick break. I'm sorry. All right. If we could take like 5 minutes, come right back. Thank you.
Thank you.
I will second that.
I mean, what do you like? What do you like? Because my wife's having two surgeries, one next Friday and one. What day is it? Hey, I'll take my son.
Okay, please take your seats. We're going to go back on the record. All right, Mr. Cerna, thank you. I'm sorry to interrupt you.
Oh, no problem, no problem.
Please raise your right hand. Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Davis, you may proceed.
Thank you, Your Honor. Mr. Cerna, say your full name for the record.
It's Luis Cerna, Luis Cerna, Serna.
And Mr. Cerna, would you tell us where you're currently employed?
I'm employed with Calvin Giordano and Associates in Clearwater, Florida.
Your Honor, I believe Mr. Cerna has testified previously as an expert on the Land Development Code and planning. Before you, we would tender him in that areas.
All right, on the LDC and in planning. All right, is there an objection, Mr. Tatum?
There's a question.
Okay.
Walton County Land Development Code or?
Walton County Land Development Code.
I have no.
And comp plan, yeah.
I don't think he was previously certified as an expert in Walton County LDC and comp plan, so I would ask for proper stuff in that regard.
Okay, would you like to go ahead and ask those questions then?
Brooke Davis on behalf of the county. Mr. Cerna, as far as Walton County, what is your exposure to Walton County's Land Development Code and LDC?
Yes, I have written at least 2 neighborhood plans for Walton County that are part of the Walton County Code, and I've represented various communities in Walton County for the past 15 years or so.
Have you testified in Walton County in an expert capacity in either the comp plan or the Land Development Code and any other quasi judicial matter in Walton County?
Yes, I have. In a DOA hearing, at least one DOA hearing and several other hearings.
As far as an expert in the LDC and the comprehensive plan?
Correct, yes.
I don't have any other questions at this point.
All right, are you continuing to object, or did that clarify for you?
That clarifies.
All right, and let me clarify with you, Mr. Davis, so you're offering him as an expert in planning, an expert in the Land Development Code, Walton County Land Development Code, and the Walton County Comprehensive Plan?
Yes, Your Honor.
All right, Mr. Tatum, you didn't have an objection before, but it wasn't clear to me he was offering it as an expert in the county's plan as well. So do you have any objection?
No.
All right. All right, so accepted.
Mr. Cerna, did you prepare a memorandum analyzing the application for the Sunliner Diner at the Blue Water Landing Blue Water Landing development?
Yes, I did.
And is that memorandum dated September 19th of 2025?
Yes.
Judge, may I approach?
Yes, you may. And Mr. Davis, I don't think you offered this letter into evidence. Did you intend to offer that one into evidence? Okay, so I realize we're going back to the letter that the previous witness was questioned about. I noted that it was not actually moved into evidence. Mr. Davis is moving it now. Is there any objection to the objection? I was referring to it as opposition.
No.
Opposition Exhibit 1.
No.
Ms. Davis? No. All right, so that one is admitted. All right, you may proceed.
One last exhibit. We do, even though he's been accepted, we do have his resume we'd like to make part of the record, or curriculum vitae.
Okay. All right, so are you moving Opposition Exhibit 2 as well? Okay. All right, so Opposition Exhibit 2 is a memorandum to Blue Water Landing's HOA from Mr. Cerna himself, and it appears, I guess, his analysis or report. Is there an objection to this document?
Not from the county, if Mr. Davis has a copy.
Okay. Okay. All right, so I'm admitting Opposition's Exhibit 2. All right, the third one being offered is Mr. Cerna's curriculum vitae or resume as Exhibit 3. Is there any objection? And do we have a copy for the clerk? All right, so that one is admitted as well. All right, now you may proceed.
Thank you, Your Honor. Mr. Cerna, did you prepare the report that's been marked and entered into evidence as opposition number 2?
Yes.
And tell me what you did how you prepared and what you did to complete this report.
Yes, I reviewed the applicant's submittal, reviewed the staff analyses prepared by the county, did my own code and comprehensive plan analyses, and did the report.
And can you briefly, or I guess as long as you need, describe your conclusions or how you reached the conclusions regarding the application for the major development order filed by Sunliner?
Yes, and I can be fairly brief. It's my conclusion is that it is not consistent with the Land Development Code or Comprehensive Plan because it does not qualify as neighborhood commercial. It's not pedestrian in scale and does not comply with the purpose and intent of the Route 30A Scenic Corridor Overlay. And just to cite the sections of the code that where I've got those where I received those terms, Section 2.02.18 gives the purpose and intent of this small neighborhood district in which the proposed diner is located. Section 2.02.18B, primary uses allowed, states neighborhood commercial uses subject to subsection G, which are special development standards. Within that subsection G, it states small neighborhood projects shall be pedestrian in scale and shall facilitate and encourage pedestrian use. We also cite section 6.10.00A, which is the purpose of the 30A Scenic Corridor Overlay. It states the design standards shall be to preserve and maximize views of the Gulf of Mexico and to enhance the visual characteristics of the north and south sides of Route 30A right-of-way, as well as the east and west rights-of-way of the connector roadways.
Let me interrupt you just briefly. Section 2.0218B, primary uses allowed. A restaurant is a use that's allowed, is that correct?
Correct, yes.
But it is subject to the terms and conditions of subsection G, is that correct?
Correct.
Okay,
yes.
Go ahead, I'm sorry. And one other thing, you read a portion of small neighborhood projects shall be pedestrian in scale. There's also a second sentence related to that. Could you tell the court what that is?
Yes, it states the placement of residential and commercial land uses shall be such that pedestrian rather than vehicular access to commercial uses is facilitated and encouraged.
And that particular part of subsection G is applicable to this project, is that correct?
Correct, yes.
Go ahead, I'm sorry, I didn't mean to interrupt.
Oh yeah, no problem. I cited the sections about the 30A Scenic Corridor Overlay. We also cited policy L-1.6.2 of the Comprehensive Plan. It states that each small neighborhood shall provide for a mixture of uses to encourage economic diversity and sustainability within the area, promote the future viability of the neighborhood, and encourage a walking and bicycle-friendly design to conserve energy and reduce emissions. Just briefly going through some of the terms that we have looked at. First, I mentioned pedestrian scale and where that's mentioned in the Land Development Code. We looked at pedestrian scale. It's not defined in the code, but in the planning world, planners typically use pedestrian scale as anything within 5 to 10 minutes walking distance, which is considered to be 1/4 to 1/2 mile. So we did an analysis. We just did a quick and dirty 1/4 mile radius of the Sunliner Diner site. We've identified 474 residential units according to the property appraiser's data. That includes condominium units. It includes vacant land, vacant lots. So 474, approximate number. that what is being proposed here is a 10,000 square foot restaurant with 71 parking spaces. The 71 parking spaces are slightly more than what's required by the Land Development Code, clearly designed to attract a large number of customers outside of that, what would be considered a pedestrian scale. We also, and just to note, we only looked at a quarter-mile radius because we measured walking distance within a quarter mile because obviously people don't walk in a straight line. So taking into account sidewalks, crossings, walking paths, walking in the roadway. At the edge of quarter mile, we came up with about a 9-minute walking distance. So we think the quarter mile is appropriate. We looked at the term neighborhood commercial. Again, it's not defined. There are uses defined in the code, but it's not a question of use, it's a question of scale. In my professional career, I've never been asked to try to approve a 10,000 square foot restaurant as neighborhood commercial. Typically, when you're talking neighborhood commercial, you're talking about small retail like a convenience store, which is anywhere from 1,300 to 1,650 square feet. Looking at a typical Starbucks, that would be 1,500 to 2,000 square feet in size. So again, these uses would be more typical of what is considered neighborhood commercial. And that would be if they did not include gas pumps, drive-through facilities. Our opinion is that this is at least 3 times larger in terms of square footage as what could be considered neighborhood commercial. And we understand that the previous development order designated this area for 20,000 square feet of commercial, but the intent of neighborhood commercial is that that use not be a single use, because clearly anything 20,000 square feet and 10,000 square feet as what is being proposed is not neighborhood commercial. And as I indicated, it's not pedestrian in scale. And finally, we looked at the 30A scenic corridor overlay. This is a large themed restaurant. The architecture has a theme that includes signs that extend, lighted signs that extend above the roof of the building. It includes lighted accents along the roof line. So it's clearly designed to be viewed from a distance beyond the immediate area of 30A. So in our opinion, it's not consistent with the 30A scenic corridor overlay. So for those reasons, it is my opinion that this development is not consistent with the zoning and comprehensive plan.
Just one couple of follow-up questions. You do understand that the 30A scenic corridor overlay does not have any architectural requirements for buildings?
Correct, yes.
But that's not the concern you have, correct?
Correct.
Okay. Secondly, specifically as it relates to the Land Development Code, as you understand pedestrian friendly, this particular development in size and scale would not be pedestrian friendly to the area, correct?
Correct.
That's all I have.
Thank you. All right, Mr. Tatum? Uh-huh.
Mr. Sir, my name is Stephen Tatum. I represent the applicant. Just have a few questions for you. You stated that neighborhood commercial uses are to be pedestrian in scale. In your opinion, would the approved 31 residential houses that are already built and the 20,000 square feet of commercial be considered pedestrian in scale?
Well, it's the neighborhood commercial that has to be pedestrian in scale, and individual uses within 20,000 square feet of commercial could be considered pedestrian in scale, but a single use, certainly over 3,000 or 10,000 square feet would not, in my opinion, be considered pedestrian scale.
But the Land Development Code, does it require, and I know it uses the words pedestrian in scale, But does it require a certain square footage anywhere for a particular neighborhood commercial project?
No, you're correct. It does not establish a square footage, but, I believe there is an intent behind the term pedestrian scale.
So to your knowledge, does the small neighborhood zoning district include a floor area ratio maximum and an impervious surface area maximum?
Yes, I believe it does.
And you have reviewed our project, correct?
Yes.
And does our project meet the requirements for the FAR and the ISA?
Correct,
Okay,
correct.
all right. You also stated that the intent of neighborhood commercial is that the commercial be mixed use. I did not understand that statement. This is just more of me asking for clarity.
Yeah, I don't remember stating that it had to be mixed use. It shouldn't be single use, I think is what I stated, is a single use of that size is not neighborhood commercial. Let me, just clarify. You can have a single use and it be neighborhood commercial, but a single use of 10,000 square feet would not be neighborhood commercial.
And you're basing that upon a land development code provision?
No, that's just based on my experience of what is commonly considered in the planning world to be neighborhood commercial.
And what is generally considered in the planning world to be neighborhood commercial?
Yeah, as I stated in my testimony, uses that would be around the range of 1,500 to maybe 3,000 square feet. Basically, it's uses that provide essential services and retail needs for residents within a residential neighborhood.
So a neighborhood commercial market is an allowed use as a neighborhood commercial use. Is it your contention that a 15,000 to, I think you said 3,000 square foot, the market would have to be limited to that square footage to be considered neighborhood commercial?
Yeah, I think based on it depends on the use and it's a question of use and scale. But if you're talking about a restaurant, yes, I would say it cannot be 10,000 square feet would not be considered neighborhood commercial because it's not neighborhood serving. It's serving beyond the borders of the neighborhood. And I think that terminology is used in Walton County's code for a reason. It's not general commercial. It's not just commercial. It's specifically stated as neighborhood commercial. So I believe, in my opinion, there's an intent behind that language.
Would it surprise you to know there's actually a neighborhood commercial zoning district in the land development code?
No, I understand.
Okay, all right. Last question. This again is another question more for clarity. I think I heard you say that the height of the building means that it's intended to be seen beyond the neighborhood. Is that what you said?
The sign, at least in the renderings in the submittal package, extend above the roof of the building. So it's clearly the signage, which are lighted with the neon type lighting, are clearly defined to be seen beyond the borders. It's designed for visibility.
Okay. And would it surprise you to learn that the maximum height on the building is 26 feet?
No, that wouldn't surprise me.
Okay. And would it surprise you to learn that the maximum height of the trees surrounding that area is higher than 26 feet?
No.
Okay. All right.
I understand.
All right. I have no further questions.
Okay, thank you, Mr. Tatum. Ms. Davis? No problem. All right, Mr. Davis, redirect? Okay. Thank you, Mr. Cerna.
Thank you.
Yes.
The next witness I have is Nikki Nickerson.
Hi, Ms. Nickerson, welcome.
Good morning.
Please raise your right hand.
Right hand.
Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please state and spell your name for the record.
Nikki Nickerson, Nikki, Nickerson.
You may proceed, Mr. Davis.
Ms. Nickerson, tell the hearing officer of the magistrate, what do you do for a living?
I have been an owner-operator on 30A for the last 25 years in the restaurant business, retail business.
And tell the name of the last restaurant you owned on 30A.
Well, I still own a few, but
How many restaurants have you owned on 30A?
I have 3.
You've had 3.
So the last restaurant was Blue Mabel, which was a 4,200 square foot restaurant,
And where was-
142 seats.
Thank you. Where was it located in relation to this project?
Quarter of a mile, half a mile.
Okay, and again, how large was it?
What?
What was the square footage of that restaurant?
4,200 square feet.
Okay, and how many parking places do you have available for it?
We had 52.
How long have you been in the actual restaurant business?
25 years.
And have you had experience in restaurants that are open part of the day or all day? Tell the court their background experience as it relates to the type of restaurants you've owned.
So I own restaurants, started in Rosemary Beach, which is planned development. I owned a restaurant in Seagrove Beach. I have a restaurant in Blue Mountain Beach called Cowgirl Kitchen, which is very close to this project as well. All of my restaurants, aside from Blue Mabel, which was a large-scale, upscale restaurant with 142 seats, my other restaurants have all been more small neighborhood commercial.
You understand that this project's going to have 200 plus seats and 10,000 square feet and 3 services a day. Is that your understanding?
Correct.
Based on your experience, what would be the staffing requirements for that particular type of restaurant?
Over 110 employees.
Okay, and given, again, your experience, where are those employees going to park, for instance?
Where, say it again?
Where are they going to park? How are they going to get to the?
Well, that's a good question.
Your Honor, I have a question.
Okay.
I'll be qualified as an expert in it.
Yeah.
She's providing testimony at this point about the project. Just trying to figure out really not relevant to that. I'm taking the question again.
Let me go ahead and attempt to qualify as an expert judge in the area of restaurant management.
Okay, she's being offered as an expert in restaurant management. Mr. Tatum?
Going to object. My main objection is that she just said on the record that she owns a restaurant very nearby. And I've not heard enough yet to know if she is an expert running a restaurant on.
Well, there's some.
Okay, hold on a second. All right, Ms. Davis.
I don't know that partiality would be a objection to whether she's an expert or not. But as far as restaurant ownership, that may be one area. I'm not really sure as far as the management goes.
So, Mr. Davis, I don't understand what the relevance would be of testimony as to restaurant management.
The size and scale of the proposed restaurant, Your Honor, as it relates to the Land Development Code. And to support the previous testimony of Mr. Cerna as it relates to the size and use of the property, or size and use of the restaurant.
So you say restaurant management, but when I ask you what the relevance is, then you say the size and scope in relation to land use planning. That's not a management issue.
I may be parsing it too carefully, Judge. Essentially, she's owned restaurants on 30A. She could absolutely, I believe, testify and give the court some understanding of the effect, the effect and impact that this particular restaurant will have, both on the neighborhood, and that relates to the Land Development Code as testified to by Mr. Cerna. Is that a little clearer?
It is clear, and I don't agree that it's relevant. I think that that's what the experts are here for. The land use experts are here for. That's what the experts in engineering are here for, and those with experts in traffic analysis. So, I mean, I've already heard today that the traffic generation reports that were submitted for this development were based on the ITE manual codes, and those codes assume a certain number of employees will be used, or are included in the count of trip generations, right? So how could I possibly accept testimony from someone who's neither a traffic engineer nor a land use planner as to how the number of employees is going to impact traffic? I mean, do you understand?
Judge, I'm probably, again, not parsing it well enough. I think it would not be an issue of the traffic as relates to the ability of 30A to handle the traffic, but it is, and that's what the ITE study is. It's whether there's capacity on 30A to handle the traffic. That's the questions I'm trying to get to is whether, or the effect that increased traffic will have on this neighborhood, and what that actual number of traffic would be in the neighborhood versus the capacity of 30A to handle it.
The impact of the traffic from this proposed restaurant on this particular neighborhood is still not something I would accept from an expert in restaurant management. I would still want to hear that from an expert in planning or site development or land use, something like that. So, okay. So,
thank you, Your Honor.
So there have been a couple of objections. I'm not necessarily sustaining those objections, but I'm not allowing it on the basis of relevance.
Okay. And Judge, what I may do is just let her sit, and if she wants to come make public comment later, I would allow her to.
Well, if you have factual questions you want to ask her, you can elicit factual testimony from a fact witness. I'm talking about expertise.
Yeah, well, that would all be related to the impact of the restaurant. Yeah.
Okay.
Thank you. Just have a seat right now. Thank you. And Judge, you can have a seat right now. The next witness or judge would be Brad Webster. He's the president of the Homeowner Association at Blue Water Landing.
Okay.
And Judge, I'm going to let him speak, and he's speaking on behalf of the organization. So as my understanding of the memorandum, he would be allowed 10 minutes if necessary.
Okay, so then are you concluding your presentation then as an intervener party opposition? Because this would be him coming up as part of the public hearing process.
To answer your question, no, Your Honor, I'm not. But that transition, it's hard to know when we're doing that, but I'm not doing that now. I'm just calling him as a witness now. But I didn't want the court to think he's testifying as just a general member of the public, but as a representative of the HOA.
And that's fine, but we're not going to double count. When it comes time to public hearing, I'm not going to hear from him again for 10 minutes, okay?
And as I understand the memorandum, or other members of the association, if I understand the memorandum.
Okay.
Thank you.
Just to be clear, I have no objection to him testifying in a narrative fashion as far as the evidentiary portion. I will have some housekeeping to talk about before we move into the public portion of it.
Okay. All right, great.
Thank you.
And I may have an objection, but I want everybody to say.
Okay. Well, I mean, the main difference is if he's testifying in your case presentation, he's gonna be testifying under oath and subject to cross-examination. If he's testifying in the public hearing portion, it is not under oath and not subject to cross-examination. So that's your choice, and you're choosing to present him now.
And Judge, I'm doing that because, quite frankly, there's been a lot of discussion about the weight and relevance of evidence that's presented at public comment. So I just want to make sure it's not considered public comment.
All right. Welcome. Please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
And please state your name for the record.
My name is Brad Webster, BradWebster.
Thank you, Mr. Webster. And you are president of the Homeowners Association?
Yes, ma'am.
Okay. And the name of it again is the Blue
Water Landing
Water
HOA.
Landing. Thank you. All right, Mr. Davis, you may proceed.
And I'm just going to ask a couple of general questions and ask him to provide a narrative to
Okay.
the court. Mr. Webster, where do you actually reside?
Blue Water Landing.
And you have lived in that neighborhood for how long?
Approximately a year and a half.
Have you been involved in meetings and discussions regarding this particular development of this restaurant from the beginning?
Yes.
And have you spoken at both TRC and, at the Planning Commission?
Yes, I got up at the first and second technical review meetings and the Planning Committee meeting.
Okay. Do you have a statement you'd like to provide to the hearing officer?
The primary thing that we want to make sure is known is this development really is centered, for us, is centered around the character, the scale, and the access. And I don't want to go through all of the code because we've had a lot of discussion about the code, but there's some key terms in here I think that are relevant, and I want to make sure it gets highlighted. And that the code promotes the health, safety, and general welfare of the residents. It does talk about enhancing the character of the community, and it talks about having adequate provision of infrastructure. And those are key things. Specifically drilling down to the small neighborhood that's been talked about a lot, it talks about the economic diversity and sustainability of the neighborhood and promoting the future viability. Again, it states sufficient infrastructure and talks about the pedestrian and scale. The one thing that we find very interesting or troubling is that pedestrian and scale term gets used a lot, but to the best of our knowledge, that is not really defined in the Walton County Code. So we have to go to multiple sources. We went to the internet and just started digging through that to try to understand what it means. And it talks about, that again, it's walkable, reducing the car dependency, that it's safe, there's frequent crosswalks, and all that. And just summarizing that, again, it talks about the walkability, the safety, serving the neighborhood, having multiple mixed-use services to serve the neighborhood for the local residents. In our opinion, pedestrian scale is not a 10,000 square foot single-use facility. We do believe that its size and the way it's advertised, it's more of a tourist destination that's going to draw from miles away. And the big thing, especially for the residents in the front of the neighborhood, is the lights and the noise from the music that's going to be going on all the time. Those are things that we would not deem to be pedestrian scale, in our opinion. The photo here, I just want to make sure that we kind of level set everything. A lot of the initial presentation that was done by this developer, they omitted when the homes were built, and they've just recently started adding those in there. So there was a perception out there, I think, with a lot of people that this restaurant was going to go here, and there's nothing there. Our homes, and I've gone out to the best of my ability with a measuring wheel, tried to estimate where this thing would sit, and to best I can determine, the first two homes are going to be within about 115 to 125 feet of this restaurant, with lights and everything pointing right at the homes. So I think that is important to understand. The orientation of the building, again, is facing right at the first two homes, within 100, 125 feet, whatever that is. The light study, I do want to bring this up again because it was introduced, I believe, in the very first technical review meeting by the engineer, that he said that the lighting study was not intended for the people of Blue Water Landing. It was intended for the people across Draper Lake. And I want to draw special attention to the Fourth Amendment of our CCRs, where it specifically states in our Fourth Amendment that any lighting in this has to be pointing straight down and completely shielded to not distract or annoy the neighbors in this addition. So that's important to understand, as well as the music. I think in their original presentation, they had a sound study that was done at one location. I believe there are multiple entrances in this building, of which one of them, I believe, is on the end facing the homes. And the bubble that was drawn around that, or the study actually went down into our amenities area, which is would be to your left, right over there. So their parking lot and their building is going to face the homes. The sound is going to go all the way around the perimeter of the building, and will definitely reach into the our future amenity area where we intended to build a swimming pool or tennis courts, whatever it might be. It clearly gets into that area for us. The character, we have talked a little bit about the character of this. This clearly does not fit within the character of 30A, and most certainly doesn't fit within the character of Blue Water Landing. All the architecture there is white with black metal roofs. If you go to the villages across the street, it's the same white building, metal roofs. This does not fit within the character of that area at all. I do want to flip, if I could. I believe this is the Pigeon Forge location of Sunliner Diner. And I just want to point out that this sets on a multiple lane road, multiple access points, and it's hard to see, but just the sheer volume of the cars for that location. If you could flip to the next one as well. There's the Gulf Shores location, similar scenario. It sits on a 4-lane road, multiple access, large parking lots, full. Don't see a lot of homes in this area. This is going to set within 125 feet of our homes.
I'm going to object to relevance on this, but also those two facilities sort of have nothing to do with our development.
Okay. Because he is testifying in the opposition's case in chief, he is subject to cross. So I'm going to ask you to just save that for your cross-examination.
I want to find this picture here with our gate code on it. It may be back. Had a lot of talk about the gate. So the reason I bring up the other locations, this is the entrance that we've talked about for Jetty Road coming off of 30A. Again, I have measured this from the boundary there on 30A to the access point. It's 151 feet. That entire Jetty Road is approximately 340 to 345 feet. The distance between the jet outs of the curb is 22 to 23 feet, depending on where you measure on the radius. So the key part of this is this additional traffic, as we saw in the other locations. We try to funnel that into this 151-foot access road is going to be an issue. I live this every day. It's an issue today, getting out, especially during peak season. It is a problem getting out there.
What am I looking at? Are these aerial photographs? Is this a rendering? What
That
am I
is
looking
an
at?
aerial photograph of right over the entrance of the subdivision. And I do want to highlight that our access gate terminal is on the left. So as cars are going to be exiting from this facility and we have people coming in, we have to get in that left lane for the RFID tag to work, or if it's a renter, to put in a gate code or whatever. So there's going to be conflicts right there, absolutely. The other thing I would want to point out is, and I am not an expert at driving a semi, certainly, but I have done some research on it, and for like a supply truck, a Cisco supply truck, come in and supply this restaurant, they need approximately 65 to 70 feet to make a turn. That road is only 23 feet wide. So for them to swing out and make a turn, it's going to be very difficult. And I would challenge everybody to think, if they can't get into that access road to get to the restaurant to do that, where are the supply trucks going to park? Are they going to block the front parking lot there that's supposed to be overflow for the residents? Or are they going to put it out on the blind curve of 30A, further causing problems with visibility? Just regarding the visibility, I don't have the pictures of the slide, but we do have something that we can present to you in a minute. I sat at the front of the subdivision in our vehicle, stopped at the line in which Department of Transportation or the county put the lines there for cars and vehicles to stop. And the visibility to the right or to the left is, I'm going to say, maybe 40, 50 yards. Because of the blind curve and the vegetation that's there, it's very difficult to see cars coming on, as well as the bicyclists and the pedestrians. So again, the residents there, we're dealing with this every day. And you have to make a snap decision to get out there without, you know, hitting another car, getting in an accident, coming around that curve. It's just difficult. I mentioned earlier about the Fourth Amendment of our CCRs. In the deed in purchasing this property, it's my understanding they were presented with this. It does talk about all the outside lights, got to be placed to avoid annoyance to the subdivision. It talks about the landscape buffers. I heard earlier they had mentioned 10 feet. In the covenants, it says they have to have 15 feet, and there has to be an 8-foot wooden fence to completely block any view from the first few homes. I've not seen or heard any of that mentioned. For those reasons, we believe this development doesn't fit, simply because of the increased traffic, the difficulty it's going to cause the residents getting in and out of our homes, the noise and the lighting. That's what I have.
Just a couple of follow-ups. You're not opposed to any commercial development in the area. You understand there would be commercial development on that lot.
Absolutely.
And could you give the magistrate an idea of what you think would be a reasonable commercial development within this lot?
When all the homeowners in there purchased, we were under the impression it was going to be mixed use.
Not a single large
facility, mixed use. So maybe there's a barber shop, maybe there's for the ladies to get their nails done, maybe there's an insurance agent or something there. And the traffic patterns on those types of businesses are clearly not going to run from 7 a.m. to 10 p.m. at night. And the volume's not going to be near as heavy 3 times a day for all the meals throughout the day.
And I know you've mentioned the CCRs. You understand the magistrate doesn't have any authority to enforce CCRs.
Absolutely understand that.
Just want to make her aware of them. Is that correct?
And just for the record, I don't think we ever stated what CCR stands for. I do know what that is, but if you could state for the record what that means.
Covenants, conditions, and restrictions.
Yes.
Thank you.
Thank you. That's all I have. I tendered.
All right, let's see if Mr. Tatum has
Okay.
questions.
Okay, Mr. Webster, what do you do for a living?
I'm retired.
What did you do for a living?
I worked in the oil and gas business in Houston.
Okay. In the oil and gas business in Houston, what was your primary responsibility?
I was VP of Sales and Marketing.
All right. So it's safe to say you have no expertise or familiarity at all with land use planning?
Other than what I've learned going through this process.
With traffic counts?
Correct.
Even with semi-truck trailer turning?
Drove them before when I worked for UPS.
Okay, so you got a little bit there.
Yeah.
Are you aware of what kind of trucks generally deliver to a Sunliner Diner establishment?
Not a Sunliner Diner.
Okay, all right. You mentioned that the code is in place. This was one of the first things you said. The code promotes the health, safety, and welfare of the public. Is that what you read?
I think the code says residents.
Okay, of the residents. All right. So the code itself, this is my understanding of it, and tell me if you agree or not. The code itself is designed to promote the health, safety, and welfare of the residents.
That's what it reads.
So the language of the code is intended to do that.
That's the way I interpret that.
Okay, all right. You also, I'm assuming, but I'll let you answer this. Do you have any experience as far as outdoor lighting design?
No, sir.
Okay. And you have reviewed our lighting plan?
I have.
And did that lighting plan show any lights leaving the property?
On a rendering, I can't answer that question.
All right. We'll get someone else up here who can. Another question, you brought up the gate. Who installed that gate?
That's D.R. Horton when they were in control of the HOA before they transitioned it to the homeowners.
Okay, all right. And when you purchased there, knowing there was a gate there, were you aware that there was going to be a 20,000 square foot commercial building of some sort on the commercial lot?
We knew there was supposed to be a 20,000 square foot mixed use businesses.
Okay, you keep using the word mixed use. Well, let's clarify. What do you mean by mixed use?
We would take that as a larger building with smaller businesses in it.
Okay. So not a planning perspective, mixed use, the use of the word as planners use it. I have a question about this picture.
Mm-hmm.
Who created that picture?
If Barbara.
So you just answered the question.
It was done by somebody else in the community, an aerial photo.
Well, who was it that created it?
I believe it was TK.
No.
TK? I'm not sure.
Was South Walton Community Council involved with the creation of that picture?
No.
Okay, all right. To your knowledge, the cars you see located on that picture, do they exist?
There are some of them that are actual, and there are others that were put in and mocked up.
Okay. Which ones are actual and which ones are mocked up? Can you tell?
I can't answer that
Okay,
question.
all right. So you know there's no scale to that drawing, correct?
Correct.
Okay, all right. You stated that when you're at the intersection going on to 30A and you're leaving Blue Water Landing, that you can only see 40 to 50 yards in either direction. What are you basing that on?
My actual sight of sitting in my car and taking a picture.
So have you ever gotten out and actually walked it with the wheel you mentioned that you had?
No.
Okay, all right. And what's the speed on 30A in that area?
I believe it's 25 or
Okay.
30.
I've been 25, you're correct. I was out there yesterday and looked that up. Okay, you've answered all my questions. Thank you.
All right, Ms. Davis? Okay, thank you. Any redirect? All right, thank you so much for helping us out.
Lastly, I'd call Chance Powell.
Okay. Welcome, Mr. Powell.
Thank you.
If you would, please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And if you state and spell your name for the record.
Chance Powell, CHANCE POWELL.
Thank you. Mr. Davis, you may proceed.
Mr. Powell, tell the hearing officer or magistrate what you do for a living.
Currently employed as a county engineer for Walton County.
How long have you been employed with Walton County?
Almost 11 years.
And what roles have you filled as an employee of Walton County?
Was hired at Walton County as a traffic operations engineer and took the county engineer position almost 2 years ago.
And as a traffic engineer, tell us what your general responsibilities were.
As traffic engineer for Walton County, maintenance and control of traffic signals throughout the county, retiming, coordination with DOT on transportation facilities within the county, and some overview of private development work with respect to traffic concurrency, but most of that was farmed out to consultants who work for the planning department.
That's fine.
And how many years were you in that position?
I guess it'd be 9.
Thank you.
And currently as a county engineer, what are your general job responsibilities?
Management of the engineering department of Walton County, which we have engineers that review private development projects for the planning department. We also oversee capital improvement projects, maintenance projects throughout the county, and provide services to all departments within the county.
And Mr. Powell, are you familiar with the area that this particular development order request is being made?
Yes.
And can you tell the magistrate which side of the road, it's probably obvious from the picture, but I just want to make a record, which side of the road the bike path or walking path is located on?
It's on the left side in that picture.
It would be adjacent to the property, is that correct?
Adjacent to the
Property being considered for this
that's
restaurant.
correct. Yes.
Are there any pedestrian facilities on the other side of the road?
At this time, no.
Are there any plans for any at this time?
Yes.
When would those plans come to fruition?
That has not been determined at this time.
Okay. Is there any current funding for that today?
Not that I'm aware of.
Okay. Is there any plans for any crosswalks between, let's say, the village, the village and the Gaffney Art Gallery and the curve? Is there any plans for crosswalks in that area?
Not at this time, no.
And why is that?
I will say that it is our intent to build a sidewalk on the opposite side of the road to direct pedestrians to safe crosswalk locations that currently exist, I believe at Triggerfish, which is south of this development, and as you said, the Justin Art, what's his name again?
Gaffrey
Art Facility, yeah.
And how far is it from this curve?
I don't know that exact number.
So is it fair to say, or fair to characterize that testimony, that there will not be crosswalks if there's ever a sidewalk built on the north side of the road? Would there ever be crosswalks in the immediate vicinity of this project?
I won't say that there will never be one. I guess there could be one based on a specific design and how it was implemented. Say if it was done with like an RRFB, which stands for Rapid Rectangular Flashing Beacon, like a pedestrian push-button type facility. That might be permitted, but I would not encourage one to be in that curve. That's what I would say.
Why would you not encourage that to be in a curve?
I just don't feel like it's a place that we would want to encourage people to cross the street.
Thank you. That's all I have, Mr. Hart.
Thank you. Let's see if there's questions from Mr. Tatum or Ms. Davis.
No.
Powell, did your office have an opportunity to review this particular project?
We looked at it from a perspective of right-of-way access, I believe, but we did not look at the specific details of the site, stormwater and that nature. That was all done by, I believe, maybe DRMP.
I don't have any other questions.
Thank you. Any redirect, Mr. Davis? All right, thank you.
Thank you.
Now, right now, allow the public here to comment.
Before I open up the public hearing, does either of the other parties have any rebuttal? Okay. Okay, thank you. All right, I'd like to move on then to open the public hearing on this particular application. I would ask that the public, oh, I'm sorry, Ms. Davis wanted to say something. Go ahead.
Your Honor, when we began this morning, you mentioned about the amendment to the memorandum of understanding between DOA and the county regarding how public comment's going to proceed for someone that is representing an organization. At this point, the signatures have not been done on that amendment. However, it is my understanding that we can stipulate at this point that both parties intend for this to be done. It has been drafted. It has been sent out under DocuSign to be done. So we would ask to implement the opportunity for 10 minutes to be given to somebody that represents an organization or an entity. So they would have the additional time. Now, that would then restrict anyone that is part of that organization to then speak subsequent to that 10-minute representative.
It's my understanding of the county's guideline, which is now being incorporated into the quasi-judicial proceedings that are being conducted by my office instead of the full county commission, that the limitation of 3 minutes per speaker, there's an exception to that for individuals who are representing an organization or association if they are speaking on behalf of the members, some or all of the members of that organization, and that the way it is written, the way it's drafted, then that if the group or organization's representative speaks to the issue, then no other member of the organization's governing body may address the board on that item on the agenda. Okay, so I think I have the same understanding of it that you do. And if there's not an objection from anybody of the parties that we're introducing this practice, okay. All right, so my instruction then to the members of the public is to make your way up to the podium. Please state and spell your name for the record for me. Speak into the microphone. Clerk's office, have we got the kinks worked out in the timer? Okay. Oh, the lights are not working. Okay. Okay. So you're not going to get a yellow caution light at a minute, and then a red light. You're just going to hear the beeper. If you are representing an organization or association, please identify yourself as such when you get here, so we can adjust the time accordingly. All right, come on up. Yes.
I'm part of the Blue Water Landing HOA.
Okay.
I'm the secretary and treasurer. Do I have 10 minutes or 3 minutes?
So I guess now this is the question, because Mr. Davis, when he was presenting the president's testimony, he said that he understood no one else with the HOA would be speaking since the president spoke.
Well, I understand the memorandum, they can speak for 3 minutes.
All right, let me ask if the parties have any objection then to allowing other members of the HOA to speak for 3 minutes, since their president has already presented testimony.
The memorandum, as I read it, says that no member of the organization will be able to testify once the representative of the organization speaks. So that's our position, that he has already conceded his time to his president.
Okay. Ms. Davis, anything you want to say? Do you agree, disagree?
In my reading at this point, that person was offered as a witness as far as an evidentiary portion and was not subject to any kind of time limitation. In my reading, this is regarding public comment section. So since there was nobody that was nominated and spoke for 10 minutes as far as the public comment section, it would be my reading that this gentleman would be allowed to speak for his 3 minutes.
All right, I'm going to err on the side of more public participation than less. I think that's always a good idea. All right, so let's go ahead and let's get your name for me.
My name is Michael Mather, Michael Mather. I'm a resident of Blue Water Landing and a member of the HOA.
All right, Mr. Mather, you may proceed.
Okay, I'd like to address a couple of things. Well, one of the things that was brought up is the fact that this is on a blind curve, and Brad Webster had said that he went and didn't measure off. I did go out to that same place, the stop line, in the evening and with a stopwatch. And from the time you can see headlights starting to come around that curve, and I don't know if they were going the speed limit or not, but I did use several dozen. It was about 4.7 seconds before they were directly in front of me. When you look, you have to look both directions, and you also have the e-bikes, bicycles, and walkers on the path. 4.7 seconds is probably a conservative number because you can see the headlights a lot faster than you can see a car during daylight. I think the safety issue is pretty critical here, especially when you consider the amount of traffic that's going to come through. Another question I have is they say that they have 71, I believe, parking spots for 250-seat restaurant. Assuming you have 25 to 30 workers, that's going to take it down to about 40 parking spots for 250 people. I can't imagine that those cars are going to be able to, that their parking lot's going to facilitate that. They're going to use the parking spots along Jetty Road, which are designed for our overflow, or as Mimo's does, on the road, which is going to further block vision of oncoming traffic. I'd also like to say that in the past, they have made a lot of overtures about how they respect the community. They never gave any notifications to Blue Water Landing of any meetings. They could have done it. They could have posted it on mailboxes, sent out letters, sent out certified letter. Never did anything like that. So they had community meetings, but they excluded us, or at least notification to us. They also did a lighting study. I saw the light from my house. I'm the 7th or 8th house down on the right-hand side, and walked down there and talked to them during their lighting study. Very, very visible to us, and I'm assuming that the houses here, the light's going to shine directly into their windows. The patio, outdoor living space on this house is on that side, so the noise and the light is definitely going to affect them. But I went down there and come to find out that the lighting survey they did was really only for Draper Lake. They weren't really concerned. And the same thing with the noise study. Everything points towards what's happening to Draper Lake, not to our community. Excuse me. Look at my notes real quick. though the hours of the operation is from 7 o'clock to 10 o'clock, assuming people get there a little bit earlier than that and the wait staff cleans the restaurant afterwards, we're really looking at more like 6 to 11, and the music is going to be from 7 a.m. till 10 p.m. And I'd also like to point out that the common use space there, we're planning on putting a pool, and this is going to be very detrimental to our use and enjoyment of our land. Thank you very much.
Thank you. Next, if you can go ahead and make your way up. Hi there.
Hello, John Harrison, John Harrison. I live on Draper Lake, and I'm here representing the Retreat HOA and its board. And the Retreat is a community of 90 non-rental homes located on 30A, bordering Draper Lake, directly behind the subject diner. We share the community's objections to the diner, as it's strikingly out of place on 30A due to its scale, shiny architecture.
Let me interrupt you. Since you are representing the Retreat HOA, did you want to use the 10 minutes or just stick with 3? And I'm sorry, thank you.
I should be able to wrap it up in 3, but I'll take the 10 in case I run over.
Well, that will exclude other members of your HOA who are here from speaking.
That's fine.
Okay. All right.
I'll represent
You may
the
proceed.
community.
Thank you. So he wants to go with 10.
So we object to it. We think it's strikingly out of place due to its scale, shiny architecture, bright lights, the 1950s car that's sitting in the front that we feel is signage or at least hardscape, and the continuous music. We think it directly undermines the very intention of the scenic corridor, and it's fundamentally incompatible with the surrounding architecture and culture. And it ultimately diminishes what makes 30A special to the residents and the tourists. And I'd like to address our objection to the amplified sound. The proposed project's continuous amplified sound is in violation of the negotiated development order. This development order was negotiated between Walton County, our community, and D.R. Horton, which was a land seller. It took over 2 years to finalize and involved over 27 residential communities. And Provision 8 of the development order has a prohibition against amplified sound. It was a major point in negotiations, and the Sunliner Diner proposal to play amplified sound from 7 a.m. to 10 p.m. on a continuous loop violates this requirement. The DO language is not perfect, but the amplified sound is exactly what the prohibition in the development order was addressing. Due to the echoing effects on Draper Lake, this amplified music will be clearly heard all across Draper Lake and could possibly be heard on the beach and really disturbs the quality of life. Given the project's what we feel is terrible incompatibility with the local community, we feel that this is a watershed moment on whether the character and quality of life along 30A will be maintained or altered for the worse. Thus, our community requests you uphold the Technical Review Committee's conclusion on its incompatibility and the Planning Commissioner's recommendation that this project be denied.
Thank you, Mr. Harrison. Next, and make your way up. I don't have a list to call people from, so don't be shy.
My name is Francine Healy. It's FranCineHealy.
Thank you. Welcome.
Thank you. I'm representing Old Florida Beach Homeowners Association. I'm the president there, and our opposition to this particular development. Old Florida Beach, excuse me? No, I'm not, actually. Okay. I won't go that one. Okay. So we are right across from the retreat, so we're somewhat Gulf front, 66 lots, and also we have lots adjacent to Draper Lake. And even though I'm not a Gulf front owner or adjacent to the lake, when Local Catch, which is a restaurant in that same area, I think within a half mile of the proposed development, when they do have bands, we can hear it in our house. The sound carries on Draper Lake. It's quite effective at amplifying sound. And so the thought of having 50s style music that constant in the day, every day, because it'll be some kind of loop. I don't, you know, I imagine that'll be quite disturbing to a number of people in the area. Walton County calls 30A a serene and scenic area. In Santa Rosa Beach, the neighborhood in particular, they describe as giving private island vibes. And so if you look at what is being proposed in terms of the size and character of this diner, I don't know, I mean, I'm not sure what private island that would ever fit on. But I am also concerned about the amount of food waste and general waste that size of a restaurant would generate. There's a restaurant nearby and they are a seafood restaurant, but the smells of that are constant. And on a warm day, you wouldn't want to pass by. I don't know how they'd be able to contain the amount of waste that's going on in that area in a way that does not impact, that it butts up against the conservation area there. If we allow something that, of this scale and character to go through, our concerns are about the noise and the light pollution, the safety of those that are enjoying Timpucci Trail. I mean, I think you could hear a lot more about that. And the waste that comes with running such a large-scale restaurant steps away from a treasured coastal dune lake. You know, one of 15 or 16 in the world. So I think it would stay in the character and quality of life for those who are visiting or residing on 38. Thank you.
Thank you. Hi there.
Good afternoon.
Good afternoon.
Sorry. I will take 3 minutes.
Go ahead.
Okay. Judy Jacobs, Judie Jacobs.
Thank you. Welcome, Ms. Jacobs.
Thank you. And thank you for the opportunity. You're honored to be here. I'm president of the Ventana Dunes Association. Sorry, by the Ragweed Tears. And we represent, I want to say about 70 homes. If I had to guess, I also live in Atlanta, so I'm here part-time. Very familiar with D.R. Horton and was involved with that project many years ago as well. I have a few things to say, okay? So my son is now 20, and when he was 2, we used to walk around Draper Lake. And I have pictures of like photo albums, and nothing really was there, just that lake between Draper Lake and Lake Stallworth on the west side of 30A. They're my favorite lakes, and as she just mentioned, they're beautiful. That's why I left Atlanta to come here part-time of the year. That'll be gone. It will be gone. The noise, I can sit on my front porch. I hear Redfish Tacos bands every night that they have bands. Whoever it is, we hear it. Talk to Jack McTighe of is the McTighe's restaurant. I'm sorry, I'm a little nervous. I'm very emotional.
Take a deep breath.
I know, I'm trying. Spoke to him the other night. My husband and I went there for lunch and told him about it. He said to me, I thought that it was a done deal, the Sunliner Diner. I said, no, sir, it's not. I asked him to come here and join me today. He had to go to town. I don't know. I mean, I don't know if they live in this area, but safety. I think there's been, since I've owned here, 2 or 3 deaths. And they were, one lady was on a bike, and it was right outside of Triggerfish Street. I'll never forget it. It was very sad. Another guy was on a motorcycle going across Stripper Lake Bridge. And there was a little memorial there with him for a long time, and I think it's gone now. Nobody really has talked about golf carts, okay? There will be people walking, that is true, I think somebody all mentioned, but there are so many golf carts, so many. And I have a golf cart, I'm not opposed to them, I'm gonna keep my golf cart, and they're going down that road, 30A. A lot of times they don't pull over. They put in now signs where they can get off the sidewalk and pull over. A lot of times they don't. So they will be pulling into this establishment. They'll have walkers, you'll have bikers, you'll have moms with the baby strollers trying to get by. In my neighborhood, directly across in Montana. Okay, I'm up.
Wrap it up.
I'm sorry?
Go ahead and just wrap it up for me.
Okay, I'll wrap up real quick. So safety and quality of life and just overall compatibility. One thing, summing up, one thing somebody mentioned on one of the calls, he said, "You'll love it. It will look like it will look like Las Vegas." So I just don't want it. My community doesn't want it, and I'm sorry, but thank you for your time.
Thank you, Ms. Jacobs. Welcome back.
We'll try this again before I turn into a Snickers commercial. It's coming. So I want to...
Your name again for the record.
Nikki Nickerson. I am a resident of Draper Lake. I am not speaking for Draper Lake. So I want to address the numbers being presented. I feel the impact is being greatly understated on behalf of Sunliner Diner. So this proposal is a 10,000 square foot diner with 200 seats on paper and only 71 parking spaces. That footprint will actually support over 300 seats, not 200. And with that scale, we are looking at 3,000 or more guests daily with nowhere to park via one access point that's shared with a residential neighborhood. A restaurant of this size will need over 110 employees. The employees alone will nearly consume the parking lot before a single guest arrives. That's not speculation, it's what I've lived. At my former restaurant, Blue Mabel, we operated a 4,200 square foot space with 142 seats and 52 parking spaces. Even at half the size of this project, our customers were spilled onto both sides of 30A, into the neighboring businesses, which are all commercial around me, and at capacity every day with only lunch and dinner service. Staffing. So at Blue Mabel, 45% of my payroll were J1 contract workers from overseas. That meant constant turnover, housing pressure, transportation issues, and neighborhood strain. So the reality today is every restaurant on 30A is depending on this transient labor to survive, to operate. You can go down to 30A after this and go to lunch and you'll see it for yourself. All high school workers are already hired. Every person able to work is already working. So the impact of having this influx of over 50 transient workers entering our community every single day is significant. Logistically, there is one 22-foot entry off Jetty Road, shared with the residential neighborhood. So every day for 3,000 guests, breakfast, lunch, and dinner, every single day, there will be U.S. food trucks, Cisco trucks, Performance Food Group trucks, produce trucks, linen trucks, every truck that needs to service this restaurant. They're not going to be able to park these 18-wheelers like they do at my place currently. They park right on 30A. They're not going to park that. They're not going to be able to park that way at Sunliner Diner. There's a bike path, and then across the street, they're not going to be bringing all that product across the street. They're not going to be able to park on the bike path. So this 18-wheeler is swinging into the neighborhood in order to deliver goods. In less than a month, over 3,000 residents signed a petition in opposition of this diner. 3,000 residents in a period of 3 weeks, because we didn't know that this was coming. We didn't know, we thought, oh, a new restaurant, great, we would love a new restaurant. So the real picture is this: over 300 seats, 3,000 people a day, freight trucks choking a residential road. This is not small neighborhood.
Okay, just
This
wrap
is
it up
Las
for me.
Vegas style. Oh, I got 35 more seconds. Anyway, I'm not impartial. Thank you.
Thank you. Right, so when the beeper goes off, I'm asking the clerk's office, that means the 3 minutes is up? Oh, 35 seconds, you mean, okay, all right. Sorry. I just want to make sure I know what's going on up there. Welcome.
Hi. Is it this one?
Either one.
Okay. My name is Mark Dotson. That's M-A-R-K, D as in Dallas, O-T-S-O-N.
Thank you, Mr. Dotson, welcome.
I represent myself. I've lived in the area for about 7 years. A lot of people since we've lived here have moved here. The school district is very good, and it's a good environment. That's why a lot of families are living here now. A lot of children have moved in the area. Last year alone, my grandson was nearly hit 3 times in front of the Pines waiting for the bus. Lights on, arm out, almost to the bus, car through. I saw that myself. I called the sheriff's department to try to increase some sort of presence in the morning. I was told they don't have resources for that. Pretty disparaging. In the inherent nature of this business being a morning rush, lunch rush, dinner rush, you can only imagine in the morning what that's going to do. And I know there's experts with the traffic counts and whatnot, but I'm using this on practical knowledge of what I've seen every day. Further, I'm also an avid cyclist. I get about 200 miles in still at my age a week. And, you know, if you really want to know what's going on, if you're there every morning at that time, when you see beach vendors, when you see school buses, when you see just people going to work and whatnot, at that hour in the morning, the numbers and the rubric and all that, it all sounds interesting. But truly, unless you see it yourself, and the kids out there waiting and stuff, you have to really wonder to yourself, what is this going to do on that curve? I think it's a lot more dangerous than people with all the numbers and things. I think it's a lot more dangerous than people really think. So anyway, with that, I appreciate the opportunity. Wow, I got a whole minute. I beat you, Nikki.
Thank you, Mr. Dotson. Next. Well, it's afternoon now, but thank you.
Yeah, it is. Sorry, we're going into lunchtime. My name is Scott Kaminsky.
All right, Scott, spell the last name for me.
K-A-M-I-N-S-K-I.
Thank you and welcome.
I'm a full-time resident of Draper Lake Coastal Village. I am on the board of directors. I represent the homeowners and their opposition to this development. Draper Lake's a 28...
So you're requesting 10 minutes?
No.
No?
Draper Lake is a 28-acre dune lake, which is adjacent to the proposed location. The Sunliner Diner proposes to build a 10,000 square foot restaurant with music playing outside and will have a serious negative effect on the quality of life for both owners and renters in this area. My community has written into its bylaws that homeowners are not permitted to have outdoor speakers. This was enacted because the way sound reverberates over the lake allows it to be heard from a long distance away. It's not uncommon to sometimes hear live music from Redfish Taco, which is a mile away from our community, albeit sporadic, and it's only for a few hours per week. Hearing music all day long, 7 a.m. to 10 p.m., living just over a quarter of a mile away from this will affect the quiet, peaceful lifestyle that we like to have in our area. As you've heard before, there are no current plans or funding from Walton County to change the road pattern, to add more sidewalks, particularly on the north side of 30A, or to install yellow flashing pedestrian crosswalks. That, in my opinion, without those in the plans, provide both vehicular and pedestrian accidents to be more likely to occur. The diner doesn't have a dedicated entrance of its own, and it shares with the Blue Water Landing. With this increase in diner traffic entering and exiting this future choke point, all east and westbound travelers on 30A will be affected by this increased traffic. I'm concerned the drivers will be forced into making hasty decisions, turning onto or off of 30A. We've all pushed our luck. We get up to this stop sign and we say, can I turn before that car hits me? The lighting of this facility will impact the population of the wild animals that we share our facilities with: black bear, wild boar, deer, fox, coyotes, bobcats, eagle, just to name a few. These are just a few of the negative effects that I foresee. We have a chance to keep our neighborhood beautiful, and we'll continue to fight until we stop this bill from moving forward. Thank you.
Thank you. Welcome.
Thank you, Your Honor. My name is Lee Moore, Leighmoore, and I'm the Executive Director of Scenic Walton. We are a 501c3 nonprofit organization, community-based, and I would like to request the 10 minutes.
Any objection? Okay, you may proceed.
Okay, so just for context, our mission is to preserve and protect and enhance the scenic beauty and quality of life in Walton County, throughout Walton County, and we do that through pursuing safety and beautification projects and promoting excellent development design standards and the use and implementation of them. So our board is concerned that the project will have negative impact on the quality of life and the property values, actually, of the people in the surrounding area of this proposed development, and that the project does not fit in with the neighborhood. So I'm not going to go through all of those. Most of those specifics have been, so in the interest of brevity, all the things you've already heard today from others. And it's just really, in general, a safety issue, a fit issue, and an aesthetics issue for us. And our goal has been in this particular situation to urge the applicant to make changes to the proposed project to improve that fit and to eliminate or minimize those negative impacts. So I attended all 3 community meetings prior to this going through the county meeting process and spoke at those. And I just want to take a step back and talk about this from a little bit of a common sense perspective versus technicalities of planning and code. I served on the design review board for Walton County for 10 years. We heard projects from an aesthetic perspective for 98 and 331 south of the Bay. And this project would not meet those standards in the scenic corridor guidelines for that corridor from different perspectives: building materials, exterior lighting, signage at a minimum. And one quick point about the signage. I know that they will have to come back for administrative approval of the signage, but that signage, when you look at the building, there are architectural elements of that building that work in concert with those signs. So when they come back, we got to the point at the DRB where we needed to see the signage and the project at the same time, because it's hard to look at that afterwards in many cases. But that is definitely the case for this project. So I see challenges ahead for that. But honestly, this project is a better fit as it is presented now for US 98. And the fact that it wouldn't, this is the common sense thing, the fact that it wouldn't meet those standards. We're trying to put it on 30A, which is not a commercial corridor like 98, but a beach highway and surrounded by neighborhoods. So I just, in close proximity. So it's just an interesting point. When I attended those community meetings, requests were made by me and others to decrease, and you've heard them today, decrease the size of the building, change the architecture to make it more of a subtle beach coastal aesthetic, minimize the lighting and the signage as well, and eliminate the display vehicle and the outdoor music. Just almost like a courtesy with the outdoor music part. You can talk about planning and noise studies and all that, but the only change that came out of that I'm aware of was the change to the building color, which I did suggest and appreciated that. It did help, but it's not nearly enough. Someone mentioned that the applicant said they wanted to bring Vegas to 30A, and that's just, I don't know if there are very many people at all out there that are impacted by this in any way that would want that. It's highly out of character with all of 30A, in my opinion, and the board's, but also seriously out of character with this particular setting in this neighborhood with so much residential right around it. It's just, and from another common sense perspective, there's been a lot said about the details of the code, but just from a common sense perspective, the zoning is small neighborhood. This is not small, nor is it neighborhood oriented, as far as all of the factors that I've mentioned already. So we just have great concerns about it. Not to say that we don't want the development to happen. We just feel like there are significant changes that need to be made for it to fit and to not have a tremendously negative impact on those around it in this particular location. Council earlier was talking about the definition of compatibility, and they brought up that it not have a negative impact over time on what surrounds it, any development. And that's where I think this one really is having, there's difficulty in reconciling it. So in summary, it's late in this process, but we continue to urge, I guess, the applicant, although they haven't been willing to do it thus far, the applicant to make these changes and be open to it, or someone to actually require it of them so that this does fit and it's not destroying neighborhood character for all these property owners and others who enjoy this area and this quality of life. Thank you very much.
Thank you. Welcome.
Good afternoon. I'm John Disharoon, Disharoon. I'm a homeowner in Highland Parks, directly across the street from the development. I also am president of our HOA association. Highland Parks is comprised of 165 homes.
So are you requesting 10 minutes?
No, I'll just take 3.
Okay.
Or less. 165 homes, 170 lots. We share on this map here, this is our driveway. We're directly across the street. As our neighborhood is exiting onto 30A during busy times, it's difficult to get out of the neighborhood as it is today. Everybody's talked about safety this morning. I will remind you that when Highland Parks was developed, they actually requested a crosswalk, and the county denied it because it was too close to the dangerous curve. The engineer just spoke a few minutes ago about how he would not approve a crosswalk in that area now. It really is a safety concern about this development and the amount of traffic that it's going to generate. From a commercial property perspective, we have a commercial property right here, right at the edge of our development, the old Draper J building. That's about 12,000 square feet. When I built my home 6 years ago, that had a law office, a nail salon, a barber shop, a title company, and a handyman shop, mixed use. 10 or 15 cars came in every day, parked. 10 or 15 clients came in daily. No problem at all. That was recently sold to a church. It's now an administrative office for a church, so a 12,000 square foot building that is going to hold 7 administrators and a radio station with 2 engineers and a DJ. That's neighborhood compatibility. That's a 12,000 square foot commercial building in a neighborhood that you don't even realize is there, as opposed to the amount of traffic that's going to be generated across the road on a dangerous curve as defined by Walton County. Our concern is about safety and neighborhood compatibility. We oppose this project and War Eagle.
Thank you. All right, next. Anyone else wishing to speak? Come on up.
Yes, definitely. Good afternoon, Your Honor. My name is Barbara Morano. I am on the board of South Walton Community Council, which is a 501c3 organization, and I am definitely asking for 10 minutes.
Okay, if you would spell your last name for me.
Sure, it's Morano.
All right, I got it right. Thank you.
All right. Your Honor, I believe a picture is worth 1,000 words. So we're going to turn this video on, Cora, and you're going to see some traffic. The traffic was not edited. You can see that happening. You're going to zoom down. You probably will see that would be Jetty Road. And then you're going to see the bicycle people right there. That's not edited. More cars coming. You see a car actually pulling a low-speed vehicle that got stuck probably on 30A. See another Jeep coming, cars, and across the street is Highland Park. To the left of that, thank you, Cora, was the Blue Water Landing. Did you need to see that again?
I do not.
Okay,
Got it.
thank you. Your Honor, 31 families bought into this at a price point of $1.5 million. They did their due diligence. They knew it was going to be at least or minimum of 20,000, up to 20,000 square feet. And they knew it was going to be a small neighborhood with mixture of uses. The applicant is making you think that that was never said to them, and it was. I also am affected by this personally. I live in Draper Lake. I was involved in the 3 neighborhood meetings. I was also at the 2021 meeting when we got the 186 homes down to 31. I know David Smith, an honorable man. We worked together. David Smith asked me to help facilitate the 3 neighborhood meetings. I assume Blue Water Landing was still under D.R. Horton's organization. They didn't make it, but I put the responsibility on the developer and on David Smith because they did not reach out to Blue Water Landing at all at any of our 3 meetings. And it was never revealed that they were part of an HOA. Not at one time at any of those meetings did the applicant from Blue Water Landing, when they bought the property in February, and I think they just bought the property just before Blue Water Landing handed it over to the neighborhood. So even the neighborhood didn't understand that it was sold to the diner. They're not being completely honest because this building is going to be open from 7 o'clock in the morning to 11 o'clock at night, as opposed to up to a 20,000 mixed use, which will not be open from 7 to 11, which would have a different mixture of uses and not 7 days a week. The music is not tolerable. At the Planning Commission, and I can't cross-examine the attorney, but Philip Tatum stated that the music would be heard in the pool area. He stated that. Can you imagine owning a home and then going to your pool and listening to 50s music? I can't. I can't imagine that one. The former planning director, his name was Matt Carpenter, at the first TRC meeting, the planning director said, the Sunliner Diner is looking like a spaceship that has landed on 30A. Your Honor, I'd like to show you 2 more. This is Pigeon Forge, and this is the Sunliner Diner, but I'm showing you that these are arterial roads. They're large roads. They're not 30A, they're not connector roads, they're huge. There is not a neighborhood around this. Their other project is in Gulf Shores. Again, not in a neighborhood. When you look at where this is, (150 feet, Blue Water Landing. That's just, it just can't happen. And if you see Sunliner Diner and Gulf Shores, you'll see a cemetery. You'll see other areas. They are not affected. I'd like to read some key points, Your Honor, very quickly. Parking and traffic. There's no overflow plan for this diner. They're going to be parking in the common area right there by Blue Water Landing and on 30A. The diner of that size is going to overwhelm 30A. And the comp plan is already called 30A as a contained road. You know, the applicant makes it sound like, oh, we conserved all this land. It's not that applicant. It was D.R. Horton that did that. The scale, the small neighborhood zoning was meant for corner stores, walk-up cafes, medical facilities. We need those kinds of facilities. In Ms. Ekblat's report, she says, the proposed development will complete the planned mixed-use community at Blue Water Landing, providing needed commercial services. Yes, Blue Water Landing does need commercial services, but not a single-use 10,000 square foot restaurant that people can get breakfast, lunch, and dinner in their own home. They need medical facilities, dental facilities, any other kind of thing that would help them, but not commercial services of a diner. Workforce was mentioned by Ms. Nicky, and then you have environmental, and you have compatibility. And there's no precedent for a 10,000 square foot diner in Blue Mountain. This would be the largest restaurant, small neighborhood, on 30A in South Walton. They mentioned Shunk Gully and they mentioned Old Florida Fish House. They are on commercial property. So, Your Honor, I just want to mention something else which I find interesting. When our Walton County attorney explained the magistrate process before we started to the commissioners, one of his persuasive arguments was that if the code had issues, he said to the commissioners, quote unquote, be prepared, board, you will find some things to clean up. Well, this project is a good example, Your Honor, of some things that need to clean up. This is a small neighborhood. The code is not clear. Stephen Schoen has the director's determination. Every point of that is showing the code is not clear. We are asking that you deny this project based on all the reasons you have heard, based on the quality of life for the people not only who live on 30A, you heard from the presidents, but from the 31 homes that bought into a development, their quality of life. I don't want to see those homes for sale. I don't want to see them calling code because of traffic issues or noise in their house. Everyone, you know, a home is a man's castle, and that is what we need to keep established. This is an outlier, and that word was used by Stephen Schoen in his director's determination. I'm not talking compatibility, but it's an outlier, and I think that in of itself does not need any explanation. I just want to end, Your Honor, by saying, if I could find my notes, everybody spoke so well, that the code is the conflict. The LDC is failing the community, especially the community of Blue Water Landing. The Sunliner Diner is a 200+ seated restaurant that will pull diners from Okaloosa County, Walton County, and Bay County. And why will it pull it? Because it will be very successful. This is a 50s themed restaurant. You're going to have waitresses with the same color lipstick. They're going to be wearing their uniforms. You're going to have a car outside. It's going to attract teenagers because there's a curfew already in some of the communities. They'll be meeting there. They'll have car rallies. Could you imagine that? This is a draw. This is an event center. And as Mr. Harrison said, we determined in 2021 that there would be no music and no outdoor entertainment. But the applicant is determined to keep his music on from 7 to 11 because he wants outdoor entertainment for the people who are going to be waiting to get into that diner. This is just not acceptable, Your Honor. So Sunliner is an outlier to the small neighborhood zoning district. It should be denied, and then let the commissioners do their job to clean up the code, because the code is not clear, and we need to change that. And that was one of the reasons why I stood up at the podium at the commissioner's office and said, let's do this magistrate. Let's get the code in order, because we've had too many issues through the years. So thank you.
Thank you, Ms. Morano. Anyone else? Okay. All right, then we'll close the public hearing on the Sunliner Diner application. Do either of the parties or any of the parties want to put on any rebuttal evidence?
Your Honor, we have just a couple of things we want to run by you.
Okay. Welcome back, Ms. Ekblad.
Thank you.
I'll just remind you that you remain under oath.
Correct. And I will try to be brief. I do have some notes to keep my comments streamlined, but if I pause, it's because I'm trying to dig something up in the Land Development Code. So first and foremost, I want to focus on what Land Development Code Section 218, which is the Small Neighborhood Zoning District, actually says. The black words on the white page say, each small neighborhood shall provide for a mixture of uses. And that mixture is to encourage economic diversity and sustainability, promote the future viability of the neighborhood, and encourage a walking and bicycle friendly design. This project is a phase 2. It is a piece of a larger development order that does provide a mix of uses. We talked about that, residential and commercial at the baseline land use categories. And then because that previous development order and the current use fall within the neighborhood commercial uses, we are subject to Section G. And I've heard some summaries of this section, so I want to actually read what it says. First and foremost, the special development standards in Section G state, mixed-use, small neighborhood projects shall submit a detailed plan. The Blue Water Landing development project did exactly that. And as we discussed, this parcel was created by the Blue Water Landing plat. And then the second item is that the small neighborhood project shall be pedestrian in scale and shall facilitate and encourage pedestrian use. Again, that larger Blue Water Landing development project with the mix of uses is pedestrian in scale, and it does facilitate and encourage pedestrian use. You heard in the case in chief how we've added to that. The existing sidewalks occur on Jetty Lane. We have an interconnection to that, and we have an interconnection to the multi-use path along County Road 30A. I also want to note that when we talk about walkability, we cannot forget that the existing 31 residential units can walk to this site should they desire, in addition to the surrounding residential communities. There is not a limitation regarding the square footage of the use in the Land Development Code. The proposal meets the required 5% of commercial for the small neighborhood zoning district, the 0.5 FAR, as well as the ISR. Those are the only limitations outlined in the LDC, and we are consistent with that. As I mentioned, the project is pedestrian in scale. We are facilitating connections to that existing infrastructure. And when we look at the 30A scenic corridor, it does have specific design requirements outlined in Land Development Code 6100, which I discussed in the case in chief, relate more towards site design than they do building architecture. You also heard during some of the cross-examination regarding the director's determination that there is a mix of architecture in this area. I included photographs of the existing commercial that occurs along this portion of 30A. There is not a consistent theme. In one location, we have a purple building. So, you know, when we talk about theme, we need to be consistent here, and unfortunately, there isn't a standard that exists within this location. The project was elevated to the major development order process due to its impact on public facilities and roadways. You've heard the testimony from the engineers, and you have the memorandum demonstrating those actual impacts and the reduction associated with the request today. And then the last two items of note that we heard from the community were the lighting. The county's Exhibit 1 includes a photometric plan that demonstrates 0-foot candles at the commercial lot boundary. LDC Section 590 outlines the lighting requirements, and that includes a provision that the building and landscape lighting must be shielded so that direct illumination is focused exclusively on the building facades and plantings and away from adjoining properties. I also want to note that our rear facade is adjacent to a 22-acre mature vegetation conservation area that would filter any light that were to come off the building as well. And the same is true for noise. The county's Exhibit 1 includes the site speaker layout and the associated decibel levels as it relates to the property boundaries. And we agree with the county's interpretation that the condition from the existing development order will apply to this project. If you were to look for that, it would be Condition E in the final order and existing development order for Blue Water Landing. That, I believe, concludes all the comments that were made. I'm happy to answer any questions. Oh, you want David?
I do not have questions for you, no. Ms. Davis, do you have questions for the witness? Mr. Davis.
I want to be brief about this. The code does not have within the actual language of the code an actual definition for pedestrian scale. Is that correct?
I believe that's accurate.
Thank you.
Thank you.
I'm going to have David Smith come back up for just a couple of questions from him as well.
Okay.
David, if you could, we didn't elaborate on this, but the letter from Dewberry from February 26, 2020, I believe it was.
For the record, I just want to remind Mr. Smith he remains under oath. Go ahead.
The letter I'm referring to, I believe, is Applicant's Exhibit, might have been D, but this is the, C. Applicant's Exhibit C, the initial engineering review letter that discusses only one entrance. Could you explain to us why there was only one entrance allowed?
That is due to the curve that you've heard several times. And the reason that the curve is there is because of the coastal dune lake, Draper Lake. So County Road 38 does meander around the coastal dune lakes. They're very rare as was presented. But the reason that Public Works made this comment to consolidate the entrances is due to the safety of the curve and to align the roadway up with the exit or entrance to Highland Park, which is across the street, because having the roadways aligned is a safer operational location than having them offset. So that was the reason for that comment.
Thank you. Also, if you could comment on why the size of the commercial space changed so much between the initial design and what we have today.
And if I can, I'm going to go back to this exhibit.
Okay.
This was the original application in February of 2020. And as I mentioned earlier, this was a planned unit development. The commercial phase 3 on that application was 0.61 acres and 6,000 square feet. That was a requested deviation at that time. As I mentioned, this was very controversial. We've had, back at that time, probably over 20 community meetings, different meetings to discuss. And the theme from the residents was follow the code, no deviations. And it was said at many of the meetings, including the county meetings, follow the code, no deviations. So the developer, my client at that time, D.R. Horton, chose to withdraw the application. And what they did is they submitted a plan, no deviations. The plan followed the code. This was what was reviewed as a development order, not a PUD, and ultimately approved. And this is the approved master plan that's before you today.
All right, thank you. One last thing. The final order from the original approval for Blue Water Landing, it contained a provision or a condition, condition E2, which states no outdoor entertainment as an ancillary use to a commercial business that uses amplified sound, such as stages and amphitheaters. Can you expand on that? Was that part of your negotiations during the development order process?
Yes,
I'm
sir.
going to object at this point. That's regarding a prior development order. That's not something that is at issue currently. That's something to be dealt with in a separate scenario with administrative approval.
Okay, I thought there was testimony earlier, I think elicited from you, Ms. Davis, that the conditions from the previously approved master plan will still apply to this development. So am I missing something?
The conditions for the prior development order will still be in play.
Mm-hmm.
There's nothing that will be changed by the grant or denial of this development order as far as things like the noise and outside amplified music.
So I don't understand your objection then to him getting this witness to tell me what the conditions are that relate to noise.
Outside the relevancy of whether or not this meets the code and the comprehensive plan, because those things are dealt with outside of the bounds of this development order.
And how so? At what level then are they dealt with?
Through the actual application process after this,
The building permit itself? Okay.
I'll withdraw the question.
Okay.
Okay, that said, I think that's all I've got for you.
Okay.
Thank you.
Thank you.
And then just a little bit of a closing from me. We've heard a lot about the sound.
Well, let's, before you close, let me make sure everybody else is ready for that, because if they're going to put on any witnesses, then we might want to get closings at the same time. So, Ms. Davis, are you finished?
Yes.
Okay. All right, Mr. Davis, did you want to? Okay. All right, great. Thank you. Just had to check and make sure we're all on the same page.
All right, thank you. Just real briefly, the compatibility definition in Florida statutes, it says unduly negatively impacted. That is the words that it uses. One use cannot unduly negatively impact the other over time. Unduly is the word that is in play here. This is a project that together on a master plan was approved to have up to 20,000 square feet of commercial use with no condition on what kind of use that commercial use was on this commercial lot. There's, in my mind, no way that you could say that a master plan community that required 20,000 square feet of commercial use next door to the residences in any way unduly negatively impacts one another. There's also, like I stated, there's nothing in the approvals in any of the previous development orders that says there has to be a mix of use in the commercial development side. It doesn't say it has to be a single, or does it have to be 3 or 4 different commercial uses. I would point out that to the extent they were trying to address the Pigeon Forge and Gulf Shores Sunliner Diners, those are the other 2 that exist. That's irrelevant. It's irrelevant to our particular application, and also the design of those is just simply different. It's not something to even get into for our particular purposes today. Again, this use is allowed. The property is already vested with the ability to build up to 20,000 square feet, so the property owner has the right to build that, provided he meets the other conditions of the Land Development Code. You've heard testimony from us and from staff that it meets the requirements of the Land Development Code and Comprehensive Plan. So we just request that you issue a proposed order approving the project with the conditions contained in the proposed order. Thank you.
I do have a question for you, and if you need to bring up a witness to answer my question, great. Is the zoning category itself, the zoning of this property, and requiring mixed use, do they get some sort of credit for internal capture of trips?
I'll let David come answer that question.
I thought that might be a more technical question.
For the record again, David Smith.
Thank you.
Yes, but I do want to point out that on the original approval for Blue Water Landing, internal capture was not claimed between the uses.
Okay.
What's called a pass pod percentage reduction was, and that reduction is called 66% of new trips. What that means is that 34% of the people visiting the shopping center are already driving by the area. So you're not generating it, they're already driving by. But we did not use an internal capture methodology on that original approval. So therefore, on the analysis that was submitted on the diner, we did not use the internal capture as well. And we maintained that same pass by percentage of new trips at 66%.
Okay, thank you.
Thank you.
Any questions from either Ms. Davis or Mr. Davis in light of the question I asked? Okay, thank you. Closing from you, Ms. Davis?
I don't
Only
have
if you
anything
want.
further. I'll defer to
Okay. Mr. Davis?
I will be brief. I understand you've been here a while already this morning. Thank you, and thank you for your patience. Ultimately, the decision, in my opinion, 38 years of practicing law in this county and been a county attorney here for at one point for 4 years, is it comes down to the question about the other conditions in the Land Development Code mentioned by Mr. Tatum. And the one condition I think you should focus on is the question, is this project pedestrian in scale? And you heard from our expert, we've given you factual testimony, I believe, and expert testimony that indeed it's not. And you make that finding, that would be a simple and easy basis to deny this project. There are other bases, and I don't want to spend 20, 30 minutes talking about it, but in the end, as I told commissioners many times when they were hearing quasi-judicial, in the end, you have to be able to point to the code. And we can point to the code. You have expert and factual testimony on that issue alone. You have expert and factual testimony on other issues, but that alone is enough to do what we're asking the court, the officer to do, magistrate to do, and that's to deny this project.
Right. Mr. Davis, before you get away.
Yes, sir. Yes, ma'am.
There were a number of filings that you made in this case yesterday, and I think another one today, on the portal at DOA's docket. And they surprised me, but I guess I shouldn't have been surprised because I don't know that you were familiar with the process that we were working with the county. So because one of those is a motion, I want to make sure it's disposed of. Okay.
Yes, ma'am. I had, and I was not familiar that the county was going to be the record keeper.
Right,
so,
no problem, no problem.
The motion was a simple motion to view.
Right.
Frankly, I couldn't remember and I couldn't find in the DOAH administrative code whether that was even a proper motion, but it is obviously in circuit court or in trial courts in Florida. This particular project, given its location, I personally think a view would be helpful to you to decide the issues we've been talking about today, or help you have at least some understanding of the layout of the area. I have no objection to you doing it on your own without any of the parties or any of the attorneys present. And I have not heard from Mr. Tatum about that.
So, okay, I wasn't, first of all, I wasn't even sure if Mr. Tatum and Ms. Davis were served because I couldn't tell from the way it went on our portal. So I just wanted to ask first if either of them had a response. I hear no objection from Mr. Tatum. What is your response, Ms. Davis?
Your Honor, I have no objection to the filing.
Okay. So I am going to deny the motion.
Yes.
I have granted, it is not an improper motion at DOA in a growth management case. I have been faced with those before, and I actually have granted one before. In this case, I am going to deny the motion.
Thank you, Your Honor.
Thank you. All right, then this concludes the quasi-judicial hearing on the Sunliner Diner application. We need to take a break, and then Ms. Davis, what do you think is reasonable? I know nobody's had a chance to even eat anything, so.
I'd say 15 minutes.
Okay, so let's take 15 minutes. That's gonna have, if y'all could keep it down until I'm finished, please. Please keep it down until I'm finished. We're gonna take 15 minutes, so we're gonna resume, let's say at 1:45, and then Let's get started with the next item on the agenda. All right, I have, the next one is SEC Freeport Hot Mix Asphalt Plant, and the number is MAJ 25000035. All right, if I could have council make their appearances for the record, please.
On behalf of the county.
Gary Shipman on behalf of the applicant, I think, won't do anything else. This Robert is here, who was hired by all that private planning commission. Wants to make a motion to press that before we do anything else.
Okay.
Your Honor, my name's John Roberts again. I represent Protect the Emerald Coast Alliance. Just a very brief kind of Ori Tennis motion to intervene on this one. I was recently brought in after being away in Birmingham for the better part of 2 weeks with a father in the hospital on this one. The real question for us is there is a traffic expert that has been hired by the group that wants to present expert testimony, and then the president of the association wants to present 10 minutes worth, which he'd have a right to either way. Those are the two witnesses that they'd like to put on, one of right and then one based on Your Honor's willingness to hear that evidence. It is simply an Ori Tennis motion to intervene and then the right to cross-examine. One of the threshold issues is going to be standing, and I know Mr. Shipman has mentioned that before, and Ms. Davis, I think, is aware of that issue as well, but it is one that has been brought up in the last 20 minutes, so that's not on them, that's on me to have addressed the standing issue. I'm happy to do that if Your Honor wants to hear.
I'm sorry, you mean who's standing are you talking about?
Standing of the Protect the Emerald Coast Alliance, because the rule says that you have to have not just an injury or a potential public at large injury, you have to have a special injury. These are all homeowners in Hammock Bay who travel that road every single day, and their special injury would be the increase in the lack of safety or the decrease in safety on that particular line and traveling up and down that road. That this property touches that and also has watershed that flows out from there that will touch and concern both Choctawhatchee Bay and also the streams that run through their community.
Okay. Let me hear from council then on the motion to intervene. And I'm while you're coming up, I want to say that so earlier this month, the very first hearing, we actually did have expert witness testimony from the opposition, but we didn't have an attorney for the opposition, and I don't know that they actually intervened or were given intervener status. Ms. Davis?
Your Honor, that would be a correct statement as far as giving intervener status based on what was represented by Mr. Roberts. It would be my reading of case law that would not be sufficient to demonstrate a particularized interest that Protect the Emerald Coast would have in the decision of this process.
Okay. My question was the development order that I conducted the quasi-judicial hearing on, or at the beginning of this month, I guess it was the 8th, we allowed a member of the opposition to present some expert witness testimony. And my question was that they never moved to intervene, though, and I wanted you to set me straight on that.
No, I'm sorry.
That's correct, Your Honor.
Okay.
But they also, in that they were not given the opportunity to cross-examine any witnesses that were presented by the county and the applicant.
Right. Okay. But they did introduce expert witness testimony.
Right.
Okay.
That's correct.
But
okay.
Under the Walton County Land Development Code, which sets forth how a quasi-judicial is to be conducted, there's only two entities that get to present evidence here automatically under the code, and that is the planning department and the applicant. So to present evidence, meaning moving some document into evidence or calling an expert witness, you have to give party status, which means you have to intervene.
Well, my point being that's not what we followed on September 8th. And that's why I was asking the attorney to help me out with that. So I don't know if that was just done by stipulation. Maybe that's what we did.
It
I'm
was
recollecting that. Okay.
because the person that was supposed to be introducing that particular witness was not able to be present.
Right.
So by stipulation of the parties, that expert was
Okay.
allowed.
So that's what we did. The parties just stipulated to them introducing expert witness testimony, but they were not a party, did not intervene, and they could not cross-examine the parties' witnesses. Okay, thank you. Thank you.
And Your Honor, there's actually, I sent a brief to you on this issue.
You did, because you said you would, and then I don't have it. Where was it filed on the docket at DOA? Because I didn't receive anything. Oh, okay, so it's in the portal for this one? Okay,
I can give you a copy. It's not very long with the cases.
okay, great. That would be great, because that would be helpful if I'm gonna have to make this decision right now.
And really, the primary legal authorities that I
Is this three copies? Okay, I don't know, I just need mine. I just need mine, I don't need everybody else's, thank you. I don't want to be responsible for that. Okay.
I don't have it printed. There was 159 that was received yesterday.
That was a bench
This was
memo.
on Tuesday. So there were two separate documents. The other one was 100.
Yeah, that was where we include the exhibits. Judge, but the primary things to look at under tab D, which is Hayden versus Walton County. That was an interesting case. I was actually the loser on that case. It was at a zoning Board of Adjustments hearing and it was quasi-judicial, where a neighbor appealed my client's lot split. And so there they were the applicant. And they objected to me, which I had filed a petition to appear as, to intervene, alleging we had a special interest because it was obviously our property. So we would have a special damage under the Citizens Growth Management Coalition versus West Palm Beach case. And that's the case that sets forth, you gotta have a special damage beyond the general public's interest. So if you're a organization, it's all your members, to be a member, you have to have that same common, whatever that special damage is. And the judge in the All About the Beach versus Hayden case found that no, under Walton County's Land Development Code, which governs how we conduct this, there is no provision that allows for a party to intervene. The parties are strictly the county and the applicant. The DCA, when we appealed it, actually PCA'd it. So I could not find any other appellate decision that has those same sort of factual distinctions where it was a unique quasi-judicial hearing under an adopted code. In fact, curiously, I allege that if the Walton County's ordinance, if that's the way it read, or at least as applied, would be unconstitutional because it was actually my client's property. But the first DCA upheld it and PCA, and the circuit court said, nope, only the applicant and only the county are parties.
All right. Ms. Davis, have you stated your response at this point, or did you want to say something else?
I'm trying to pull up the new ordinance that was implemented regarding these particular types of hearings.
Okay. It's, I have it, if you. Pretty sure it doesn't address this issue, but you can, if you find that it does, please point it out to me.
That's exactly what I was trying to double
Okay.
check and make sure.
There is nothing in it.
With respect, Your Honor, you could also allow the testimony and then during the order period could disregard the testimony as being either irrelevant if you find that it is, or excluded if you find that it is.
Well,
At least we could get it in.
Yeah, I thought about that, but then the issue of cross-examining the other witnesses, though, is something that I think the decision really does need to be made, unless you're going to waive cross-examination.
I could certainly talk to my clients for 2 minutes and ask if they would be willing for me to do that.
Okay, because that would be a way to move it along, where we could just go ahead and take, when I do hear a general growth management case, I actually don't ever rule on the intervener's status if it's contested until after the hearing. And that I am perfectly capable of disregarding testimony that then was offered by someone who did not achieve party status. But I know that the two folks standing next to you are going to want to know that if, that you're going to waive cross-examination, and if that works, then we can just proceed.
I believe I can get 30 seconds and get right back here to this podium.
and Judge, while he's talking, the other item, I'll go ahead and bring it up now rather than when he tries to bring a witness up. If it's a traffic engineer to talk about traffic, Highway 20 is a state-owned and state-maintained and state-controlled road. And the
Mr.
local.
Shipman, I would ask that we wait and allow Robert the opportunity to speak to his client.
Okay.
Before
Okay.
we make these arguments.
My client consents to waiving cross-examination so long as their witness is allowed to at least give his testimony.
Okay.
Then
Hold on. So then, do you want to put on your evidence regarding standing, though, here today at the hearing, or do you want to submit something in writing?
I'd like to submit, please.
Okay, great. Well, that will help us move along as well.
Yes,
I
ma'am.
really appreciate that. Mr. Roberts, how long have you been representing them?
I think I got started about 2.5 weeks ago and went to the hospital with my father the next day.
Oh, goodness.
So-
Okay. All right. Thank you, Mr. Roberts.
the other issue, evidentiary issue, since it's a traffic engineer, Highway 20 is a state-owned, maintained.
Okay. So are you now lodging an objection to the witness that they want to offer? Okay.
Yes,
I need you
ma'am.
to I need you to be a little more straightforward with me.
We object to a traffic engineer because Highway 20 is a state-controlled, state-owned, and state-maintained road. The local government has no authority to approve, disapprove, or dictate anything involving that road. We do have a DOT permit, which will be presented in the evidence. The other thing is, while transportation is listed in our LDC, because until a month or two ago, we had, you utilized it for purposes of calculating a mobility fee and how much it was going to be. The problem is Walton County suspended that because of Senate Bill 180. And so now it's not really used for anything. It's traffic studies in the file, but Walton County has no authority to do anything with it.
So, Mr. Shipman, you're lodging this when I have no context here. So I haven't even had a chance to look at this application yet. So are you planning to introduce in your case in chief as the applicant information on traffic generation, capacity of the roadway in order to meet code requirements?
We will state, and I imagine their planner, I'll probably ask her, we submitted a transportation study per the planning code.
Right.
But is there anything that you can do with it today? And the answer, I believe what you're going to hear, is no, because it was for the purpose of calculating a mobility fee, which the county has suspended because of Senate Bill 180.
Right.
And if we were on a county road, it might be used for determining some sort of improvement they would require. But because we are on a state road, it can't be used for that. So there is, while it's in the file, we did one, there is nothing today that the local government can do with it.
Okay. So this is my answer to your objection. Yes, what's good for the goose is good for the gander. So if there is a requirement for you to meet whatever, if it's the impact fee, if it's something other than the impact fee, right? That you had to conduct transportation analysis for, and you're putting that in, then the intervener is going to get to put that in.
Well,
Okay, that's all I'm trying to
Yeah,
say.
I guess what I'm trying to say, Your Honor, is that at one time it was required and it was done, but today there is nothing. In other words, the county government can't look at it today and say, well, okay, now you got to pay this much money or you got to do this improvement. They suspended it.
I understand that.
So it's not
But
relevant.
there might be other reasons for putting in traffic analysis, and I don't know what they all might be. Ms. Davis, can you help here? Was there a requirement for this development application to submit traffic analysis of any kind for anything other than determining impact fees?
That's what I'm confirming with my staff members.
Okay.
It is something that the county does consider as far as concurrency requirements. So that's what I'm confirming as far as this particular project. If concurrency was an issue, that some kind of traffic generation or other calculation would have had to have been done outside of just the mobility fee context.
Well, let's do this. It would probably be really helpful to me if somebody went ahead and started presenting evidence so that I have the context of what this project is and entails. And then if you want to lodge an objection to their witness, that would help. I would be in a better position to rule on that. Okay? All right, so who's going to go first? The county?
Yes, Your Honor.
Okay.
Your Honor, Brooke Davis on behalf of Walton County. At this time, I would like to call the project manager, Ms. Rosanna Edwards, to the stand.
All right, Ms. Edwards. If you would please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may proceed.
Edwards, can you state your name for the record?
Rosanna Edwards.
And where do you work?
I've worked with the Planning and Development Services for Walton County for the past 9 years.
And at this point, you are the project manager on this particular case, is that correct?
That's correct.
Have you provided expert testimony priorly in a quasi-judicial setting for planning and the Walton County LDC and comp plan?
Yes, I have.
And when I say LDC, I mean the Land Development Code, is that right?
That is correct.
Okay. So you work on a daily basis with the comprehensive plan and the LDC?
Yes, on a daily basis.
And you're often asked to interpret both the comprehensive plan and the LDC, is that correct?
Correct.
And approximately how many projects have you managed for Walton County?
At least several hundred, to say the least, several hundred.
Your Honor, I've spoken to opposing counsel. It's my understanding that they are stipulating that Ms. Edwards is an expert in both planning as well as the Walton County Land Development Code and comprehensive plan.
Okay.
Ms. Edwards, can you
All right, so accepted. Thank you.
Can you take a moment for us and read the blurb that you prepared regarding this particular project?
Absolutely. This is the SEC Freeport. It's a hot mix asphalt plant. It's a request to approve by development order. Project number MAJ 25-000035 was reviewed by myself. This is a major development order application submitted by Baker Engineers LLC on behalf of Highway 20 Properties LLC. They're requesting to develop a hot mix asphalt plant and associated infrastructure on 15.3 plus or minus acres. It has a future land use of industrial and extractive uses in a zoning district of heavy industrial. The property is located in District 1, and it's on the south side of State Highway 20 West, approximately 0.92 miles from the intersection of Site C6 Road and State Highway 20 West.
Okay, so can you take a moment as well and explain the process for how this particular project got to this point in the review?
This process started as most development projects do, with a pre-application meeting. They then moved to technical review committee, and with further review of the comprehensive plan, it was determined that it did require heavy industrial uses and the heavy industrial zoning to be major development orders. It moved to Planning Commission as a major development order, and today we are here.
So if I may for a minute to lead the witness, so this project came in as a minor development, is that right?
That is correct. Under the requirements for a major development order based on intensity.
So this is now a major development in order to be consistent with a comprehensive plan, is that correct?
That is correct.
And why is that?
Certain uses under heavy industrial require that additional layer. So new development in heavy industrial, such as asphalt plants specifically, are required to be reviewed as major development orders.
And let's be clear, as far as this particular site, was this priorly used as an asphalt plant?
Yes, the use has not changed. The developer activity is new. It did cease operation at some point. This would be a new development order, same use.
So we're saying this is not a new use, but a new operation. So that was the trigger to becoming a major development order is under the county regulations. Is that correct?
Yes, that would require a new development order.
Now, to be clear, Planning Commission, what was their recommendation on this?
Recommendation was a recommendation of approval. I think the vote was 5-1 approval.
Okay. So let's talk for a second about conditional use under Walton County regulations. Can you explain to the judge what exactly that entails?
Conditional uses are not primary uses. They require additional review. Their use is allowed within that zoning district with extra layers of approval, if that's the best way to say it.
So there's no expiration to that conditional use once it attaches to a property. Is that a fair statement?
That is a fair statement. The use has not changed. If it was a different use, I would understand getting a new conditional use for a separate use. That's how I interpreted it.
So after the prior asphalt plant ceased operation, nothing new was done on this property?
They're not proposing anything new from what has been previously approved there.
And how long ago did the prior plant cease operation?
I cannot give you an exact date. It was in the sometime in. It's been a couple years, but I don't know the exact date of that.
Okay.
More than 10 years, less than 10 years?
Less than 10 years.
Okay.
Is there anything that you are concerned about in your review of this with this project in terms of the comprehensive plan or the LDC?
There were some concerns with traffic on the roadways. It has met the requirements of the land development code, but there are, of course, always safety issues that we do consider.
And in that consideration, did you have the opportunity to have conversations with the Florida Department of Transportation?
Yeah, so the Florida Department of Transportation did reach out. Their response is they were just monitoring the progress of the development, but staff did ask if there were additional concerns or comments they would like to relay as part of this project, in which they did not have any at this time.
Have you had the opportunity to continue to reevaluate this project even after Planning Commission's deliberations on it?
What do you mean by that?
On whether it's consistent with the LDC and the comprehensive plan?
Yes, we agree, staff agrees that this application continues to be consistent with the comprehensive plan and land development code.
Can I back up for just a second and ask about that DOT thing? Did you receive a call unsolicited from DOT about this project?
It was response as to the progress of the application because they do require state permits through DOT. So.
Oh, okay. So the applicant was also seeking a permit from DOT.
The applicant is required to get a permit from DOT.
Okay. All right. Thank you.
The applicant should be addressing that concern in their case in chief.
Okay. And I was just trying to understand how the DOT came to be in contact with Walton County about the application. Thank you.
So in your professional opinion, do you believe this project meets the regulations of the comprehensive plan and the land development code?
Yes, that is my understanding. It does meet those requirements.
And how did you arrive at that decision?
The zoning of heavy industrial, it has been that zoning. It's had that previous use, and it meets all the requirements in the land development code for compatibility, additional buffering, and a primary use within that zoning category.
And those decisions were based on your training experience within planning and your use with the comprehensive plan and the LDC?
Yes, that is correct.
Did you prepare a staff report for this project?
Yes, I did.
Your Honor, at this time, I'd ask to move the staff report with its inserts and public comments into evidence as County Exhibit 1.
All right. At this time, I am admitting County Exhibit 1, which is the staff report, including, you always refer to them, Ms. Davis, not as exhibits, but as what? What'd you say? What do you call them?
County Exhibit 1. It's, yeah.
The staff report has
the inserts.
Inserts. Thank you. Thank you. Thank you.
That's an acquired. That's what the county here calls them,
Right.
is inserts and public comments.
Thank you. So it's not addenda or attachments, it's inserts, and I wanted to use the right word. All right, so Exhibit 1 is admitted. Thank you.
Ms. Edwards, have you also prepared a proposed final order for this project?
Yes.
Did you include conditions for approval for this project?
Yes, there are conditions as part of that approval.
Were those conditions that you gleaned from compiling your staff report?
Yes.
Your Honor, I don't have any further questions for Ms. Edwards at this time.
All right. So applicant, I have questions for this witness.
So I want to go back and ask a little bit more about the zoning. The zoning and what is required, is that addressed in the comprehensive plan and policy L-1.7.1?
Yes, that is correct.
So when we talk about that conditional use meaning a heightened review, is that what caused this to be a major development order?
The conditional use? No, the use itself as an asphalt plant, a heavy industrial use,
But
not the good conditional use.
well, isn't the land development, the comprehensive plan actually specifically say an approved use is an asphalt plant?
It does. It also says all future development within these areas must obtain a major development order prior to commencement of any new development activities.
Right. So where we're talking about conditional with this heightened review is simply that we have to go through a major development order process.
Yes, I would agree to that.
Right. Assuming we meet all the requirements for a major development order, an asphalt plant is a use by right on a heavy industrial site.
It is a primary use in heavy industrial.
And I think it's also identified in your land development code as heavy industrial. Under heavy industrial, asphalt plant is a specifically identified use.
Yes, it is.
In fact, in Walton County, under both the Comprehensive Plan and Land Development Code, heavy industrial is the only place you can put a asphalt plant.
That is correct.
I'd like to move the sections of policy 1.1-7.1, and what section of this, Melissa? Two 2.300.
All right, what is the comp plan policy number again? Let me get that straight.
L-1.7.1. It's titled Industrial and Extractive Uses.
Any objection, Ms. Davis, to me admitting it as an exhibit, or is it? It's not excerpted from anything you already have in the application. I mean, in the staff report, correct?
No, Your Honor, those are not things that are.
Okay. All right, so I'm going to admit comprehensive plan policy L-1.7.1, as well as
Land
Development Code section 2.300. Is there anything else that comes before that?
I'm sorry, it's 2.02.28.
Wait, 2.02.28.
Chart at the end.
I don't have the chart. I have the land development code
It's the
section.
chart at the end,
Yeah,
so I think Melissa gave the correct number.
All right, I need to know what I'm admitting here. Let's get it straight.
Primary uses defined.
2.03.00. All right. All right, are admitted as, I'm going to refer to that as applicants exhibit 1. You need a copy for the clerk.
I'm gonna give her the one that has the exhibit number on it.
As applicants exhibit 1. Okay, well then policy L-1.7.1 as exhibit 1 and LDC 2.03.00 as exhibit 2 then. Thank you.
As part of the review process, are there certain things that the planning department would have an outside consultant review for you?
Yes, that would be the traffic. We use an outside third-party entity to review the traffic.
Do you also use an outside third-party entity to review the stormwater plan?
Yes, he also reviews the stormwater, or did for this project.
And also, do you have, not outside, but within the confines of the planning department, do you have an environmental planner that reviews the environmental study that was done?
Yes, we do have an environmental planner for the county.
Okay, and then on the traffic, I want to get to that for a moment. Originally, at the time this application would have been submitted, did we have a mobility plan or fee in place?
That depends on the date of submittal. If it was prior to the adoption of the ordinance for the mobility fee, yes, there would have been a separate review.
By ordinance, you mean the ordinance where they...
The adoption of the mobility.
And then subsequently they suspended it.
That is correct.
Okay. And that was on a property that was accessed by a state road.
Yes.
Was the purpose of the traffic study for purposes of calculating that fee?
It was. It also did traffic counts, traffic generation counts.
Okay. But the only thing in terms of traffic on a state road that the planning department was concerned with was, one, what was the fee going to be? And number two, did we, if it was a state road, get a permit from DOT.
That is correct. If they feel necessary, they do ask for operational improvement analysis, in which case I believe the applicant did provide that.
Okay. And so there was nothing from the Walton County, since we no longer charge a fee, and we had a DOT permit, there was nothing about traffic that the county had any authority over to do anything else with.
After the review of the operational analysis, that is correct.
Okay, was there any problem with the operational analysis?
There was not. It didn't provide evidence that there were operational improvements required, but they also reviewed for impacts, in which it was determined to not have a significant impact on the operation of those roadways.
But in the case of a state road, Walton County can't require a operational improvement.
That is correct. It's mandated by the state.
Right. So as long as we went through the state and got the proper permits from DOT, we've met any operational requirement.
As far as I understand, I'm not the traffic engineer, but.
Right. But Walton County has nothing to do beyond that. Right. Okay. And then I want to just go through real quickly. We touched on most of the issues, but I think you already testified. The first thing you look at is, are we the proper zoning? And we were.
That is correct.
And then the other uses, things you look at parking.
Yes, we
and
do.
Did we meet the proper parking requirements?
Yes, those were met.
Then you look at setbacks and buffers.
Correct.
And did we meet the setback and buffer requirements?
Yes.
And then you look at stormwater, and then did we meet the proper stormwater requirements?
Yes, according to our stormwater engineer, yes.
Right. We look at whether under the comprehensive plan sanitary sewer is addressed.
Yes.
And was it addressed here?
Yes, it was.
And you look at solid waste, garbage.
Yes, the health department does their review of the project as well.
And did we meet that requirement?
Yes, it met those requirements.
And then you look at potable water. Is there a supply, potable water? Was there a supply of water to this site?
Yes, through the city of Freeport.
Are there any other requirements that they must meet under the comprehensive plan or land development code to meet the requirements of an issuance of a development order?
Outside of what has been reviewed with the staff report, I would say no.
Okay. I don't have any further questions for this witness. Thank you.
Thank you. Ms. Davis, any redirect? All right, I'm confused, so I'm going to ask some questions. I still don't understand whether the hot mix asphalt plant is a use by right in the heavy industrial zoning category or whether it's a conditional use, separate and apart from whether it has to undergo major development order review.
Yes.
Because I heard you answer that question both ways.
And I will answer that. There's a little bit of conflict between the land development code and the comprehensive plan. As a primary use in the land development code, it is allowed as a primary use by right.
Okay, so if I look at the definition of
and primary uses
of, well, industrial and extractive uses, the comp plan category itself, I will find it listed as a primary use.
You will also find it as a primary use there, but a stipulation, an additional layer that says there is a conditional use requirement that they must all be majors. That is not explicitly stated in the land development code that it must be a major development order as a conditional use. That's pulled from the comprehensive plan.
All right, and then if I go to the zoning, if I go to the LDC and I pull up the zoning designation for heavy industrial, will I find hot asphalt plant?
You will find asphalt plant.
Asphalt plant listed as a use by
primary
right.
use by right, yes.
Use. Okay, so it's listed as a primary use in both the comp plan and the land development code, but the comp plan itself requires that it undergo or it go through major development order review.
Correct, and,
Okay.
and that's the main difference.
Okay, okay, so it's not a conditional use in the more traditional sense.
That's my understanding, yes. It-
Okay, all right,
forget- Yeah,
thank you.
okay.
Well, okay, in light of the questions I asked, Ms. Davis, any questions? Do you have any questions, Mr. Shipman? Okay, thank you. You may call your next witness.
County has no further witnesses.
All right, Mr. Shipman. Make sure that you're speaking into the microphone because the recording needs to pick it all up.
Good afternoon.
Good afternoon. If you would please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And please state and spell your name for the record.
Jeff Howell, Howell.
Thank you, Mr. Howell.
Mr. Howell, are you the owner of Southeast Asphalt?
Yes, sir.
And I want to start with your background. Would you tell Your Honor your educational background starting with college?
So I graduated from the University of Alabama in 2004 with a degree in civil engineering. Practiced engineering for a couple of years before I moved into construction. Also a registered professional engineer in the state of Alabama.
And how long have you been in the asphalt industry?
Construction total around 20 years, specifically in asphalt 15.
And do you own another asphalt plant besides the one we're seeking to construct here?
I do, in Geneva, Alabama.
And could you describe what does a hot mix asphalt plant do?
Yes, sir. So we basically combine raw materials with other recycled asphalt. We put those materials together in a mixing drum, which is the black cylindrical apparatus over there on the attached picture. That gets combined with a liquid asphalt cement heated together and is then batched out onto trucks to be delivered to sites and roads.
Is this picture of your plant in Alabama?
Yes, sir.
And is this essentially what will be placed at the site that this development order is about?
Yes, sir.
Is this something that the actual construction of what we see in the picture, is that something that's just moved in on a truck?
Yes, sir. Most everything's on wheels and axles.
Was there something that was particularly attractive about this site to build an asphalt plant?
First and foremost, most of the infrastructure was there on this site because it was previously an asphalt plant. And secondly, it's zoned correctly. It's one of the few parcels in Walton County that's zoned heavy industrial, so it met those two requirements.
And by infrastructure, you're referring to the concrete pads?
Yes, sir.
And the water line?
Yep, the surface topography. Since everything was already there, they basically just pulled it out and we'll put it back.
And is there a natural gas line that goes to that property?
Yes, sir.
Is that important?
It is.
And why is that?
Because that's a cleaner burning fuel. When you heat, it's more efficient to heat the aggregates that goes into the asphalt mix, and it's cleaner.
So, in other words, you have to have a heat source for a hot mix asphalt plant.
Yes, sir.
And the natural gas line is it the best source to use?
Yes, sir.
Judge, I know it's demonstrative, but I'd like to admit as Exhibit 3 a copy of the photograph that we've showed you of what this thing looks like.
All right, any objection? Okay. And I've heard him identify this as a plant that he owns in Alabama, correct? Okay. Let's see. I believe this would be applicant's Exhibit 3 at this point.
Yes, ma'am.
All right, so that is admitted.
Now, are there asphalt, is there a limitation on how far it can go from a hot mix plant before it has to be applied in paving a road?
Typically, to meet project specifications, you have to maintain a certain temperature of around plus or minus 300 degrees. When you start getting further than 45 to 50 miles away from your source, you will start beginning to run into temperature issues.
How many miles, say it again? for me?
I would say 45 to 50.
Okay.
And I guess there'd be some variance based on the time of the year.
Yes, sir.
So in order to supply asphalt for paving roads in South Walton County, is it necessary to have an asphalt plant down here?
Yes, sir, I would say so.
Have you obtained a permit from DEP to operate an asphalt plant?
Yes, sir.
And have you obtained a permit from DOT to access this site?
Yes, sir.
I don't have any further questions for this witness.
Thank you. All right. Ms. Davis, was questions? All right. Thank you, sir.
We would call Melissa Ward. Would you?
Hi, Ms. Ward. Please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Ms. Ward, would you share with Her Honor your background, training, and education in the field of land planning?
Yes, I am a certified planner with the American Institute of Certified Planners and a member of the American Planning Association. 20 years experience in planning, 11 of which was working for Walton County as a planner and other job duties. I have reviewed consistency of plans to the comp plan and the land development code, among other duties, and have represented before the Board of County Commissioners and provided testimony as such.
And do you have a certification as a land planner?
I do.
And what is that?
It's AICP, American Institute of Certified Planners.
And would you share with the court what is required to become an AICP certified land planner?
The requirements include educational background and experiential background and a exam for which you must pass in order to be certified.
We would tender Ms. Ward as an expert in the field of land planning.
All right, Ms. Davis, any objection?
No, Your Honor. Ms. Ward testified in other quasi-judicial matters.
All right, so accepted. You may proceed.
Could you go over what are the relevant provisions of the Land Development Code and Comprehensive Plan that apply here?
I can. The policy in the comprehensive plan, which was mentioned earlier, is policy L-1.7.1. The land development code for the zoning district is Land Development Code section 2.02.28 and relevant sections. It also involves chapter 3 for concurrency that has to do with stormwater, potable water, sanitary sewer, recreation, and traffic concurrency.
Chapter 3 of which? The comp
Of
plan
the
or
Land Development Code, my
Land-
apologies. In the comprehensive plan under protection of resources, I don't remember the name of that policy. I apologize. And the Land Development Code, Chapter 4, under 4.01 for wetland resources, as well as Chapter 5 for development standards, all of which would apply. I think that mostly covers.
And we had a discussion earlier, but let's go to zoning.
Yes, sir.
What is the zoning category at this location, and does it meet the requirement for an asphalt plant?
Yes. So, speaking strictly to zoning, it is zoned heavy industrial. The future land use for the property is the extractive and industrial uses, and the zoning district heavy industrial is a subcategory to that policy. And then it's zoned for industrial, and prior to zoning, it had a future land use of heavy industrial.
And when you say prior to zoning, so that I don't believe the judge is from here, what are you referring to regarding that?
Absolutely. So in 1996, Walton County adopted their current comprehensive plan, and at that time, future land use map, at which time that property was zoned heavy industrial. In 2018, the Comprehensive Plan and Land Development Code were amended to include zoning districts, which we previously did not have. At that time, it was modified to be under the future land use of industrial and extractive uses and zoned heavy industrial.
Is an asphalt plant a use by right?
Yes,
at
it
this
is.
location?
It is. The clarification is that the condition that is placed in the comprehensive plan is that all heavy industrial uses are meant to be heard as a major development, regardless of the size or nature of the use, and therefore we've met that condition. There are 3 subcategories within that policy to concerning conditions or development standards, which include ensuring that they have adequate buffers, and that's in policy L-1.7.1, subsection B, subsection 3, subsection 4. A regards the adequate buffers for the development site. B requires that it is on a regional access or has regional access, which Highway 20 is. And C is that it complies with other regulations in the Land Development Code, which we do.
Okay. So I want to go down the list, and if I leave any out, please correct me. The requirements under either the Land Development Code or Comprehensive Plan, which we must meet. One is zoning, and we've already talked about that.
Correct.
And we meet it.
Yes, sir.
Another one is parking. Do we comply with the parking requirement?
That is correct.
What is the requirement for parking on this site?
Chapter 5, section 5.03.00, I believe, is the parking section, in which it states all heavy industrial uses have a requirement of 1.5 spaces per 250 square feet. And what we have provided, which would have equated on this property, since the building is only 400 square feet, about half of a parking space or so. 2 parking spaces at the most. We've provided 6 spaces, 5 of which are standard parking spaces, 1 handicap.
What about setbacks and buffers? Is that a requirement?
It is a requirement. It's found in Chapter 5. The setback requirements for heavy industrial uses are 25 feet in the front, 20 feet in the rear, and 10 feet on each side. The site plan provides that the setbacks on the property far exceed, and I need to have the site plan to tell you exactly what they are, but they're 168 feet, 362 feet. I know those 2 numbers, and more than 25 feet on the front.
Site plan, and we will mark this, I guess it's applicant 4.
So is the site plan already included in the staff report? I try not to, okay. I try not to have a lot of duplicates in the record. It especially helps when I'm writing.
Right.
But if you want to give her that one to look at, I need to
and
know.
perhaps, the only reason I would suggest you might let me admit in the evidence, this is big and easy to read. The one that's in the report, I'm old. I have to use a magnifying glass to read it.
Okay, I mean, if you want to move it, that's fine.
Okay.
Any objection, Ms. Davis?
No, Your Honor, I know what we have in our package, it didn't print
Okay. All right, so you're offering as applicant's exhibit for the approved site plan, or the site plan as proposed to be approved, right? Okay.
Yes, ma'am.
Yes.
Okay, so admitted.
So for clear references, the required setback in the front is 25 feet. They provided 168 feet. The required setback for the rear is 20 feet. They provided 338 feet. The required side setbacks are 10 feet. They required 320. And the maximum height limits, which is under the same subsection, is 50 feet. And we meet that requirement.
What about buffers?
So the site did present with some wetlands, and therefore is required to have, under Chapter 4.0100, a 25-foot wetland buffer, which are provided on site. And beyond that, there are additional landscaping or natural vegetation beyond that 25 feet, so it's more than 25 feet. On the east side of the property, there is a uncomplimentary land use buffer, which is under Chapter 5.0109, which provides that heavy industrial uses will have a 25-foot buffer when they abut a different land use category. In this case, it's rural residential next to industrial, and therefore it has a 25-foot buffer of natural and supplemented landscape buffer. That particular requirement is also a subcategory or a special condition under the zoning district of 2.02.28.
So even though it is zoned rural residential, it's actually a closed landfill.
That is correct.
What else surrounds this area?
And is the zoning rural residential or the land use?
The zoning, it's currently a closed filled landfill that is vacant.
But it's designated rural residential, and it's the zoning district, which was my question. Okay, thank
That's
you.
correct.
Okay.
What's directly across the street on Highway 20?
An industrial zoning district that has a mining operation.
And is down the street a junkyard?
That is correct.
And is that also heavy industrial category?
It is industrial.
Stormwater, that would be something you would defer to the engineer on.
That's correct.
Sanitary sewer, is that something you would comment on, or is that defer to the engineer?
The sanitary sewer is not available at this site. The applicant will be required to apply for a septic tank.
What about solid waste?
The county has an agreement with Waste Management. There is waste pickup.
And what about potable water?
The applicant will have to connect with the city of Freeport for potable water.
Other than what we've just gone over, is there any other provision of the comprehensive plan or land development code that the county has authority over for purposes of imposing a requirement to build this plant?
We have covered all of the portions of the code that reflect on this property, and that this particular project, as the staff has stated, meets the comprehensive plan and land development code.
I don't have any further questions.
All right, Ms. Davis, any questions for this witness?
Ms. Ward, this is not any insult to your integrity, but I do want to make sure that we are clear for the record. Where are you presently employed?
Dunlap and Shipman.
And is that the attorney for the applicant?
It is.
Okay. That's all I have.
Okay. Any redirect on that point? Okay, thank you.
we would call Scott Singletary.
Welcome, Mr. Singletary. Keep hitting my own microphone. Please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Sir, what do you do for a
Let me
living?
get him to state, I know you already called him, but let me get him to state and spell his name for the record.
Scott Singletary, Singletary.
Thank you.
Mr. Singletary, what do you do for a living?
I am an ecologist with a company called UES.
And could you share with the court your educational background and work experience?
Right. I graduated from the University of Florida, the degree in natural resource conservation, and I've been working with UES for the past 6 years, conducting these assessments and writing these reports.
Did you perform an environmental assessment on the property?
Yes, I did.
And why is this done, and how do you do it?
Typically, this is these reports typically address the Walton County LDC requirements. It's typically a pre-buy sort of inspection.
What?
A pre-buy.
Oh,
if you might,
pre-purchase.
yeah,
Okay.
Right. It's
okay.
It's primarily there just to identify natural or resources that might be on the property, and including other environmental things that may be associated with the property that the landowner might need to know about that may be of interest to them later in the future.
And what were your findings?
We found what we call an altered site. A disturbed site is typically the way it's reported, but a site that has been completely altered from its natural state.
And is that because there had already been something on the property?
That's correct. Several layers of alteration. On this site, there are impounded wetlands abutting the property. The historic aerial imagery shows pine plantation. And then, of course, there is the prior industrial use that has completely disrupted the native vegetation on the site.
When you say a prior pine plantation, you mean it was literally planted and harvested? Is that what we're talking about?
That's right. That's right.
Thank you. And that would have the impounded wetlands that would have been the wetlands would have been impounded in conjunction with that development.
It's
Or
hard
you
to
don't know?
It's hard to
Okay.
say. They could have been through. We don't really know.
It was hard for me to tell from your testimony whether you were explaining that the prior pine plantation was the reason the wetlands were impounded. So that's why I was needing the clarification. Thank you.
But obviously, any impoundment on the wetlands has nothing to do with what we intend to do, because we're not there yet.
That's right. That's right. Just an observation.
And were there any endangered species identified on the property?
No, sir.
Any hazardous materials or contamination?
No, sir.
Did you prepare your inspection in the form of a report?
I did.
And is this a copy of that report, which I'm marking as A5?
This is it. Yes.
Okay. And was this presented to DEP?
I don't know.
Was an environmental resource permit obtained?
I don't think that's my question.
Okay, would that have been the engineer?
I wouldn't know. Yep.
Okay.
If
We'll cover it with the engineer.
these reports are typically associated with those applications, yes.
Did you ever learn that Walton County's environmental planner had reviewed your report?
I heard that today, yes.
Okay. I'd like to admit this report into evidence as A5.
Okay, is there any objection? All right, so I'm admitting as applicant's Exhibit 5, the environmental assessment report provided by Mr. Singletary.
I don't have any further questions for this witness.
Davis, any questions for this witness? Okay. All right. Mr. Shipman,
Yes, ma'am.
you have another witness?
Yes, ma'am. We would call Alan Thompson.
And Mr. Shipman, at some point, I'm going to need applicant's Exhibit 3, so when you get a chance to make a copy or provide me with one. That's all right. Thank you. It's probably more important that she have it, but since you provided me with everything else, I want to make sure that I go home with it.
Well, and this is, you know, I've done administrative hearings, but not in this format before, so it's a little different trying to, we usually, when it's the county commission, planning commission, we're handing them out to everybody. And all right.
Okay, so if you would please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Please state and spell your name for the record.
Alan Thompson, ALLEN THOMPSON.
Thank you, Mr. Thompson. You may proceed, Mr. Shipman.
Mr. Thompson, what do you do for a living?
Environmental engineer. My degree's in civil engineering, but I've been basically in the environmental field for the last 35 years.
I was going to ask you if you could give your educational background and work experience, starting with undergraduate, and
Yes.
where you went,
Yes.
what your career was.
Yes, my degree, I graduated from Auburn University with a degree in civil engineering. I'm a registered professional engineer in the state of Alabama, Mississippi, Georgia, and Florida. And basically, I've been in the environmental field mainly from doing stuff from air permitting to environmental assessments and site cleanups for the last 35 years.
And in this particular case, on hot mix asphalt plants that are located in the state of Florida, who regulates their air quality?
That would be the Florida Department of Environmental Protection.
Did you obtain the necessary permits from DEP for this plant?
Yes, I did.
I want to show you what we marked as the A6, I think.
We are at 6, yes.
Is this the permit?
That is the permit.
I'd like to admit this into evidence.
Right. Have you taken a look at this before, Ms. Davis?
Did you submit all the documentation required by DEP for them to issue this permit?
Yes.
And you get a copy of the permit as part of preparing the documentation for DEP?
Yes.
Did you handle all the work for obtaining this permit for Southeast Asphalt?
I did.
I was asked to admit this into evidence.
All right, Ms. Davis, any objection? Okay, so at this time, I'm going to admit applicant's Exhibit 6, the air permit issued by DEP. Thank you.
I have no further questions for this witness.
Ms. Davis, any questions for this witness?
No, Your Honor, as illustrated, it's not within the county purview.
So you're not positive it's actually relevant to what I need to make a decision on, but you don't have an objection? Okay, all right.
We would call at this time Michelle Baker.
Welcome. All right, Ms. Baker, if you would please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
And state your name for the record.
Michelle Baker.
Spell it for me.
Excuse me, Michellelebaker.
Thank you. You may proceed.
Would you, what do you do for a living?
I'm a civil engineer.
And would you describe to the court your educational background and experience starting with undergrad?
I received my bachelor's degree from Auburn University in civil engineering, and I received my master's from Auburn University in civil engineering with a focus on transportation. I have my PE license I've had it for 18 years. I'm registered in Florida, Alabama, and Georgia. And I founded Baker Engineers in 2010, 15 years ago.
And is that where you currently work?
Yes.
And is your husband, Nolan, also an engineer, works with you at Baker Engineering?
Yes.
Did you do a stormwater plan for this
I did.
project? I want to show you what we will mark as Exhibit 7, I believe.
Yes.
Is this the stormwater plan that you prepared?
It is.
Now, in preparing a stormwater plan, do you review what is required by the Walton County Comprehensive Plan Land Development Code?
I do.
And what is required as far as stormwater plans go for a project like this?
Retaining the first inch of stormwater runoff, designing for the 25-year storm event, as well as looking at the 100-year storm event for flood control.
I'd like to admit this in the evidence at this time and provide you a copy, Your Honor, so you could look at it while she talks about it.
Okay, Ms. Davis, is there any objection?
I believe the staff report had at least a portion of it. Well, I want to admit it because this one has her stamp on it, and she has established that she's the author of it and can go through the calculations. I don't know that I've reviewed the staff report to determine completeness.
Okay, all right. Let's not waste any time arguing over it. I'll accept it. So at this time, I'm admitting as applicants Exhibit 7, the stormwater, is this the stormwater plan?
Yes.
The drainage
report. Okay. Drainage report for the project.
And could you describe to the court what is required for drainage or stormwater on the property?
Well, the stormwater management plan that captures the stormwater runoff in retention areas. In this case, they're dry retention. And the flow that's leaving the property needs to be equal to or less than the flow in the precondition. So, and then we have the Walton County requirements, as I said before, with the 1 inch, the 25 year and the 100 year. And then on top of that, we go to the state level and also get a permit from them. And they look at water quality and, water control.
Now, just to, because Your Honor's not an engineer, I'm not either.
Mm-hmm.
Based on what you said, to kind of clarify, when you say 25-year event, that means with the water flowing on the property.
Yes, the stormwater runoff from the property.
And it's supposed to contain that.
Mm-hmm. Contain it and treat it and release it.
And then when you say 100-year, that means your stormwater ponds are supposed to be able to hold 100 years events worth of water without breaching the top.
Right.
And did your design do that?
Yes.
And how do you go about doing it? Is there sort of measurements and calculations you have
Yes,
to
there's calculations. There's certain calculations and methodologies approved by both Walton County and the state.
And did your report indicate what they were and that it comported with all these requirements?
Yes.
Now, we've had some discussion here about traffic. You actually did do a traffic study here.
That's correct.
But as of this date, is there, well, let me back up. Is this property accessed by county road or state road?
State road.
And as of this date, is there anything that the county has some sort of regulation over, or fee, or something else that traffic report comes under their control?
I think Rosanna Edwards stated correctly where they have it as a item that you submit for their review for their informational purposes for operational analysis, or they can comment on, but there's nothing that I know of that's regulatory because there's no county or local road adjacent to this property.
Was the study also provided to DOT?
It was.
And does DOT have requirements that have to be met?
They have many requirements that have to be met, starting with the pre-application meeting where they tell me what methodologies and formulas they want me to use. They go over the site with me. They tell me what traffic counts might be usable, and we did have a thorough discussion. So the traffic report is based on what they want to see, and then they can review it and analyze it internally, and then they can come back to me to ask for any different analysis if they want to see something special or different, and we can discuss. So, and then at the point where everyone agrees that the report is complete, they make a judgment on what is needed, and then you receive your permit.
And was a DOT permit received?
Yes.
I don't have any further questions of this witness.
All right, Ms. Davis.
I do want to make clear, at this point, Ms. Baker was not qualified as any kind of expert. We discussed that she had some background in engineering,
Well,
but as far as the report goes, it's at this point.
all right, let me ask it, do you have an objection based on her qualifications?
I do not have an objection.
I would tender her as an expert in stormwater engineering.
All right, do you, hold on. Ms. Davis, do you have an objection to her being qualified as an expert in traffic? Did you say, I mean, in stormwater engineering?
The one that we entered.
The drainage report was entered, which I think the witness has said stormwater report is interchangeable, correct?
Yes, ma'am.
on the next part, since you provided testimony on traffic, how many traffic studies do you think you've done?
Many, I don't,
Over years?
yeah, over the last, I started doing traffic studies 20 years ago, so I couldn't tell you how many.
All right, we would tender her as an expert on traffic studies for purposes of obtaining the DOT permit.
Actual traffic studies, like traffic reports, like what the county requires.
So I don't, the further and further you get away from an ology or an ing, the harder it is to determine if you actually qualify as an expert in an area. Seems like if you want to offer as an expert in traffic engineering, that would be an appropriate field of expertise. I don't know that
All right,
traffic
I'll
studies.
offer her as an expert in traffic engineering.
So do you have an objection? Did you want to elicit any testimony from her about her qualifications in that area?
I am aware that Ms. Baker has testified in
Okay.
Just so the record's clear, and I'll just ask a few other questions. Have you submitted many traffic studies to qualify for aspects concerning Walton County, such as where it was a county road or when they had a mobility fee?
Yes.
And have you testified before in those matters?
Yes.
And have you performed and submitted many studies in the circumstance where a DOT permit was needed to be issued?
Yes.
And were they accepted by DOT?
Yes.
Have you ever had to testify in a hearing where you did the work to obtain a DOT permit?
In a format like this for Walton County, yes.
Okay. And your particular background in engineering, did you do any sort of expertise in traffic?
My expertise for my master's was in transportation.
Does that include traffic?
So yes.
Thank you.
All right, so she, accepting her as an expert in both stormwater engineering and traffic engineering. Thank you.
All right, our last witness would be Nolan Baker.
Welcome, Mr. Baker. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And please state and spell your name for the record.
Nolan Baker, Nolanbaker.
And Mr. Baker, what is your occupation?
I'm a civil engineer.
And would you share with the court your education, training, and experience in the field of civil engineer?
Yes, got my bachelor's degree from Auburn University, a master's degree from Auburn University as well.
In what?
Master's.
Both.
Oh, in civil engineering, sorry. It's been practicing engineering for about 27 years, licensed engineer for over 19 years. Currently carry a license in Alabama and Florida. While I was at Auburn, specialized in asphalt, worked for the National Center for Asphalt Technology for about approximately 6 years.
So your master's degree is in civil engineering with a concentration with a specialization in asphalt? Is that what you were saying?
Yes, ma'am.
Okay, thank you.
We would tender him as an expert in the field of performing engineering work for the design of asphalt plants.
Okay, any objection or any more dire?
I would have no objection if we're talking about that Mr. Baker is qualified as
Well, he's going to be rendering opinions on what he did to meet the design criteria on this
I
particular.
would anticipate that
All right, I'll accept civil engineering and I'll await an objection if she thinks we go beyond.
All right, so I'm going to accept Mr. Baker as an expert in civil engineering. You may proceed.
Mr. Baker, what was your, well, let me back up. Who do you work for right now?
Baker Engineers.
And was your company retained by Southeast Asphalt to do all the engineering design work necessary for this asphalt, hot mix asphalt plant?
Yes.
I guess I should say an exception would be the air quality environmental work.
That's correct.
And we've already heard from your wife. What was your role in the design work here?
I was primarily project manager, and also responsible for coordinating the site plan and the grading and utilities.
We've already submitted the site plan evidence, but were you the person who did the work and created that site plan?
Yes, sir.
As part of doing the site plan, were you required to familiarize yourself with the requirements of the Comprehensive Plan and Land Development Code for Walton County?
Yes.
And did you design this site plan to meet all the requirements, at least from an engineering perspective, of the Walton County Comprehensive Plan and Land Development Code?
Did.
So it does meet those requirements?
Yes.
Did you have any role? Your wife testified about a little bit about the DOT permit, but did you have any role in designing the access to this site?
Yeah, I laid out the geometrics of it, and then she applied for the permit.
And was that access approved by DOT?
It was.
Did you, I want to talk about a few things we've kind of checked off, but does this site have access to potable water?
It does, from the city of Freeport.
And when it was reviewed by Walton County, did they request that a fire hydrant be put in at this location?
Yes, one's being installed right there near their entrance.
And that's in your site plan?
Yes, it is. It's on the utility plan.
And does your site plan include placing vegetation in any location where the buffer isn't thick enough?
Yes, they're on the east side. We're adding supplementing plantings where the buffer is thin.
Is there any state permit required for the operation of this plant that was not obtained?
No, sir.
And was there any requirement by Walton County that was not done in the site plan?
I'm not aware of any.
Did you submit to DEP an application for a permit for this asphalt plant at this location?
Yes, this is the URP permit. Initially, we submitted it to Water Management District, but given the nature of the project, they kicked it up to DEP, which reviewed the project, and we received that permit.
And were you the one that submitted the application and the materials required?
I was.
Did that include the environmental assessment that we previously heard Mr. Singletary doing?
Yes, DEP reviews that as well.
Is there any other requirement by DEP that there is not a permit? We've heard about air quality, and now we've heard about the environmental assessment permit.
No, sir.
I'd like to move in as Exhibit A, the environmental protection resource permit.
All right, have you seen this, Ms. Davis?
No objection, Your Honor.
All right, so I am accepting into evidence applicant's Exhibit 8. Environmental Resource Permit from DEP.
That's all the questions I have at this time for this witness, Your Honor. Thank you.
Do you have any questions for this witness, Ms. Davis?
No, Your Honor, not at this time.
Okay.
We don't have any other witnesses, Judge. I presume, and probably should have talked about this, Ms. Davis and I did after the last matter in front of you. Ordinarily, my understanding is you don't do rebuttal witnesses after public comment because public comment is not testimony. But I don't know how you want that.
Well, right now, there's nothing for you to rebut.
Right.
So I will ask again. I just always offer it if
Okay.
there's anything that the applicants want to say, so.
Well, we're finished.
Okay. Thank you. All right, we are not gonna take a break because we have this room for what, 40 more minutes? So come on up.
We've got Dr. Buckholz here.
Okay.
You okay to stand here?
Yes.
You state your name for the record.
Jeffrey William Buckholz.
What is your,
Okay, so at the time, I didn't understand your objection because I didn't have, the project was not presented. So what is specifically your objection to this witness?
My understanding is he's going to testify as traffic. All the witnesses testify that presently there is nothing regarding traffic that on this project that the local government has any authority over. Okay. They don't charge a mobility fee anymore, and DOT is the one who decides on traffic, and they've issued a permit.
All right, I'm going to overrule the objection, allow the testimony, and I'll determine whether, what the relevance is and how much weight to give it. Sir, if you would please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Please state your name for the record.
Jeffrey William Buckholz.
And spell it for me, please.
Buckholz.
Thank you, Mr. Buckholz. You may proceed.
thank you. Mr. Buckholz, would you tell the hearing officer your background and start with your education, please?
I have a bachelor's degree in civil engineering from the University of Toledo, a master's in civil engineering with a transportation major from the University of California at Berkeley, a PhD in engineering with a transportation major from the University of Florida.
Okay. Any other education beyond the undergraduate, the master's, and the PhD that involves traffic?
I have an MBA in finance, and I did 2 years of postgraduate transportation studies at MIT.
Okay. At this point, you've had an opportunity to review the traffic study that was submitted along with this application. Is that correct?
Yes.
Okay. Your Honor, based on let me ask another question this way. How long have you been working in the area of traffic studies and transportation?
For over 40 years, I started my own company, Traffic Engineering, in 1988.
Okay. And to this point, how many traffic studies would you say that you have conducted?
Well, thousands, probably.
Okay. Would you say it's more than 2,000?
No, probably not more than 2,000.
Okay. But thousands means more than...
I'm on job number 2,000 for my company, so it's probably
okay.
between 1,000 and 2,000 that were traffic studies.
Okay.
I do other type of work, traffic work as well.
And do you also teach at any particular university or college the subject of traffic studies or the subject of transportation?
I taught for 3 years at the University of North Florida. Okay. I no longer teach there.
And when did that end?
2005, 6, and 7 I taught there.
Okay. Your Honor, I'd move him in as an expert on traffic studies and on transportation.
I'm going to object. We can either allow me to apply this with time or serve.
Okay, but you're moving him as an expert in traffic studies. I had previously indicated it doesn't seem like a recognized area of expertise rather than traffic engineering or.
Traffic engineering might be a better way to say it.
Okay, all right, and yes, you may voir dire.
Testimony in front of the Planning Commission. Yours starts on page 141. Here, John, you need your. Now, you previously testified, you've been an expert witness concerning traffic, over 300 cases.
Been involved in over 300 expert witness cases. Not all of them involve traffic engineering.
Right. You currently advertise yourself as an accident reconstruction expert, correct?
Not true. I explained to you that that's one of the websites that I'm on. I pay them, they put the headings on it. They have me down in the accident reconstruction area, but I do not do accident reconstruction work.
Isn't most of your testimony in cases where you talked about traffic was accident reconstruction work?
No.
Don't you work for a lot of plaintiffs' lawyers?
About 60% is plaintiff and about 40% is defense, approximately.
Right. On people representing someone who is suing someone else for personal injuries in a traffic accident.
Not always. There's land use cases as well.
Okay. Isn't the overwhelming majority of your testimony in cases where there is a lawsuit over a traffic accident?
Your Honor, I'm going to object at this point that this is not as far as
I disagree, because what his work is accident reconstruction, which is an entirely different thing than what we're talking about
So,
here.
It sounds like he's done a lot of traffic studies that are in the traffic engineering field. It sounds like what you're trying to dig down on is his expert witness testimony, though, may have been limited in some respects, may have been more heavily in
Right,
traffic.
as opposed to what's going
But
on
but
here.
he has, Mr. Buckles, but you have testified in, you'll have to tell me in what setting you've testified as
Quite
an
a few
expert.
land use cases where traffic studies are
Right.
being discussed, and
Please,
traffic signal timing.
You both have a problem with interrupting other people. Okay, let me finish my question. So my question is, have you provided expert witness testimony in land use cases involving traffic engineering, traffic counts, traffic studies?
On more than one occasion.
Okay, and have they been at the local government level, state level, what kind of court?
Typically, when I'm testifying in that area, it's in front of either a county commission or a city commission or some sort of arbitration board or something.
Okay. I'm going to overrule your objection to his area of expertise. I want to accept him as an expert in traffic engineering. And I'm going to allow you to go ahead and start questioning your witness, or continue with questioning your witness.
All right. Dr. Buckholz, we were talking about the report that was issued in this case by Baker Engineering. I believe that's right. Is that right?
Yes.
All right. And you had an opportunity to review it before you went to the Planning Commission meeting.
Yes.
All right. And you have had an opportunity to re-review it before we came here today. Is that correct?
Yes.
All right. And during your period of review, it appears that you testified at the Planning Commission level that there were at least 6 to 7 different problems with that particular study. Is that correct?
Correct.
All right. And is it your testimony then that the permit that was issued by DOT was based on the study that was commissioned by the landowner in this case and was submitted to DOT by Baker Engineering?
FDOT's head of traffic operations told me that he relied on that report.
All right. And that formed the basis for the permit that was given in this particular case?
Apparently.
All right. And what are the problems in your estimation with the report itself?
Well,
Okay. Now I'm going to get to what I think may have been the original objection here. Okay. So if you're about to elicit from this witness a bunch of criticisms of the applicant's engineering report that served as the basis for DOT's permit, what relevance does that have in this proceeding where I'm to determine whether the application itself meets the code and the comp plan requirements?
In this case, what you have is essentially a garbage in, garbage out problem, right? His testimony will show that the report that was generated that formed the basis of DOT's permit having been issued, which took away from the county its ability to have some sort of a determinability, is what actually now is the problem. His testimony is, and I won't speak for him, but I'll try to give you a summary, is the report is wrong. The report was the basis for what took away Walton County's ability to be able to make a determination, and he needs to be able to point out
I need
why
you to
it was wrong.
explain that to me. What do you mean that because DOT issued a permit, Walton County somehow didn't have jurisdiction?
Well, once the DOT issued the permit, and the point that Mr. Shipman's trying to make is the county has no more authority at this point. The problem is that report that was issued by the applicant is faulty. That's his testimony. The testimony then leads us to a place where Walton County has lost its ability to be able to have any sort of impact. There was a traffic study that was commissioned. It was part of the record. It was a part of the report, and the county asked them to do it. That is a faulty basis for them to then turn to DOT and say, this is what happened and this is why we want these things. That's the problem. There's a disconnect.
Okay. The DOT permit that was issued in this case, was it for an access road? Was it for traffic capacity on the roadway? What was it for?
He's asking you.
Oh, you're asking me? Okay.
Well, I was kind of asking anybody who can answer the
When
question.
DOT issues a permit, they look at what makes the intersection safe for the driveway. So they would be concerned about
It's a
turn
simple question.
lanes.
Is it a driveway permit? Is
Yeah,
it
it's a driveway.
connection permit? Okay,
Well,
it's a
typically it's a
connection
driveway
permit. All right.
And that's the kind of things they look at, safety-related issues.
So that's a permit for a state road that only DOT can issue. There is no authority for Walton County to issue a connection permit on a state road. So I'm having trouble following your argument, sir, that because DOT issued that permit, then all of a sudden Walton County doesn't have any jurisdiction. Either they had jurisdiction or they didn't. It's on a state road. The only agency that can issue a connection permit is the state.
I agree with that, Your Honor.
Okay.
But from a fundamental position now, what we have is a record that's been entered that shows a report that formed the basis of the DOT's action that is now been entered here in this place, and
And it's irrelevant. I let it in. There wasn't an objection to it, and it's irrelevant. The DOT permit? The permit, that's what I'm saying. So he wants to, he wants to claim that he wants to introduce evidence that permit shouldn't have been granted because it was based on a faulty report. It's irrelevant. Okay. I'll give you a minute to think about what you want to do next.
well, I think the biggest issue and the biggest argument that needs to be made in this particular context is what we have is a situation where what the applicant put forward to Walton County, which formed a basis, at least a tangential basis, for letting them move forward. It was a requirement. That's what Walton County said they needed. That report was then taken over to DOT. So Walton County got a report that had garbage in it, and I don't need to use the word garbage. What I mean is wrongful information.
Right.
And having backed off of that, they satisfied their requirement that it had been turned in. At least at some point, that traffic study was a requirement that Walton County made.
So it's a part of a checklist.
Correct.
Right? It's a checklist that the applicant cannot start operating this business without getting that box checked by DOT.
Correct.
What I'm here to do is to determine whether the application itself, regardless of any state permits that are required from DEP, DOT, Fish and Game, whoever it is, whether the application to get approval for a development order from the county meets the county code requirements and the county comprehensive plan requirements. So if I say no, or I recommend, all I'm going to do is make a recommendation to the county commission that they issue it, approve it, that does not relieve this developer from having to go and get or obtain the driveway permit, connection permit from DOT.
Right.
Or from DEP. So I fail to see how this is relevant testimony at all.
Well,
Just as I fail to see that entering the permit into evidence today was relevant either.
well, I also think we would point to the issue that it's a fundamental safety issue, and Walton County has a responsibility to review that particular part. And now that they've entered in this report that doesn't take into account at least 5 or 6 different factors, that hasn't been adjudicated correctly by Walton County either.
And again, they're still going to have to do that regardless of what my decision is today. It's just separate and apart. And I'll ask Ms. Davis, I mean, am I on track or not? If you think I'm incorrect, please tell me.
No, Your Honor, the reason that the county allowed at least the DEP permit to be entered is just solely on the basis that this was something that has to be done, as you stated, it's on the checklist that all permits have to be acquired in order for this to operate. So
Right.
there's no basis to go any farther than that. FDOT is the sole authority that has the ability to establish whether or not this is going to be safe or not.
So I guess
we
would
don't
it-
have anything more that, as far as the Walton County Comp Plan and LDC, that we can do in that regard.
I am not going to be making any recommendations or recommended findings that this project meets state permitting requirements. So maybe that'll give you some comfort that regardless of whether I recommend it be found to be compliant with the comp plan and the code, they're still going to have to meet whatever requirements the state requires them to get, any permits for. If I'm well aware that there are avenues to challenge environmental permits, because I hear those cases. Nobody's ever brought me a DOT challenge, but there must be some point of entry for challenging this, and it sounds like that's what you really want to do here.
Okay.
So I just think it would be a waste of our time for me to hear that. So now that I understand the original objection, I can rule on the objection, and I am not going to allow you to introduce this testimony because it's irrelevant to the question that's before me today. Okay.
All right. Thank you, Your
Okay.
Honor.
Do you have another witness, though?
No.
Okay.
Thank you, Your Honor.
All right. Then again, we're not going to take a break. We're going to just move right through this because I'm trying to make sure we have this room available for, who is it? Planning and zoning or somebody at 5? Okay. All right. So let's go ahead and open the public hearing portion. Again, we've got the boundaries, limitations are the public may speak. They're limited to 3 minutes each. However, if you are someone who wants to speak as representing an association or organization, please identify yourself as such when you come up and let us know if you're requesting the full 10 minutes to speak on behalf of that organization.
I do want to make sure that Mr. Shipman was aware as far as that 10-minute issue that I don't believe he was in the room when we talked about it earlier. That the signatures, I don't have any confirmation that the signature has been done.
Okay. Okay.
I gets up and talks on behalf of an organization.
Right. It makes the language that was adopted by the county commission does indicate that if the individual is speaking on behalf of the members of the organization and they take the 10 minutes, other members cannot then speak. It does foreclose their opportunity. I would also ask that members, as members of the public come up, please state your name for me. Also, make sure you direct your comments to me and not to the parties. And I do not want to hear people yelling out things from the audience. I will ask for you to leave if you do that. So let's behave professionally. All right. Who's first?
Good afternoon, Your Honor.
Good afternoon.
John Jannazo, John Jannazo. I am going to take the 10 minutes. I'm the president of the Protected Emerald Coast Alliance. And
welcome.
Yeah, thank you. So just to begin, this process, and this is your second day doing it, we watched the very first one with the East Nursery Road. And it was a welcome step forward from the chaos of the Planning Commission that we endured on this matter, okay? We spent thousands of dollars and hundreds of hours preparing for the Planning Commission, only to be mocked, basically, not allowed to present all the information we wanted to. In fact, your packet today doesn't have our Planning Commission very clear, very nice color briefing with all the different issues. Didn't make it. In fact, the minutes to the Planning Commission does not have me listed as someone who spoke. The little AI generated minutes, you have to go into the transcript to find out that I actually spoke on behalf of the Alliance. The minutes did not represent the fact that the Planning Commission chairman cleared the room because the people in the audience were so upset with how chaotic the Planning Commission was going. So with that as background, I'm going to hit the high points and try to use these 10 minutes so you'll at least hear some truths and some facts that were not presented today. Number one, the asphalt plant stopped operations in 2010. 2010, March 2010. I have an eyewitness who is the plant manager who gave me that information. I have the information sent to the Environmental Protection Agency by the Association of Florida Asphalt Contractors, March 2010. I have the EPA report that references the plant in long-term reserve, 2010. Yet the applicant and their team continued to represent to you 2019, 2012, 22, the county in their emails in my Freedom of Information Act notes that it stopped operations sometime in, quote, 2011, 2012. This doesn't generate a lot of trust by the public with our county staff. The county staff submitted this report with the experts. You heard the expert testimony, Ms. Ward. I am an expert. She submitted a minor application. Clearly, the Land Development Code and the Walton County Code says it has to be a major. Yet they submitted it as a minor. The experts on the county staff submitted it as a minor. Do you know when it changed to a major? When we objected. And we went to all the county commissioners. And then Mr. Carpenter said, well, I've made the decision to change it to a major. Well, yeah, that's because that's what your code says. All right, so we've been dealing with this lack of trust from the start. The Environmental Protection Agency, do you know they never set foot on the land? They just looked at some reports and they gave them the permits. That's how it works. The EP, that's our trust in the federal or the Florida DEP. Let's see. Like I said, if you look in your packet, the agenda packet today, the 647 pages, you will not see in the transcripts the very clear 64-page briefing that we put together. Hours and hours of details and time spent to put it together. I don't know why it didn't get there, okay? You should ask for it. It was there. You can watch the tape. We talked about the conditional uses or major development. I think you need to pull on that thread a whole lot harder, okay? Use by right versus conditional use. There's a reason why we put conditional use in there. That requires somebody else to have a look at it. The fact that this plant ceased operations 15 years ago, Walton County's population has more than doubled in 15 years. In fact, in the last 5 years, it's gone up by 20,000 people. In fact, with our Tourist Development Council numbers, an average of 110,000 visitors per week. So our average county population is 200,000 people. That's on average. We have 3 major east-west roads, 98, 20, and 90. 20 is the major east-west road through the center of the county. It's a 2-lane road, 2-lane, 60 miles an hour. These trucks are going to be 70,000 pounds going 60 miles an hour on a 2-lane road without any turn lanes. Now, the applicant made a traffic report, and he did some lawyering and didn't put it in, but they did a study. I have an expert to refute that study, the basis of what FDOT gave them their permit for. Nobody is looking at a 2-lane road, 60 miles an hour, left turns and right turns with a 70,000-pound truck. Your Honor, there's going to be liability. There's going to be an accident. There's going to be fatalities. It's going to happen. It's already happening out there. We have 14 markers between here and Niceville. Fatalities, okay? The traffic is an issue. Fatalities are going to happen. Morgan & Morgan is going to roll in here and go, boy, look at this. It's going to be a nugget, and they're going to love it. The applicant also submitted, they listed it as 18,000 square foot. If you look on page 47 of your packet of the 670 pages, clearly put the little ruler next to it, it's closer to 4,200 square feet, all right? 18,000 square feet is less than 20,000 square feet because that was one more little nudge they had to make sure it stayed below the 20,000 foot threshold to be a minor. A minor requires no public comment, TRC approval. Right, so there's been problems from the start. Okay, emphasize 2010. I have emails from the county. Quote, I believe the plant that is referenced actually closed 2011 to 2012-ish timeframe. We discovered this after I sent my response, but I wasn't sure if another department had gotten anything at this time I sent my response. This is from Kim Commander to Jessica Sconiers. So this is, I don't know, 1,500 pages of public records that we reviewed, pulling out the little nuggets here and there. Walton County future land use goal. Goal number L-1, provide for a high quality of life by planning for population growth, development, redevelopment in a manner that maintains the unique character areas of Walton County and is consistent with the financially sustainable provision of infrastructure, the protection of residential neighborhoods and natural resources. Your Honor, this asphalt plant is going to be within 3,000 to 6,000 feet of thousands of homes, not 50, not 20, thousands. Most of these homes were built after 2010. More are coming. Kings Crossing, major development, 1,300 units, 250,000 square foot of retail, less than 6,000 feet away on Highway 20. 350 unit apartment, 3,000 feet from the plant entrance. Not accounted for. That's why the traffic study was important. That's why we're trying to get it into the record. We talked about conditional and major. We talked about that. The DPZ 2040 study, the county commission realized that their zoning was, and I quote, from their lead planner that did the study, haphazard and unusual. So they paid about $1 million for this DPZ 2040 study, which they just recently accepted at the county commission meeting. By the way, I was a county commissioner for 4 years. Trained, went to all the trainings, sat on that dais many, many times in making these decisions. So I know what goes into it. The DPZ 2040 study, rapid growth has exposed weaknesses in the county's existing zoning framework. Many citizens have expressed concerns about the pace of development, the types of projects being approved, and the overall quality of the built environment. While the comprehensive plan policies represent sound intentions, the land development code regulations often contradict those policies and fail to facilitate the type of development most citizens desire. And you see that with the conditional versus right by use. That's one of the conflicts that's easily seen. The site is surrounded by wetlands. Okay, I don't know what picture we have up here. Okay, wetlands and open water. So we're going to approve another industrial site on these waterways. It goes to the Alaqua Creek, which goes to Choctawhatchee Bay. Alaqua Creek, Choctawhatchee Bay, already impaired. So we're going to put stormwater ponds out there, and they're going to work maybe. You know, the design looks like it's reasonable. But you know what happened in Okaloosa County, up in the north end? The stormwater ponds were breached at the solar panel site. Major breach. Senator Don Gates is all up in arms about it. So they had stormwater plans. Somebody reviewed the plans. And then we had a big rain and the stormwater ponds got breached. There goes everything from that plant. So we're accepting a risk. We're putting this plant in here, accepting a risk, which doesn't support the use. There are 5 HMA plants within 50 miles, 5, including the Geneva plant that the applicant is talking about.
If you could just wrap it up for me.
Wrap it up. I hit that. The environmental assessment was a joke. I'll just lay that at you. I did a lot of environmental assessments as an engineer before I went to the Air Force. This one was a lick and a swipe. They didn't do a valid one. Our phase 1, phase 2 is required, but nobody's talking about it. And unfortunately, we didn't get to have all the reasons for the traffic that Dr. Buckholz would present. We're not going away, okay? Common sense says this project has issues. And all the checklist items can be checked. It doesn't mean they don't have issues. And like I said, if you have faulty information to make a decision, that's one of the major reasons that the FDOT issued the permit. Thank you, Your Honor.
Thank you. Next. Nobody else wants to speak on this project? Okay. Tell me your name.
My name is Samantha Herring, and thank you so much for this opportunity to speak. I am just a member of the public who happens to live literally right here, and I'm very concerned about a commercial project that has environmental, risks. We already have a lot of concerns as a result of 2 major dumps that are very close to where we are. And they've done everything they can to mitigate that. And the last thing in the world many of us want is more environmental concerns. And so this definitely brings those concerns. And knowing that there's already 5 other plants within 50 miles, those are all things that as citizens we see and think, why do we have to do this now? Because when we bought our homes here, this wasn't even something, mentioned. There were closed different commercial places that were closed down, but there was no speaking to the, interest of reinventing those commercial places. Had we known that, I can tell you a lot of folks would have made a different decision. So now that there's thousands of us here, I think it's realistic to consider that and consider our home values, consider what kind of community we're growing here in Freeport. There are different things that we really would like to see happen commercially that don't involve something like this with so much risk on the highways. Kids going to school, we've got all these, our schools are right here. And this 1-2-lane highway with these big trucks is a terrible idea. When you've got teenagers driving from high school to football practice, those are things you think about as a mom, So, it's not something our community wants, I can tell you that. And I just wanted to make my voice heard. I know my entire family and my neighbors are very worried about it, and we hope whatever has to happen within the county to move this further away from residential would be the ideal situation. So thank you for listening.
Thank you. Anyone else? Is that what my dad always said? Speak now, forever hold your peace. Okay. All right, then we'll close the public hearing portion. I do offer the parties, if they wanted to put on any other testimony, you're welcome to do that at this time. If not, we can close the quasi judicial. Okay. Absolutely. You may come up and do a closing.
And as this whole issue we're here on today is, do we meet the requirements of the Comprehensive Plan Land Development Code to qualify for a county development order? Which means it's restricted to what falls within the purview of the county. There has been no evidence to support that we don't meet all of the requirements. 0. everyone, the county and us, both testified that all the relevant provisions of the Comprehensive Plan and Land Development Code are met. The only thing that was provided by the public, and I wrote it down, they wanted to talk about when the asphalt plant operated, and honestly, what difference does it make? There's an asphalt plant there, and the old infrastructure's there, and it is zoned heavy industrial where asphalt plant is a use by right. State permits are state permits, as you correctly put. If you want to challenge the issuance of a state permit, you need to go to the state. We have met all of our requirements and we are entitled to a development order. The whole process on a private property owner's rights, which the people that own this property have those rights, is if the county gets to adopt a set of rules on what you have to do a development or build something on your property. But if you comply with those rules, the county doesn't get to say no. And we believe we have proved, and the county has agreed with it, that we have met all of their rules. Thank you.
Thank you. Ms. Davis, did you want to close?
Because I think, you know, we've talked in terms of conditional use by right, things like that. So because there's a little bit of a difference between the comprehensive plan and the land development code. So it's the land development code that we're talking about, this idea of use by right, that you're allowed in this zoning district to do this type of a use. So as far as the conditional use aspect and the comprehensive plan, the county's position is because this is a use that was already an established use for this particular property, and although it's been a break in time of operation, it's still a conditional use that's allowed within this property without going through further conditional use issues regarding this. So because there's been nothing different that's been done on the property since that time that there was that asphalt plant within the recent time period. So there's been nothing to interrupt that use. So at this point, we're going through this process of a major development order versus a minor development order, where typically some kind of a commercial use like this would be something that would be a minor development order that would not go through this process. But because of the type of use that we're talking about, then it's going through a more major review. But throughout that major review process for this particular project, the county has not identified conflicts in the land development code and the comprehensive plan that would be something that would cause the county concern to believe that this project does not comply with those minimum regulatory thresholds. Now, as far as environmental concerns and DOT concerns, for transportation purposes, we're preempted at this point with the permits that Your Honor has also seen on both of those regards. Those are things that the state has the ability to control. Those are not regulatory concerns that we can really address on this level as far as the comprehensive plan and the land development code.
Thank you. All right, well, the quasi-judicial hearing is closed then, and we'll adjourn. Thank you.
You staying for ZBA? Fun. It's not gonna be a short one.